ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅವರೇ, ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅವರು ಬಂದಿದ್ದಾರಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅವ್ರಿ,
ಸರ್ ಹೇಳಿ.
ನಾನು ಕೃಷ್ಣಮೂರ್ತಿ ಹಾಸ್ಯಗಾರ್ ಮಾತಾಡ್ತಾ ಇದ್ದೇನೆ.
ಹಾ ಸರ್.
ನಂದು ಲಿಸ್ಟ್ ನಂಬರ್ 2ದಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಇದೆ.
ಹಾ
ಒಂದು 10 ರೀಕ್ವೆಸ್ಟ್ ಮಾಡೋಣ, ಅಡ್ಜರ್ಮೆಂಟಿಗಲ್ಲ, 2:30 ಅಪಿಯರ್ ಆಗ್ಲಿಕ್ಕೆ ಪರ್ಮಿಷನ್ ಕೇಳಿ ಮಾಡ್ತಾ ಇದ್ದೇನೆ.
ಮಾಡಿ ಸರ್.
ಅದು ಲಿಸ್ಟ್ ಪ್ರಕಾರ ಕರೀತೀರಲ್ವಾ ನೀವು?
ಹೌದು ಹೌದು.
ಓಕೆ, ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಕರೆದಾಗ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೇನೆ, 2:30 ಬರ್ತೇನೆ ಅಂತೇಳಿ. ಸ್ವಲ್ಪ ರಿಚುವಲ್ಸ್ ಮುಗಿಸ್ಕೊಂಡು ಬರ್ತೇನೆ ಮಧ್ಯಾಹ್ನ ಮೇಲೆ.
ಓಕೆ.
ಹೇಗಿದ್ರು ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಮುಗಿದ್ಮೇಲೆ ಇದನ್ನ ತಗೊಳ್ಳೋದಲ್ವಾ?
ಆತರ ಏನಿಲ್ಲ ಸರ್, ಸ್ಟೇಜ್ ಬೈ ಸ್ಟೇಜ್.
ಹಾ ಅಲ್ಲ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ತಗೊಳ್ಳೋದು ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಡ್ಮಿಷನ್ ಆದ್ಮೇಲೆ ತಗೊಳ್ತೀರಿ ಅಂತ ಕಾಣಿಸ್ತದೆ.
ಹೌದು ಹೌದು.
ಓಕೆ, ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೇನೆ, 2ವರೆಗೆ ಬರ್ತೇನೆ ನಾನು.
ಸರಿ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್.
ಓಕೆ. ಬೇಡ ಬೇಡ ಅವ್ರ ಅವ್ರು ತಂದು ಕೊಟ್ಮೇಲೆ ಸೇರ್ಸಿದ್ಮೇಲೆ ಅದು ತಂದು ಕೊಟ್ಟು ಸೇರ್ಸಿದ್ಮೇಲೆ ಅದು TCR ಬಂದಿಲ್ಲ, ಇನ್ನು ಅಡ್ಮಿಷನ್ ಆಗಿಲ್ಲ ಅನ್ಸುತ್ತೆ. ಕೊಟ್ಟಿರೋದಕ್ಕೆ ಗಲಾಟೆ ಬೇರೆ ಮೋಸ್ಟ್ಲಿ ಗ್ರೀನ್ ಟೀ ಏನಾದ್ರು ಕುಡಿತಾರೆ.
My lord's permission. Lord, one matter at 2:30. This matter is listed yesterday, my lord. This is a ex parte decree that has been obtained yesterday. ಇದರಲ್ಲಿ
ಬರ್ಲಿಲ್ಲ ಅದು ಕೊಟ್ಟಿಲ್ಲ ನಾವೇನೇ ಎಂಟ್ರಿ ಮಾಡ್ರು
ಅದೇ ಅದರಲ್ಲಿ ಕೋರ್ಟ್ ಕಮಿಷನರ್ ವೆದರ್ ಕೋರ್ಟ್ ಕಮಿಷನರ್ has been appointed, my lord.
We have heard you sufficiently and passed.
My lord has said whether the court commissioner has been appointed in FDP. We said no.
Adjournments.
Lord, at least to liberty to move vacation bench.
You move before the vacation bench only. Why should we give you permission? You can move it before.
The court commissioner has been appointed in FDP.
So dilla.
Adjournments, page wise. List 1, page 1, cell number 1 and 2. Page 2, cell number 3 to 5. Page 3, cell number 6 to 9. Page 4, cell number 10 to 13. Page 5, cell number 14 to 16. Page 6, cell number 17 to 20. Page 7, cell number 21 to 25. Page 8.
Serial number 25, Mulaz, I appear for the appellant.
Hmm.
Mulaz, Mr. Shastri has some inconvenience, my lords. He had called me last evening.
ಅವರೇ move ಮಾಡಿದಾರ.
ಅಲ್ಲ, ಅವರೇ ಮಾಡಿದ್ರು. He has some inconvenience, my lords. He is traveling towards
He's not-
his native.
ಬಂದಾಗ adjourn ಮಾಡೋಣ, ಅವ್ರು ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ.
Sorry.
Whenever it reaches now, we'll adjourn.
Page 8, cell number 26 to 32. Page 9, cell number 33 to 37. Page 10, cell number 38 to 44. Page 11, cell number 45 to 53. Page 12, cell number 54 to 58. Page 13, cell number 59 to 63. Page 14, cell number 64 to 67. Page 15, cell number 68 and 69.
My lord, I appear for the appellant in the serial number 68, my lord. Senior is out of the country, my lord. I've informed the other side as well. I request for time, my lord.
Whom do you represent here?
My lord, the appellant, my lord.
Adjourn at the request of the appellant's counsel. Yes.
List number 2, page 1,
What's
cell number 1 and 2. Page 2, cell number 3 to 8.
In serial number 6, my lord, I appear for the appellant. I am not seeking for adjournment. I am only requesting indulgence the honorable court to appear at 2:30, my lord.
2:30. Yes.
2:30 I would appear and argue the matter.
List number 1, for orders, cell number 1. Ashok N. Patil, Nityanand V. Naik, D. Vijay Kumar.
Furnishing PF and correct address.
My lord, I am appearing for the respondent now. I filed an application seeking
1 week's
permission
time
to
will
withdraw
grant
the
it, sir.
amount.
Take steps.
deposited.
Withdrawal of the amount. Who has filed this? Withdrawal of amount IA 1 of 2024.
Parents of the deceased, my lord.
You appear for them.
Please, my lord.
Yes, what do you say for that?
My lords, I have filed, my lords, questioning the negligence. Now, my lords, the court has held the, my lords, it is 50-50 on 2 vehicles, BMTC bus as well as, my lords, the insured car. But we have questioned that because, my lord, the car has hit the two-wheeler.
Oh, he was the inmate of.
No, my lords, he was riding the
Two-wheeler.
motorcycle. The deceased was riding the motorcycle. But there is no impact with the car. The BMTC bus has, my lords, dashed to
The insurer of
the car, my lords. Now, my lords, both the charge sheet is filed against, my lord, BMTC and as well as the car driver. 50-50 is, my lord, saddled now. That is in,
Totally.
yes, my lords, because there is no contact, my lords, or my lords, dashing of the car to the motorcycle. It is the BMTC, my lords, which has dashed to the motorcycle and the,
Tata Indica car, so and so changed the lane suddenly.
Yes.
Immediately. And driver of bus number so and so was behind. This did not apply brake or stop his vehicle. As a result, the bus dashed the bike. So according to them, bus hit him because of this car owner,
Yes.
car driver.
Change the lane.
in the lane. That is how, my lord, the,
Whether you have examined him.
my lords, we have examined our official.
No, car driver.
Car driver, my lords, we have not examined.
How old are they?
Parents are 52 years, my lords.
82,000 ಅಷ್ಟೇ award.
11,82,000.
How old was the victim?
He was in the seventh semester engineering, my lord, after completion of diploma, my lord.
23 years.
25% ಆದ್ರೆ ತಗೊಳ್ಳಿ. ನೀವು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ 50% ಆದ್ರೆ ತಗೊಳ್ಳಿ ಬಿಡಿ. You are
Yes,
not
because-
examined the driver of the car.
Not
Please,
the
my lord,
charge sheet and the
80%
other document,
halt.
The sheet was against both of them.
both the way.
Right?
Yes.
So to say that it was the bus driver who was solely responsible, you have not examined the car driver.
No, my lords, we have not.
You have not examined any eyewitness also.
But the statement of the, my lords, the cross-examination, my lords, would read like this, my lords. May I read, my lords?
Even the BMTC or KSRTC, they have also preferred appeal.
No, man, they have not preferred.
preferred that.
They have not.
Then that.
That 50% he has taken, my lords.
Not
That
take.
50% he has taken.
It is not.
Look at their age.
But may I request this, my lord? Your lordship kindly, my lords, release 20% because they are also in appeal, likely to be enhanced, my lords, in their appeal, so that, my lord, that could set off 20%.
25% ಅಂತ ಹೇಳಿದೀವಿ ನಾವು. ಈಗ 50%
50.
ಅಂದ್ರೆ
Please, my lords, 25% is your lordship.
I mean, out of the deposit, 50%.
Yes, ma'am.
Please.
We'll give the reasons for that.
Yes, ma'am.
Orders and 1 of 2024. Counsel for the, under the above application, the Respond number 1 and 2, claimants slash claimants are seeking release of the amount in deposit. Appellant's counsel opposes the application that the driver of the insured car was not negligent and the accident occurred solely due to the negligence of driver of the BMTC bus. Admittedly, charge sheet was filed against the drivers of the bus and the car both. The appellant insurer has not examined either the driver of the car or any eyewitness to prove that, to rebut the presumption under the charge sheet regarding negligence. The claimants are
Parents.
Parents
claimants are the aged parents of
and suffering from severe cardiac problem, my lord. 80% blockage is there. I have to undergo treatment.
deceased. Under the circumstances, it would be just and proper to release 50% of the amount in deposit to them, subject to the result of result.
Much of
I am for respondent number 3, my lord.
Registry is hereby directed to release. Here, it is here or before the tribunal?
before this honorable court, my lord. The
Before High
appellant
Court
has
only.
deposited on 25/11/2019 in compliance with the order 12/6/2018.
Respond number 1 and 2 digitally and furnishing the required documents. I have 1,024 is disposed of accordingly. At request, 2 weeks time is granted to do the needful in respect of respond number 5. ನಿಮ್ಮದ್ರಲ್ಲಿ ಇನ್ನು notice awaited ಅಲ್ಲ
Yes.
ಅಲ್ಲ ಫಸ್ಟ್ ಟೈಮ್
I shall take.
ಇನ್ನೊಂದ್ರಲ್ಲೂ connected 1.1 ನಲ್ಲಿ at request 2 weeks time is granted to do the needful in respect of response 2 to 4. Yes.
Seal number 2, Anil
Much-
Kumar MS.
much obliged.
Much obliged.
Vishwanath R. Hegde.
2618.
Lord, Ian Raghupati was appearing on the earlier occasion, my lord. He had filed the appeal for appellant. And on account of his demise, my lord, the court notice was ordered. Now court notice has been is there, his colleague, it appears, my lord. But
You are instructed to appear.
yes, I instructed to appear. I will file wakalat, my lord. If your lordship permits, because Anil Kumar is there.
File it in the registry.
Yes,
Permit.
your lordship may permit me because Anil Kumar is there, my lord.
R. Gopal.
Since Mr. Anil Kumar did not appear on several occasions.
Not coming.
Please.
Probably his colleagues, they may not come.
was
Yes,
the
yes, that may be true.
Reason for issuing court notice, my lord, was that he did not appear.
I'll think
Your
about
lordship
the
is very
lesson
good.
Since Sri Anil Kumar MS
So
is
and
a
so
colleague of
ಹೇಳಿದ್ರಲ್ಲ, ಎಣಿಸ್ಕೊಳಕ್ಕೇನಲ್ಲ ನೀವೇನು?
Shri K.N. Raghupati, who unfortunately passed away, right, did not
R.
appear.
Gopal.
Court notice was issued to the appellants. Shri Sohan from Learned Counsel
So and so
undertakes to
said that
appear
the
for
appeal
the
or
appellant, sole appellant.
Sole appellant, my
He
lord.
permitted to file the wakalat in the registry. Nim full name ಬರುತ್ತದೆ.
Lord, with regard to steps, my lord, I will take, my lord.
Permitted to file the wakalat in the registry within ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಹಾಕ್ತೀರಾ?
Today itself, I will file it. Yes.
Then, his name shall be shown in the call list accordingly. At request, 2 weeks time is granted to do the needful in respect of no court notice issued to appellant ಅದು ಬಂದಿದೆ.
ಅದು
Served ಅಂತ ಬಂದಿದೆ.
ಬಂದಿದೆ. On filing of application for appointment of.
My lord,
court
that is, I think, my lord, mother is there, my lord, already.
She has not appeared, it seems.
But my lord, she was, these 2 minors were represented by mother in the trial court, my lord.
Correct.
As such, my lord,
That does not turn up, then we have to appoint a court guardian.
mother served.
Sir, but if she doesn't turn up to
Yes, yes.
protect the interest of the minors,
Yes.
16 and 17 ಅಲ್ಲ?
ಹೌದೌದು.
ನಾವು ನೋಡಿ
ಅವರೆಲ್ಲ
last time-
ಎಕ್ಸ್ಪರ್ಟ್ ಅಂತ ಆಗಿದ್ದಾರೆ ಅಲ್ಲಿ.
See, it is the responsibility of the court when there's.
Yes, yes, my lord. I will do it, my lord. I will file application for appointment of court.
Respect of unserved respondents and for appointment of guardian for court guardian for respondent number 16 and 17. Yes.
Seal number 3, A.G. Sadashivaya, A. Subramanya Prasad, for R2.
6 and 7, my lord. It has been
7.
returned as unserved.
Sir, as per the postal endorsement, response 6 and 7 have not claimed the notice. Trial court will contest ಮಾಡಿದ್ರಾ?
Please, my lord, they contested the matter.
Service on them sufficient. In-alia R1, 3, 4 and 5. 30 plus 2 weeks time is granted for the needful in respect of response 1, 3, 1 and 3 to 5.
1, 3, 4 and 5.
3 to 5, yes.
Please.
Seal number 4, Akshaya BM,
Fourth time.
V Lakshmaya for R1.
Sixth respondent is not served, fourth time.
Please, my lords, the address is in US. We've tried to
First
serve them for 4
Time
times.
notice to proposed R1, A1. Appellant number.
The appellant number 1 demised and their LRs.
You were appearing for appellants also, no?
For the appellants, my lord. Appellant number 1 and 2, husband and wife. Appellant 1 demised. And his-
His heirs have not come forward to entrust the matter to him.
Please, my lords, I will represent them. I filed an application to bring the LRs on record.
IA 1 of 2024. ಅಲ್ಲಿದೆ ಬೇರೆ ಕಡೆ 1 to 3 of 24. These applications are still pending or
Please, ma'am.
what is that amendment I have to do in the?
Amendment is as regards a certain
Number 2, application is filed by appellant number 2, that's what we are asking.
Please.
Whether LRs are not coming forward.
I'll file wakalat on their behalf, my lords. I just want.
Yeah, we should have filed application on there. By them.
Appellant 2 is already on record, so we filed it on her behalf.
Appellant number 2 is there. Now appellant number 1 is dead. Appellant number 2 has filed application.
Please.
Notice is ordered. Why this exercise? If they are coming forward, application could have been filed by them only.
I'll file wakalat on their behalf.
Now person for the appellant submits seeks time to appear for proposed appellant number 1A and 1B. ಹಾಗಿದ್ರೆ ಆ ನೋಟಿಸ್ ಒಂದು ಪ್ರೊಸೆಸ್ ತಪ್ಪುತ್ತೆ.
Notice has already been issued regardless, ma'am.
Waiting for this.
ಸರ್ವ್ ಆಗಿಲ್ಲ ಅವ್ರಿಗೆ.
Please. None of the notices have
That it
been
was,
sent.
Fourth time ಈಗ respondable to 6
6 months.
instead of putting. Finally,
We've tried to serve them multiple times, my lords.
ಅವ್ರದ್ದು awaited ಅಂತಾನೆ ಇದೆಯಾ?
ಎಲ್ಲಾರ್ದು
List, sixth also, list on. Otherwise, we could have allowed these applications. ಅವರೇ ಹಾಕ್ಬೇಕು this.
411.
Much appreciated.
Seal number 5, Anand Ram K, Ravi Shankar Shastri Ji. For the appellants, my lord, kindly pass over.
Why you have to make some amendment? Appeal, first title of the appeal memo and Vakal. Why pass over?
My lord, senior is held up in court hall number 12.
You have to comply certain things here.
My lord, there's an explanation to be given. Senior will be coming, my lord.
Counsel for the appellant submits that GPA holder died but has not rectified the cost title. GPA holder ತೀರೋಗಿದಾರ? ಆಯ್ತು.
We pass over, my lord.
Passed over.
Much obliged, ma'am.
Seal number 6,
Please, my lords,
D
in this-
Sharat Kumar.
please, my lords, in this case, I appear for the appellant. What has happened is, take steps with regard to,
Setting aside abatement R1.
really, it was there is a,
R2, 3 to 5 and A notice also has to go. Then why have you moved it?
please, my lords, what has happened is, my the typographical error for the R2 and R1, it has been interchanged. Now, notice has to go to R1 and R3 to 5. please. Shakuntalama is dead and the LRs are already on record, notice serve ಆಗಿದೆ.
Shakuntalamma is not alive.
Please, miss.
R1 is Shakuntalamma. What is that interchanging?
ಅದು R2 ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇದಾಗಿದೆ. There is a mistake. Jagadamba is alive. I should
Ratnam.
take, I will take steps to Jagadamba and R3 to 5. please. and also be permitted to serve a notice on the counsel who is appearing in the lower court. FDP Act, there is an ex parte decree.
Error, couldn't get that.
Now steps
Are person record ಮೇಲೆ ತರೋದಕ್ಕೆ application ಹಾಕಿದ್ದೀರಾ?
ಶಾಕುಂತಲಮ್ಮ ಅಂತ ಹೇಳೋರು ತೀರೋಗಿದ್ದಾರೆ. R2.
Just. Changing the LRs.
ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆ ಅವರಿಗೆ. ನೋಟಿಸ್ ಹೋಗಿ ಎಲ್ಲಾರು ಸರ್ವ್ have ಸರ್ವ್.
Please to bring on record proposed respondent number 1A2 see as legal representative of deceased respondent number 1 Shakuntalamma.
ಶಕುಂತಲಮ್ಮ
ಈಗ ಅವರು ಇದಾರ ಇಲ್ವಾ?
ಇಲ್ಲ ಅವ್ರು ತೀರೋಗಿದ್ದಾರೆ. ಅವ್ರಿಗೆ ಎಲ್ಲಾರು ನೋಟಿಸ್ ಹೋಗಿದೆ.
ಹ್ಮ್.
ಈಗ ಜಗದಾಂಬ ಅಂತ ಹೇಳಿ ಸಾರಿ ರತ್ನಾಂಬ ಅಂತ ಹೇಳೋರಿಗೆ ಮತ್ತೆ 3 to 5 ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು.
ನೋಟಿಸ್ ಹೋಗಿರ್ಲಿಲ್ವಾ?
ಹೋಗಿದೆ, ಅದು ಸೆಕೆಂಡ್ ಟೈಮ್ ಬಂದಿದೆ. ಸರ್ವ್ ಆಗಿಲ್ಲ. ಸೊ ಐ ಮೇ ಪರ್ಮಿಟ್ ಟು ಸರ್ವ್ ನೋಟಿಸ್. ಐ ವಿಲ್ ಟೇಕ್ ಸ್ಟೆಪ್ಸ್ ಟು ಡೇಟ್ ಸರ್. ಐ ಆಲ್ಸೋ ಪರ್ಮಿಟ್ ಟು ಸರ್ವ್ ದ ನೋಟಿಸ್ ಆನ್.
ಈಗ ಎಲ್ಲಾರ್ಸಿ ಸರ್ವಿಸ್ ಆಗಿದೆ.
ಎಲ್ಲ ಸರ್ವಿಸ್ ಆಗಿದೆ.
BC ಗೆ ಮಾತ್ರ ಸರ್ವ್ ಆಗಿದೆ.
2 to 3 ಅಂಡ್ ರತ್ನಾಂಬಾಗ್ ಮಾಡೋದು.
ಅದ್ರಲ್ಲಿ ಎಲ್ಲಾರ್ಸಿ ಇರೋದು 3 ಜನ ಇದ್ದಾರೆ.
3 ಜನ ಇದೆ. ಹೌದು.
ಹೇಗ್ ಸರ್ವ್ ಆಗಿಲ್ವಾ?
ಎಲ್ಲರಿಗೂ ಆಗಿದೆ. ಎಲ್ಲಾರ್ಸಿಗೆ ಸರ್ವ್ ಆಗಿದೆ.
ABC.
ಅದರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಆಗಿಲ್ಲ.
At least those applications can be disposed of.
ಅದಾಗುತ್ತೆ ಬಟ್ ನೋಟಿಸ್
2, 3, 5 and 3 to 5 ಸರ್ವ್ ಆಗಿಲ್ಲ.
ಆಗ್ಬೇಕು.
Orders are 9 number 1 to 3 of 2022. ಯಾವಾಗ ತೀರೋಗಿದ್ದಾರೆ? 30th March 2019.
14/12/21 ಅಲ್ಲಿ.
She died
14/12/21.
14/20. ಇಲ್ಲಿ ಕೋರ್ಟಲ್ಲಿ ನೋಟಿಸ್ ಬಂದಾಗ ಗೊತ್ತಾಗಿದೆ.
ನೋಟಿಸ್ ಇದು ನೋಟಿಸ್ ಹೋಯ್ತು ಅವ್ರಿಗೆ, ಬೇರೆಯವ್ರಿಗೆ ಹೋಗಿಲ್ಲ. ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಎಕ್ಸ್ಪರ್ಟ್ ಆಗಿದೆ ನಮ್ಮ ಮೇಲೆ. FDP ಹಾಕಿದ್ಮೇಲೆ ವಿ ಕೇಮ್ ಟು
reported died on 14/12/2021. The above application is filed to bring her LRs on record. The proposed LRs, those who are appointed to considering the reasons assigned. To explain delay. Delay of how many days? Forty-nine days, 49 days in filing IA number 3 of 2022 is hereby condemned. Abatement of the appeal against respondent 1 is hereby set aside. And the appellants are permitted to bring on record proposed respondent number 1A to C as the legal representatives of deceased respondent number 1 on record in the interest of justice. IA number 1 to 3 of 2001 and 2 to 4 of 2024, 22 are disposed of accordingly. Appellant's counsel shall amend the cause title of the appeal memo and furnish the copy of the copies of the amended appeal memo. At request, 2 weeks time is granted to do the needful in respect of response 2 and 3 to 5.
Permit to serve a notice on the council, the court below.
Why you want to serve on the council? You take
They are not interested. Only the plaintiff who has been served, who has been expired.
that
I
process.
will take steps through court also and also permitted to serve the council.
ಯಾಕೆ why it is not served? ಏನಂತ ಬಂದಿದೆ?
The address ಸರಿ ಇಲ್ಲ ಅಂತ not
Then
seen.
how can we permit you? Correct address.
There is urgency bill not say FDP ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅವರು ಅದಕ್ಕೆ.
ಆಯ್ತು ಸಬ್ ಸರ್ವಿಸ್ ತಗೊಳ್ಳಿ ಹಾಗಿದ್ರೆ. FDP ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. They are the plaintiffs before the trial court. R2 and
The plaintiff expired and the LRs are they have filed now.
who are
the
these R2 and
Respond defendants please.
co-defendants.
Co-defendants please.
Our FDP
ಅಲ್ಲಿ ಪಾರ್ಟಿ ಇದ್ದಾರೆ ಅವರು ಅದಕ್ಕೆ may permit.
have appeared there.
ಅಲ್ಲಿ they have appeared. Then my advocate is there.
Then you
I will take steps here also and also.
correct process ಕೊಡಿ we direct
Please.
service to that court. ಯಾವ court ಅದು? ಚಾಮರಾಜನಗರನ? ಸೀನಿಯರ್ ಸಿವಿಲ್. It request 2 weeks time is granted to the needful. If needful is done, issue notice to respondents 2 and 3 to 5 for service to the process branch of Senior Civil Judge Chamarajnagar.
Please.
List on
511.
file.
Seal number 7 is Kalyan Baswaraj, Ganesh R.
For the appellant, my lords.
Something paid cost of this respondent.
My lords, I'm for the appellant. I'm paying the cost,
Respondent ಕೊಡ್ಬೇಕು ಅಂತ ಆರ್ಡರ್ ಆಗಿತ್ತಲ್ಲ ತಗೊಳ್ತೀರಾ ಇಲ್ಲೇ ಕೊಡ್ಬೇಕಾ ಅದನ್ನ ಕೋರ್ಟ್ ಎದುರಿಗೇನೆ ಅಷ್ಟು ಒಂದ್ ದಿವಸದ ಇಂಟ್ರೆಸ್ಟ್ ಉಳಿಯುತ್ತೆ ಅಂತನಾ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸಬ್ಮಿಟ್ ದಟ್ ಹ್ಯಾಸ್ ರಿಸೀವ್ಡ್ ದ ಕಾಸ್ಟ್ ಏನಾಗ್ಬೇಕಿದ್ರಲ್ಲಿ ಮುಂದೆ
paper book,
ನಾನ್ ಫೈನಲ್ ಅಷ್ಟೇನಾ
final year. Yes, yes, my lords.
ಲಿಸ್ಟ್ ಫಾರ್ ಫೈನಲ್ ಇಯರಿಂಗ್ ಆಫ್ಟರ್ 2 weeks.
Publish.
Seal number 8, Vinod Prasad, SB Halli.
ಅಯ್ಯೋ that is
Suit was
serious.
decreed. I preferred an appeal.
Sir, what is
Subject
that
to
office
some
objection?
payment of stay was granted. I could not
There
pay.
is delay in filing the appeal.
Now matter is settled in the court below. We have paid every amount. And I want half court fee refund. But details of the things I could not. There is a delay office has raised objection. I will look into it. It will court after vacation and mail if necessary. I will do it.
Court fee ಕೊಟ್ಟಿಲ್ಲ ಅಂತ
Refund of the court fee because suit was decreed. I preferred appeal.
ಮ್ಯಾಟರ್ ಸೆಟಲ್ಡ್ ಇನ್ ಲೋಕದಲ್ಲ ಇಲ್ಲಿ ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ
ಇಲ್ಲಿ ನಾನು appeal of the court fee ಕಟ್ಟಿದ್ದೆ.
ರಿಫಂಡ್ ಹಾಫ್ ಕೋರ್ಟ್ ಫೀ ಥ್ರೂ ಆನ್ಲೈನ್ as the matter is settled before the ಲೋಕದಲ್ಲಿ. What is this application your IA 2024?
Refund of half court.
Correct. ಯಾಕೆ ಎಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದೆ?
ನಾನು ಅದನ್ನ ನೋಡ್ಲಿಲ್ಲ.
Where it is, you have filed an application for refund of court fee.
Yes.
ನೀವು ಹಾಕಿದಿರಾ ಇಲ್ವೋ?
ಅಲ್ಲ ಅದನ್ನ ನಾನು ನೋಡ್ಕೊಂಡು ಹೇಳ್ತೀನಿ. My colleagues matter I look into it.
Then why they have moved it?
Let me put after vacation.
Move ಮಾಡಿದ್ದಲ್ಲ? 08.
Number 8.
06. Though the appellant's counsel himself has moved the matter, he is seeking adjournment. Next after 2 weeks, irrespective of any mentioning or memo being moved, matter being moved. Yes.
Seal number 9, KV Satish Chandra.
ಒಂದು artificial urgency create ಮಾಡೋದ? ಒಂದು artificial urgency create ಮಾಡೋದ? They have moved the matter.
ಅಲ್ಲ,
You are
ಇದೆಲ್ಲ-
not prepared.
ಇಲ್ಲ, this is not the matter which I filed. 65 is urgency. That is posted.
ಇದ್ರಲ್ಲೇ ಮೂವ್ ಮಾಡಿದ್ದಾರೆ ನೀವು ಅಪಿಯರ್ ಆಗಿರೋದ್ರಲ್ಲೇ.
ಅಲ್ಲ ಅದರೊಳಗೆ ಆಫೀಸ್ objection raise ಮಾಡಿದಂದ್ರೆ I asked him. Then he say I don't know. Then I have to now first to take it back.
ಇವರೇ advocate.
Seal number 9, KV
In this
Satish
case,
Chandra.
Your Lordship, I cooperate the service of the summons to the respondent, Your Honor. And all the PF copies is go to trial court. I cooperated the process server and the respondent is refused that in my information, refused, but the intimation is not given to the court, Your Honor.
Residing with his sister at the address shown. Notice through family court ಶಿವಮೊಗ್ಗ. ಮತ್ತೆ ಅವ್ರು ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಅವ್ರು
ಇಲ್ಲಿ
ಕೊಟ್ಟಿಲ್ಲ.
non furnishing of peer.
Although we are for furnishing in the trial court, no, my,
Punished it in the trial court.
no, I furnish here itself.
ಮತ್ತೆ ರಿಪೋರ್ಟ್ ಏನು ಬಂದಿಲ್ವಲ್ಲ ನಮ್ಗೆ?
ಇಲ್ಲ ನಾವು ಇನ್ನೇನೋ ಹೋಗಿದ್ರಂತೆ ಮತ್ತೆ ಕರ್ಕೊಂಡು ಅವನೇನೋ ರೆಫ್ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರು.
ಇಲ್ಲಿಂದ ಇಶ್ಯೂ ಆಗಿಲ್ದೆ ಅವ್ರು ಹೇಗ್ ತಗೊಂಡ್ ಕರ್ಕೊಂಡು ಹೋಗ್ತಾರೆ? Unless we issue, how do they serve it?
ಹಳೇದ್ ನಾವು ಪ್ರೋಸೆಸ್ ಕೊಟ್ಟಿರ್ತೀವಲ್ಲ ಅದ್ರ ಮೇಲೆ ಕಳ್ಸಿರ್ಬೋದು, ಕೋರ್ಟಿಗೆ ತಾನೇ ಕಳ್ಸಿರ್ತೀವಿ.
Clerk counsel for the appellant submits that he had furnished the PF and notice already issued.
Earlier process was served,
Registry shall verify and list.
any date may be given around.
1610.
Much of it.
Seal number 10, T Govind Raj, Shekarappa HC.
For appellant Millard, suit for partition was decreed in favor of the respondents 1 and 2, 1 for share.
You have to take process to them.
We will pay the process so far as second respond is concerned. But unfortunately, they have filed a FDP case for taking the final decree proceedings.
Finding no case. the
That
matter-
has to be, the original decree has to be
See,
paid, my lord, for the reason that the party, the suit properties were already divided during
correct,
2003.
now, once notice was ordered without granting any interim stay, that goes to show that you did.
Like
court did not find such a case.
interior matter stay or at
But
least
ಇಲ್ಲಿ ಮೊದಲೀಗ
ಇಲ್ಲ interior matter ಕೊಟ್ಟಿಲ್ಲ.
process ಕೊಡಿ.
ಕೊಡ್ತೀವಿ, we will pay it today itself.
Now, counsel for the appellant insists for.
Interior matter of status may kindly be ordered. Otherwise, those we have grown up with coconut and coconut trees
Hearing the.
and they have come up for harvest.
Has issued the notice. And I have 1 of 2023, there is delay also.
60 days delay ಇದೆ. ಅವರು the
60 days.
mother of the
Then there is Therefore,
appellant
registration
was suffering serious disease.
without service of the notice. At request, 2 weeks time is granted to do the need. Yes.
Seal number 11, Vikram Padke, Narayan Swami K.
For respondent.
It is order dated 29. No representation for, no, no. Why it should be recalled? No representation.
Subsequently, the NOC Vakalate has filed. And on last occasion, no order has been passed.
No order. Please to recall the order dated adjourning the matter to be list. Oh, in the error. On the early hearing, it's all these applications do not survive.
Yes.
No representation for the appellant. The above applications advancement. Trial court advancement. Applications are filed seeking advancement of the case and the order dated and recalling the order dated 20/9/2024, adjourning the matter. Though the matter is listed today, none appears for the appellant. As no specific order was passed on 29. Very wicked. Anyhow, as the matter is listed, IA 1 and 2 of 2024 do not survive for further consideration and disposed of accordingly. Non-filing, our paper books are list after 2 weeks.
Seal number 12, BR Vishwanath, Satisha KM.
I pray for 2 weeks' time to comply, my lords.
You all move the matters, keeping some office objections soon. Look at the previous case. Application hakoltare court munde baradilla.
My apologies, my lords.
Other side copy to be served. Who is for Satisha? They are not there. Non-filing of the paper book, furnishing of PF.
Paper book ready after the 2 weeks.
You have to use the
Right.
PF also, no? What is IA 1 of 2024? There are some office copy to be served. For TI. The matter is moved without doing the needful. At request 2 weeks time is granted for the matter.
Great.
Seal number 13, Satisha T, D Vijay Kumar for R2.
For the appellant in the connected matter.
Second can set appeal. You are in the connected matter.
Connected.
IA 1 of 2024 not present.
Withdrawal already permission ಇದೆ ಮತ್ತೆ ಐ ಹಾಕಿದ್ದು.
No representation for the appellant. Finally, 2 weeks time is granted to file the second set, filing which appeal shall stand dismissed. Connected 13.19 as ಅದರ ಮೇಲೆ ಬರೆದಿದ್ದಾರ ನಾಟ್ ಪ್ರೆಸ್ಟ್ ಅಂತ.
ನಾಟ್ ಪ್ರೆಸೆಂಟ್. ಆಲ್ರೆಡಿ ವಿಡ್ರಾಲ್ 8/11/2022 ನಲ್ಲಿ ಆಗಿದೆ.
ರಿಪ್ಲಿಕೇಶನ್
ಸ್ಟೇ ಕೊಡುವಾಗ ಏನೋ ಕ್ವಾಂಟಮ್ ಅಂತ ಹೇಳಿ ವಿಡ್ರಾಲ್ ಪರ್ಮಿಷನ್ ಇತ್ತು, ಮತ್ತೆ ಪುನಃ ಐ ಹಾಕೊಂಡಿದ್ದಾರೆ, ಐ ನಾಟ್ ಪ್ರೆಸ್ ಮಾಡಿ.
The appellant's counsel has made an endorsement on IA number 1 of 2024 that the same is not pressed, recording the same. Appellant ಅಲ್ಲ, respondent.
ಹೌದು, ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್.
Respondent's counsel. Madam, respondent. Yes. Noting the same, application is dismissed as not pressed. Admit ಆಗಿತ್ತಾ?
ಇಲ್ಲ ಸರ್.
ಇಲ್ಲ madam.
List after 2 weeks.
Seal number 14, Rakshita DJ, Viresh R. Gurihal.
Beg to appeal for the respondent number 1, please, my lord. Appellant counsel, the point for, in fact, this is covered by your lordship's order. May I request, my lord, page 143 may be kindly be changed. This is under the special. No,
Memo for dispensation.
oh, yes, exactly. My memo is for, in fact, your lordship kindly, may I request, my lord, the memo dated,
Who are R 2 to 6, 11, 14, 15.
the memo for dispensation. Now my relief is only against the first respondent. That is in fact.
Okay, we can dispense with the notice to them.
This, for so far.
Yes, at the
others
risk- Lord, at the risk of appellants, my lord, I have no objection, please, my lord.
As the appellant has not sought any relief against his 6, 11, 14 and 15. Well, 7 and 7 to 9. 1 to 9, then number correct of 7 to 9, 18, 20 and 25. ಉಳಿದವ್ರಿಗೂ dispensation ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
For others are not the only grievance is against.
We have not sought dispensation for them. We have sought dispensation only for respondents 7 to 9,
7 to 9.
18, 20 and 25.
Yes, exactly.
Correct. 6, 11, 14 and 15 ಅವ್ರಿಗೂ ಸರ್ವಿಸ್ ಆಗಿಲ್ವಲ್ಲ ಇನ್ನು?
They are all appeared and served, all of them.
ಇಲ್ಲ ಸರ್, appear
You will ask me kindly. Now the
11.
relief is only against the first respondent.
ಅವ್ರು ಬೇಡ ಅಂದ್ರೆ ನೀವು ಅವ್ರಿಗೂ dispensation ಕೇಳಬೇಕು.
I do agree. In fact, my lord, in fact, your lordship may kindly, in an earlier occasion, your lordship's order, your lordship has been, all the others have been, only there have been, other response has been deleted.
ಇದ್ರಲ್ಲಿ
Sure.
ಮಾಡಿಲ್ಲಲ್ರಿ. In this you have not deleted their names. You have not deleted their names.
And I am
They are not
filing a
sought
memo,
dispensation.
so far I am filing a memo, so far the other responses, they are not,
ಮಾಡ್ತೀರಾ? You are
they are
going to
not the contesting respondent. Your lordship may kindly appreciate.
do it once in one stroke. ಎಲ್ಲದ್ರಲ್ಲೂ ಅಲ್ಲೇ ಹಾಕ್ಕೋಬೇಕಿತ್ತು.
ಹೌದು. ಹಾಕ್ಬಿಡೋಣ.
ಇಲ್ಲಿ 2 ಸರಿ ಬರಿಬೇಕು ನಾವು. Respondent. ಅಲ್ಲ, ಅದಕ್ಕಿಂತ ಮೊದಲು ಬರ್ಕೊಳ್ಳಿ. Counsel for the appellant, you are going to file it today.
Yes.
Counsel for the appellant files memo seeking dispensation of notice to respondents 2 to 6. 11 to 6. 2 ಹೆಂಗ್ ಕೇಳ್ತೀರಾ? Group form.
Yes. So far the first respondent is the contesting respondent.
11, 15 and 15. As the appellant is not seeking any relief against respondents 2 to 7,
Petition is
9, 11, 14, 15, 18, 20 and 25. Notice to them is dispensed with as paid for. Yes, ಆಯ್ತು, ಒಂದಾಯ್ತು ಈಗ.
no.
Next is non-filing of response to IA 5 of 2023. They had to file it.
Please, my lord, I'll file it, my lords.
You have filed it or
ಇಲ್ಲ, ನಾನು ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. By next date of hearing, I'll do it, please, my lord.
office objection ಏನದು?
Lakshmi,
Certified copy of the sale deed dated 25 filed by advocate. ಏನದು?
this memo may be kindly be considered. May your lordship may request my lord, page 145 may be kindly be
What
seen.
is my objection?
ತಾವು ನೋಡ್ಬೋದು ಒಂದು ತಮ್ಮ judgment.
ಅದೇ ಏನಿದೆ ಮೆಮೊ?
It is a-
preliminary ಎಲ್ಲ.
I do agree, I am not disputing.
Otherwise you take back this.
Now,
memo.
this,
What is this objection on memo?
the subject of matter is, you have question.
Stated so and so, particular sale deed filed. Discrepancy in extent ಆಗುತ್ತೆ. Land from clear para of appeal memo to notification.
In the facts and circumstances of the case, I may be permitted to make my submission.
ಅದು ಮೆಮೊದಲ್ಲಿ ಸರ್ಟಿಫಿಕೇಟ್ ಆಫ್ ಸೇಲ್ ಹಾಕಿದ್ದಾರೆ, ನಾಟ್ ಸೇಲ್ ಡೀಡ್. ಕಾಪಿ ಆಫ್ ಸೇಲ್. ಮತ್ತೆ ಅದಿನ್ನೊಂದೇನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಇದೆ ಅಲ್ಲ? That is discrepancy in prayer para of the appeal and notice. What is your prayer?
Sale deed ಅಂತ ಹಾಕಿದ್ರೆ ಅದು sale certificate. In fact, it is wrongly shown, it is actually sale certificate. By mistake.
Just annexure A2.
Our
Extent of
certificate of sale.
in
along with
making
the memo.
attachment in survey number 27/1, new survey number 27/7 and survey number 27/6 ಅದು ಇದ್ರಲ್ಲಿ ಏನಿದೆ ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ?
Total extent, my lord.
Discrepancy of land in prayer column of the appeal and notification. Notification is at page number?
Survey number is 27 to next.
Notification ಯಾವ page ಅಲ್ಲಿ ಇದೆ ರೀ?
138, my lord. Notification ಅಲ್ಲಿ 138, page 138. ಹೌದು. Serial number 30, 138 ಇಲ್ಲಿ ತಾವು kindly, Lakshmi, kindly 130. Serial number 30 is the notification. Yes, exactly. 27/1. Total extent.
ಅಲ್ಲ ನೀವು ಇಲ್ಲಿ ಹೇಳಿರೋದು ಸರ್ವೆ ನಂಬರ್ 27/1 and ಸರ್ವೆ ನಂಬರ್ 27/1, 27/7, 27/6 ಅಂತ. ಅದು ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು?
After the notification, there is a bifurcation. There is no quarrel about it.
Survey number 27/1.
Yes.
My son. Is that correct? He says that this number is revised. 27/1 has become 27/7
Yes.
and 27/6.
Exactly.
But on that aspect, I'll have to take instructions only as far as my lord. But the main contention of the appellant.
Correct. The property attached as per the notification is survey number 27/1. Eštadu? Extent to 1 acre 8 guntas.
Exactly.
Now in their prayer, they say this is given new number 27/7 and 27/6. Out of that.
I'll have to as far as my lord, that I may be permitted to verify and my lord submit, my lords.
You will actually kindly the
Seeks time.
Well-
Submit. If there is any change in survey number of the attached property, which is the subject matter of this appeal. Okay. Yes, next.
the facts and circumstances of the case, my lord. You will actually kindly spare a minute. May I request, my lord, for kindly spare a minute. 145 may be kindly be seen, your lordship's order. 145. This is the fact. The entire case is covered by your lordship's order. Your lordship in a special court. 145. Kindly be seen, my lord. Come there. Interpreting the section 12(3) subclause 3 of the Karnataka Interest Protection Depositors Act. Now my case is also covered. Anyway, however,
Is the law laid down here?
the law, they have an interpretation, your lord, may I request, my lord, the section 12(3), page 152, your lordship, sir, paragraph 6. Section 12(3) of the Act 2004 provides an opportunity to the person interested in the property, irrespective whether notice is contemplated under section 3 subclause 3 of the Act was issued to him or not. Section 3 subclause 3 notice contemplates only a general notification. Section 12(3) of the Act 2004 reads as follows. Your lordship, powers of special court regarding the attachment. Any person, subclause 3, any person claiming an interest in the property attached or any portion thereof may, notwithstanding that no notice has been served upon him under section, make an objection as aforesaid to the special court at any time before an order is passed under subsection 4 or subsection 6. The above provision goes to show that entitled to object the proceeding before the special court for confirmation of the attachment order. Since the appellant possesses the registered sale deed with respect to the bits of the land aforesaid, they are entitled to an opportunity to subject the proceeding so far as the land relating to them. Therefore, the appeal deserves to be allowed only to the extent to provide an opportunity to the appellant. That is my submission before this honorable court. Here, my lord, in fact, by virtue of a registered instrument, I paid a
When did you purchase? When did you purchase?
I purchased it in the Lakshmi kindly on, that is by virtue of a registered 22/12/2021, my lord.
So that was after this
Yes,
attachment.
howದು. So Lakshmi kindly, I am not a party before the special court. I paid nearly 26 lakhs rupees.
But you have purchased it after attachment.
An agreement of sale.
Did you
After
accept
that,
the certificate?
I do agree with your lordship, sir. Now the issue
Then
before.
how are you entitled to seek
Now,
equity?
That's why, my lord, in fact, I do agree. I am an interested person as per the 12(3). I may be heard before the special court.
If you had purchased it prior to the attachment, it's all right, but
No,
you have purchased it, then notification, gazette notification was done.
The gazette
Yes.
notification, your lordship kindly appreciate
So what
me.
is the stage? You have brought it for sale?
Yes.
My lord, sir, may I make only two submissions, my lord.
Why
One,
have you
as far
brought
as,
it for sale now?
my lords, we have auctioned the property, my lord, but this property is not auctioned because, my lords, we have not got the bidder. Now it is his submission that the other property has been sold, so I should be permitted to purchase this property also at the same rate. My lords, I'll go to the memo, but kindly see, my lord, there's a suppression of fact and a deliberate misrepresentation. I'm so sorry to make this submission. The submission made is that they have purchased the property by a registered sale deed. Kindly come to page number 8. Sir, 1 minute, sir. 1 minute, sir. 1 minute,
Now
sir.
only you said you have purchased it. No, you submitted, you have purchased it under a registered.
No,
sale.
no, your lordship.
Kindly see page number 8. Sir, 1 minute, sir.
I am not suppressing, that was argued earlier.
You should tell us that now only you submitted.
No, your
you have
lordship
purchased
kindly,
it.
by virtue of an agreement of GPA, by virtue of.
Is it a registered? document?
No, your lordship, registered
registered?
GPA coupled with interest. I am aware of the judgment of the Supreme Court. So far, the position of law that was argued earlier before the same bench. My learned friend is also aware, and may I request the order of this.
You are not answering our question. Where is
Your
that?
lordship kindly.
Where is that your sale deed? Show us your sale deed or GPA, whatever it may
Your
be.
lordship kindly. Surya lamp, that is the
ಎಲ್ಲಿದೆ?
Surya lamp. My agreement of registered.
Page number ಎಲ್ಲಿದೆ?
ಹೌದು GPA ನಾ?
ಸೇಲ್ ಡೀಡ್ ಅಂತ ಹೇಳಿದ್ರ ಸೇಲ್ ಡೀಡ್
No.
ಅದ್ ಯಾವ್ದಾದ್ರು ಇರ್ಲಿ ಅದನ್ನ ತೋರಿಸಿ
Register, your lordship kindly, may I request,
ಪೇಜ್ ನಂಬರ್
121 may be kindly listed, annexure D. In fact, on this issue, you are argued earlier, and my learned friend has cited a judgment of the Apex Court, Suraj Lamp case. I am an interested person, my lord. Your lordship may kindly appreciate. I am an interested person as per section 12(3). I paid nearly 26 lakhs rupees.
ರಿಸೈಟಲ್
It's coupled with interest, and the sale agreement of sale was executed with respect to.
ಕ್ರಯದ ಒಪ್ಪಿಗೆ ಪತ್ರ ಅಂತ ಇದೆ.
ಹೌದು, ಸರ್ವೆ ನಂಬರ್ ಇದೆ, ತಾವು ನೋಡ್ಬೋದು 127.
ಈ ಕೆಳಕಂಡ ಕೆಲಸ ಕಾರ್ಯಗಳನ್ನು ನಡೆಸಲು ಈ ಸ್ವತ್ತನ್ನು ಬೇರೆಯವರಿಗೆ ಮಾರಾಟ ಮಾಡಲು ಖರೀದಿದಾರ ಕ್ರಯಪತ್ರಗಳ ತಿದ್ದುಪಡಿ ಪತ್ರಗಳನ್ನು
ಶೆಡ್ಯೂಲ್ ಸತ್ಯ ಪೇಜ್ 125. ಶೆಡ್ಯೂಲ್ ಜಮೀನು ವಿಚಾರವಾಗಿ ಮೇಲ್ಕಂಡ ವ್ಯವಹಾರಗಳಾದ 2 ಲಕ್ಷ ರೂಪಾಯಿ ನಿಮ್ಮಿಂದ ನಾವು ನಗದು ಮೂಲಕ ಮತ್ತು 9 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ಚೆಕ್ ಮೂಲಕ.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ನಿಮ್ಗೆ ಸೇಲ್ ಮಾಡಿದೀವಿ ಅಂತ ಎಲ್ಲಿದೆ ಇದ್ರಲ್ಲಿ?
No, your lordship kindly appreciate, in pursuance of the registered GPA, an agreement of sale was executed. An agreement of sale was executed. Now, my point for,
when was that?
my point for consideration is, I am an interested.
ಏನೋ ಕೇಳ್ತೀವಿ ಕ್ಲಾರಿಫಿಕೇಶನ್, ನೀವು ಹೇಳೋದೇ ಇಲ್ಲ. Now you said under this power of attorney you have purchased.
Exactly.
Show us from the power of attorney where there is a recital that it is sold to you under this power of
May
attorney.
page 123 may be kindly be.
123
ಆದ್ಮೇಲೆ 124 ಬನ್ನಿ.
124.
Yeah.
ಅಲ್ಲಿ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮೊಕದ್ದಮೆ ನಡೆಸಲು ವಕೀಲರನ್ನು ನೇಮಿಸಿಕೊಳ್ಳಲು ಕೇಸುಗಳನ್ನು ನಡೆಸಲು ಅಧಿಕಾರ ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂತ ಇದೆ. ಆಮೇಲೆ ತಹಸೀಲ್ದಾರ್ಗೆ ಎಲ್ಲ ಅರ್ಜಿ ಕೊಡೋದಕ್ಕೆ, ಸ್ವತ್ತು ಅಭಿವೃದ್ಧಿ ಪಡಿಸೋದಕ್ಕೆ ಅಂತೆಲ್ಲ ಇದೆ. ನಿಮಗ್ ಸೇಲ್ ಮಾಡಿದೀವಿ ಅಂತ ಎಲ್ಲಿದೆ ಇದ್ರಲ್ಲಿ?
ಕ್ರಯದ ಇವ ಲಕ್ಷ್ಮಿ ಕೈಲಿ ಬೇರೆಯವರಿಗೆ ಮಾರಾಟ ಮಾಡಲು 123 ನಲ್ಲಿ ಸಂಬಂಧಪಟ್ಟ ಖರೀದಾರಿ ಕ್ರಯದ ಕರಾರುಗಳು ಮತ್ತು ಕ್ರಯಪತ್ರ ತಿದ್ದುಪಡಿ ಮತ್ತು ಎಲ್ಲಾ ವಿವಿಧ ಪತ್ರಗಳ ಪರವಾಗಿ ಬರೆದು ಕೊಡಲು ಸದರಿ ಪತ್ರವನ್ನು ಸಂಬಂಧ ಉಪನೋಂದಣಿ ಕಚೇರಿಗೆ ಹಾಜರಾಗಿ ಕ್ರಯಪತ್ರವನ್ನು ಹಾಗೂ ಇತರೆ ಪತ್ರ ನೋಂದಣಿ ಮಾಡಿಕೊಡಲು ಎಲ್ಲಾ ಹೇಳಿಕೆ ಕೊಡಲು ಪ್ರತಿಫಲಗಳನ್ನು. ಈಗ ಹಿಯರ್ ಮೈ ಲಾರ್ಡ್, I virtue of a registered, that is a GPA coupled with interest, I paid an amount of 26 lakhs, and now by an agreement of sale was executed. I am an interested person as per section 12(3) of the Act. That is my only the point for your lordship consideration. Whether I am an interested person as per section 12(3). Now
ನೀವು ಅವಾಗ ಹೇಳಿದ್ರಿ you have purchased it on 22/12/2021 ಅಂತ.
Yes, exactly.
This is not this is 24/3/2022.
That notification is dated, my lord.
ಅಲ್ಲ ರೀ, ನಿಮ್ದು ಈ power of attorney which you are relying, it is dated 24/3/2022. ನೀವು ಅವಾಗ ಹೇಳಿದ್ರಿ you have purchased it on
No,
22.
Your Lordship kindly, sorry for the, Your Lordship kindly appreciate, the power of attorney was registered on 24/3/2022. 24,
Just before he submitted that you have purchased
Yes.
it on 22/12/2022.
there was an agreement of sale also. Your Lordship, all these documents to be looked into by the special court. What my contention is.
See, under the act, you get the right, if num judgment ತೋರಿಸಿದ್ರಲ್ಲ, if you have an interest in the property, when do you get interest in the property? If
So
there is a
after the registration of the,
sale deed in your favor.
after the
Even
registration.
if there is an agreement of sale, you will not get any interest.
My contention before this honorable court is, Your Lordship, by virtue of an unregistered, the registered GPA coupled with interest, I derive an interest in the property. The amount it paid rupees 26 lakh to the person only in favor of it, the Ravindranath. He sold the, and also executes an agreement of sale. All this fact to be adjudicated by the special court, and Your Lordship kindly appreciate 12(3) what it contemplates. Section 12(3) of the Act contemplates, my lord. Your Lordship, that is covered by the another judgment of this court. 12(3). Your Lordship kindly.
No dispute.
Any
that
person, Your Lordship kindly see.
If you have an interest in the property, you are entitled to right. of sale.
Exactly.
Huh.
I am an interest in the property, my lord.
That's what we asked to show us from your agreement, this GPA. Where is the recital that this is sold to you?
No, there is, so here the convention is that, my lord, there is if it is a transfer of right under the virtue of an instrument of a registered GPA coupled with it, certainly the court had to examine this issue.
Yes, yes, Mr. Response Counsel, what is it?
Please, my lord. My lord, there are two grounds, my lords, on which it cannot be held that the appellant has any locus. Point one, my lord, admitted fact notification is issued on 24th of June 2017, my lords.
June 2017.
17, my lord. And the claimed GPA, my lord, and the agreement to sell is 22/12/2021.
Yes,
Because any transaction subsequent to notification, my lords, will be void.
yes. The
Point one.
Act itself
Please, ma'am.
provides for that.
Please,
Act
my lord.
Which provision?
Hold on. I'll take my lords through that, my lord. I'll take my lords through that, my lords.
Yes, whether this agreement of sale creates an interest.
But I'll come to the second point, my lord. My lord, as far as my lord's question, clause 3, clause 4, why don't they cannot enter?
Section 3, no?
3, clause 4, please, my lord.
3 clause 4.
4, my lord.
On publication of notice, on the properties.
And the persons mentioned therein shall forthwith vest in the competent authority.
Yes.
So, my lords, once the
You said any transaction subsequent to that is void. Is there any provision for that?
my lords, I will, my lords, point out, my lords. No, please, my lord. This specific provision is not there. But by virtue of 3, clause 4, once the property stands vested with me, my lord.
Yes. Yes. Yes.
And secondly, please, my lord, the contention is that by virtue of a registered GPA and an unregistered agreement to sell, I have acquired the ownership. Lord, from ownership, it has now become interest. Nevertheless, my lord, my humble submission is, Lord, right from Suraj lamps, my lord, the Honorable Supreme Court till date, any conveyance or transfer of property shall have to happen in strict rigor of section 17 of the Act, and any GPA, ATS will not confer any title or right or interest in the property. My lord, to my lord's pointed questions as to whether at all there's any provision in the law which makes it void, my lords may kindly take rule number 6, my lord, rules, my lord, the KPID rules, my lord. Rule number 6, my lords, makes it void, my lord. Rule 6, my lord.
Yes,
My lord, when an order is made attaching the money or other property, am I able to point out, please, my lord?
yes, got it.
Please, please, my lord. When an ad interim order attaching the money or other property in the financial establishment is made by the government under section 3 of the Act, such money or property referred to in the order shall not be transferred to any other persons by any mode whatsoever. And if any such transfer is made, it shall be null and void. So, my lords, I am not even going to the question whether at all, my lords, an agreement to sell can be treated to be an instrument by virtue of which there can be a conveyance. Even otherwise, my lord, Rule 6 read with section 3 clause 2 of the Act makes the transaction impermissible. And secondly, my lord, as I was submitting, my lord, it cannot be held that by virtue of a GPA or an agreement to sell, they have acquired an interest to be heard by the court below. Thirdly, my lord, they were referring to my lord's judgment at page number 145.
That we said interested, we agree that if interest will be created.
Please, in fact, my lord's order is very clear at page number 151. If my lords were to kindly take my lord's page number 151, my lords. Page number 151 of the compilation. Para 4, my lords may kindly take my 151 in page 7 of the order. Para 4, my lords may kindly take my lords. The respondents therein, am I able to point out, my lord? The respondents therein, the original owners of the property, those served. The special court by the impugned order made the order of attachment. The appellants claim to have purchased different bits of land in survey number 495 under different registered sale deeds. And in all humility, my lord, in all humility, your lordships, my lords, I have failed. It's my failure that I have not brought to your lordships, my lord, the rigor of 12.3. Because, and other provisions by virtue of which, my lord, any person who has an interest can file an objection before the honorable court below. So, my lord, I'll not go into that question. At this point of time, my lords, it may not be required. So, anyway one looks at it, my lord, the appellant does not have a locus. Lords, and my lords may kindly recollect, my lord, in MFA number 930 of 2024, a similar question cropped up. So, as to whether at all a person who seems to have purchased.
You need not refer to the other things now.
Please, no, I board on, my lord, I board on, my lords.
May 2 points I'll point out. Two-folded argument, my lord. Lakshmi, kindly, one is I am citing a judgment of the Honorable Court with your permission, the learned single judge. And only on a limited purpose I am relying upon. Paragraph 19 of the judgment. Kindly, if I am come under the purview of this ratio and your lordship's judgment, para 19 of the order of the learned judge.
So citation, sir. Of the repetition number.
ILR
2010, Karnataka 328.
Shivshankar, please.
Para 19, my lord. Fine, para 19. If I am commanded in this ratio of the paragraph 19, 19,
Yes, Nkumar.
19, your lordship got it. The aforesaid provision provides a comprehensive machinery for adjudication of all the disputes arising out of an attachment of the property under section 3 of the Act. Once the competent authority appointed under section 5 of the Act makes an application to the special court seeking for an order of attachment to be made absolute, the proceeding before the special court commences. It is a judicial proceeding. The special court has to follow the following procedure. It shall issue notice to the financial establishment. B. It shall issue notice to the other persons, if any, whose property is attached by the designated authority under the section 3. C. This is very important, madam. C. It shall also issue such notice to all other persons. I am come under the purview of this clause C. It shall also issue such notice to all other persons representing it as having or being likely to claim any interest or title to the property attached by the designated authority under section 3. This is my submission. I am come under this subclass C of the, that is of in addition to your lordship's view. The second point, my lord, here what I try to pursue to equity. Your lordship, my own land and of the extent of 1 gunta was conducted by virtue of the auction was conducted. for the same amount, without litigating the property, without assuming for foregoing 26 lakh, I'm willing to purchase for.
Only purchase it in the auction. Is there any bar?
No, here, my lord, here I already, the 26 lakhs rupees for investing on this property. Now the question, you will ask me, why my application may be the priority, why I am, my own, no, what I request my humble submission before this, kindly I try to pursue on this point. You will ask me kindly, without, I may losing everything, whatever in a litigation. Now the question remains, my own property for 1 gunta was the action for 1,20,000. I am willing to purchase the same. That is my memo before this court. That may be kindly looked into. I may be permitted to proceed for it. If my learned friend agrees, I am willing to purchase.
Already only 1 gunta?
1 gunta's action ಮಾಡಿದ್ದಾರೆ.
ನೀವು ಇಲ್ಲೇನೋ ಇದು ಮಾಡಿದ್ದೀರಾ?
ನಮ್ದು it is my own property. I am in possession.
ನೀವು 39 guntas and 1 gunta ಅಂತ
Yes,
ಹೇಳಿದ್ರಿ.
ಹೌದು.
Not 1 gunta.
39 plus 1 gunta, total extent.
Correct. ಈಗ out of these two, 1 gunta is.
1 gunta was action.
Action ಮಾಡಿದ್ರೆ action ಎಲ್ಲ.
I do agree, your Lashman. My humble submission is because of the facts and circumstances of the case. What I try to.
ಹೇಳ್ತೀರಾ ಅದನ್ನ?
No. Because of the facts and circumstances. In my learned, let if the special competent authority concedes my submission, I am willing to purchase. But that is my memo before this court.
ಒಂದು property purchase ಒಂದು ನಿಮಿಷ ಕೇಳಿ ನಮ್ಮನ್ನು you are arguing.
I do.
ಅದೇ at least ಒಂದು ಎನ್ಕಮ್ರೆನ್ಸ್ ತಗೊಳ್ತಾರೆ ಬೋನಾಫೈಡ್ ಪರ್ಚೇಸರ್ಸ್ ಆದ್ರೆ ಏನ್ ಮಾಡ್ತಾರೆ ಪ್ರಾಪರ್ಟಿ ಗವರ್ಮೆಂಟ್ ಇಂದ ಗೆಜೆಟ್ ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ಅಟ್ಯಾಚ್ ಆಗಿರೋದನ್ನ
That's why your Lashman.
ಪರ್ಚೇಸ್ there is not even a sale deed.
My humble submission. No.
ಎಷ್ಟು ತನಕ
Registered instrument and coupled with interest and my the amount of through check it is paid by Lord. Your Lashman kindly appreciate. And now I am trying to interpret section. Your Lordship may kindly subclass C.
there is revision in
Let the special court look into all these issues.
property number. That is survey number 27/1 is assigned survey number 27/7 and 27/6. But there is no material in proof of the same. This appeal is filed challenging the order of
Special court.
the 16 additional number for comment. So it's additional city civil and session judge into bracket special court. ಇಲ್ಲಿ ಇದೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಮೇಲಿದೆ ನೋಡಕೊಂಡು ಪೂರ್ತಿ. So whereunder the special court exercising the powers under section 12 ಅಲ್ಲ follow 6 of act KP KPID FE full ಅದೇ ಮಾಡ್ಕೊಂಡ್ಬಿಡಿ 5 ಅಲ್ಲ 5 ಅವರು ಮಾಡಿರ್ತಾರೆ ಇವರು ಅಥಾರಿಟಿ ಕಾಂಪಿಟೆಂಟ್ ಅಥಾರಿಟಿ ಮಾಡಿ ಆಕ್ಟ್ ಫಾರ್ ಶಾರ್ಟ್ ಅಂತ ಮಾಡಿ ಫಾರ್ ಶಾರ್ಟ್ abbreviation ಅನ್ಕೊಳ್ಳಿ has confirmed made the interim order of attachment passed by respondent number 1 under section 5(2) another 5(2) of the act absolute. Okay, the appellant claims that he has purchased the property and therefore he is interested, he is a person interested in the property. He further contends that in that view of the matter, section 12(3) of the act required the special court to issue notice to him and hear him. In this case, the notification under section 5(2),
3(2), my lords. 3(2), my lords.
3(2) ಅಲ್ಲ 3(2) is that is competent authority ಮಾಡಿರೋದು notification final.
Illa, my lord. My lord, under the scheme of the
Appointment authority.
5(1) is the appointment of the competent
Appointment
authority
of-
by the government, my lord. 3(2) is the ad interim attachment issued by the government of Karnataka, please, my lord.
It is dated 24/6.
Of the act on the ground that respondent number 1 luring the public has collected the deposits from the investors and to defraud them, diverted the said funds, the directors, in this case, respond number 2, to defraud the, respond number 2, to defraud the investors, respond number 2, a director of, director, director of respond number 1 has diverted the funds and purchased the properties attached. Properties attached. The said notification was issued on 24/6/2017. Respond number 1, competent authority sought the confirmation of the same before the special judge under section 12.
Under 5.2, I filed a petition under 5.2, please, my lord.
Powers of the special judge.
12.3, my lord. 12, please, my lord. Section 12, my lord.
Confirmation will be done under section 12. Under section 12.
Please, my lord.
Under section 12 of the Act. The next. Lord Counsel, so and so Lord Senior Counsel, presses into service section 12.3 and of the Act and the judgments of this court in the following.
MS Shivashankar.
Following judgments of this court under the MS Shivashankar versus State of Karnataka, represented by its Chief Secretary to Government and under ILR 2010, Karnataka 328, ಇನ್ನೊಂದು ನಂಬರ್ ಕೊಟ್ಟರಲ್ಲ ನಮ್ದೊಂದು ಕೊಟ್ಟಿದ್ದಾರೆ ಯಾವುದು under court. Where is that judgment? What judgment you produced?
Para 19, my lord.
Page number.
Para 19.
Page number 144.
Some judgment to 145. 145. 145.
FA number 8332 of 2022. Page 145 with the parties name. DD 47/2023. Next one. Lord Counsel for respondent 1 submits that the first of all there is no sale in favor of the appellant. Secondly, the alleged power of attorney and general power of attorney
Registered.
of sale were subsequent to the attachment order of attachment, and therefore in view of section 3(2) of the Act and Rule 6 of the rules of the such transactions are wide. Next paragraph. Absolutely, there is no there can be no dispute with regard to the question that under section 12(3) of the Act requires the special court to issue notice to the person interested and hear him. However, transfer of property act coding in the general copy of the general power of attorney produced by the appellant's counsel, absolutely there is nothing to show that the property is sold. Therefore, under that document, no interest is transferred to the appellant. So far as the agreement of sale, section 52(4). However, agreement of sale does not transfer any interest on the him.
Section 54. The TP Act.
Then provisionally clear again. 53. I'm sorry, 53.
Section 54.
Section 54 makes it very clear. Section 54 of the transfer of property makes it very clear that a contract for the sale of immovable property itself does not create any interest in or charge over such property. Coupled with the aforesaid I'm sorry, therefore the said GP are the alleged agreement of sale have not created any interest in favor of the appellant. Further, section 3(2) of the Act clearly states that once the property is notification attaching the property is issued, such properties vest in the competent government anta ಇದೆ competent authority anta ಇದೆ
Competent authority.
government ಅಂತ ಇರ್ಬೇಕಾ
ಇಲ್ಲ, my lord, competent authority appointed by the government of Karnataka, please, my lord.
3(2) ಅಲ್ಲ
3(4), under 3(4), my lord, the property stands vested with the competent authority appointed by the government of Karnataka, please, my lord.
3(4) ಹಾಕ್ಬೇಕಾ vests in the competent authority. That is response number 1 in this case. Rule 6 of the rules. Rule 6 of the rules. States that when once ad interim order of attaching the property is passed under section 3 of the Act, such property shall not be transferred to any other persons in any mode, and such transfer made, if any, shall be null and void. Therefore, the alleged agreement of sale or the GPA has no legs to stand. We do not find any merit in the appeal, therefore the appeal is dismissed.
No. I am an interested person.
ನೀವು ಇಂಟ್ರೆಸ್ಟೆಡ್ ಪರ್ಸನ್ ಆಗೋದಿಲ್ಲ ಅಂತ ನಾವು ಹೋಲ್ಡ್ ಮಾಡಿದ್ವಿ.
I do agree with your lordship's view is concerned. 19 paragraph 19 ಅಲ್ಲಿ
ಅಲ್ಲ ಕರೆಕ್ಟ್ ನೀವು whatever you said, we said you do not become interested.
I do agree with your lordship, but I may be liberty to participate. No, I may be liberty to participate in the action.
You can participate. ನಮ್ಮ permission ಆಗ್ಬೇಕು. Dismissed.
One indulgence if I can seek for, please, my lord. My lord, even under 12(3), my lord, even if at all no notice has been issued, my lord, to the person having interest, even if he has, but he has an opportunity of filing objections. Now my lordship's order is being interpreted to say,
Party ಇರ್ಲಿಲ್ವಲ್ಲ, they were not party. ಇದು ತಗೊಂಡಿದ್ದು.
please, please.
But ಅಲ್ಲರಿ ಹೇಗೆ ಪರ್ಚೇಸ್
We are not a party to be.
ಅಲ್ಲ ರೀ, ಆದ್ರೆ ಇದು ಒಂದು ಏನು ರೆಕಾರ್ಡ್ ನೋಡಿ
ಏನಾಗುತ್ತೆ
ಎನ್ಕಂಬ್ರೆನ್ಸ್ ನೋಡದೆ ಅದೇ purchase ಮಾಡ್ತಾರೆ.
I know in a transaction
Due diligence.
I have do in a transaction like this, my lord. That has to be looked into.
Seal number 15.
Plus,
DS
declare
Umesh,
like.
Mahesh Vayal.
So, I appear for respondents
15.
in the matter.
39.
I appear for the appellant.
39.
14 and 15.
Yes.
Seal number 15.
I appear for respondents number 1 and 2. Notice I filed an application seeking for withdrawal of the compensation amount paid by the appellants. 21 lakhs 61,048 rupees was deposited.
Service and respond number.
I appear for the appellant, my lord.
Second time ಅಂತ.
ಅದು my lord, ಅಲ್ಲಿ there is some my lord confusion. In fact, R3 name is differently shown, my lord, in the causes.
Service and respond number 3 is held sufficient. Yes.
Notice I appear for response number 1 and 2. Notice I filed an application seeking for withdrawal of the compensation amount deposited by the appellant. Notes. Total amount that was awarded to me was 43 lakhs 22. By virtue of this honorable court's order, my lords, 21 lakhs 61,048 rupees has been deposited by the appellant.
Here, Miss, what do you say for release of the amount?
My lord, 20 lakhs may be permitted to be released.
20. How much is deposited?
21 lakhs 61,048.
ಇನ್ನು 1 ಲಕ್ಷ ಮಾತ್ರ ಉಳಿಯುತ್ತಂತಲ್ಲ.
ಅಲ್ಲ ಇದು statutory, I leave it to.
43 lakhs was the award, my apology.
I will leave it to him.
He has deposited only 50% of that.
Yes, ma'am.
How much is 50% investment ಎಷ್ಟು ಮಾಡಬೇಕು ಅಂತ ಮಾಡಿದ್ದಾರೆ? Remaining 50% investment. What is their age? 51 years, 47 years. Yes, release ಮಾಡಬಹುದಾ? ನಾನು 20 lakhs release ಮಾಡಿ ಅಂದ್ರೆ ಇನ್ಮೇಲೆ
ಮಾಡಿ ಸ್ವಾಮಿ, I leave it to my lord.
ಅಷ್ಟ ಅವ್ರು ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಸ್ವಲ್ಪ ತಾಳ್ಮೆಯಿಂದ ಕೇಳಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ.
ನೋಟಿಸ್ ಅದ್ರಲ್ಲಿ ತಾವು ಏನು ಐ ಕುಡ್ ನಾಟ್ ಹಿಯರ್ ಪ್ರಾಪರ್ಲಿ.
ನೀವಲ್ಲ ನಿಮ್ಮ ಕೌಂಟರ್ ಪಾರ್ಟ್.
ಅಲ್ಲ ಸರಿ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ನೌಶಾದ್ ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ ಥರ್ಡ್ ಪರ್ಸನ್, ಆದ್ರೆ ಆಕ್ಚುಲಿ ಅಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ. ನೌಶಾದ್ ಇಸ್ ನಾಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್. ಇದು
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 ವಾಸ್ ನೌಶಾದ್ ಕೆ ಕಮರುದ್ದೀನ್.
ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನನ್ನ ಅಪೀಲ್ ಅಲ್ಲಿ
ನೌಶಾದ್ ಸನ್ ಆಫ್ ಕಮರುದ್ದೀನ್ ಅಂತಾನೆ ಇದೆ ಅಪೀಲ್ ಮೆಮೋದಲ್ಲಿ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇಲ್ಲಿ ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಮೇ ಕೈಂಡ್ಲಿ ಬಿ ಸೀನ್.
ನಮ್ಮ ಕಾಸ್ ಲಿಸ್ಟ್ ನಲ್ಲಿ ನಾವು ಕರೆದ್ ಹೇಳ್ತಾ ಇದೀವಿ. ಈಗ ನೀನ್ ಯಾವ್ದೇ ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅಂತ ಬರ್ದಿದ್ರು.
ಹೌದೌದು, ಹಂಗ ತಾವ್ ಸರ್ ಮಾಡಿದ್ರೆ ಐ ವಿಲ್ ಲೀವ್ ಇಟ್ ಟು ಮಲರ್ಸ್. ಯಾಕೆಂದ್ರೆ 3, 4
ನೌಶಾದ್ ಕೆ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ.
ಇಂಟರ್ಚೇಂಜ್ ಮಾಡಿದ್ದಾರೆ ಅಲ್ಲ. ಈವನ್
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 is ನೌಶಾದ್ ಕೆ ಓನ್ಲಿ.
ಸರ್ಡ್ ಅಂತ R4 ಅಂತ ತೋರಿಸಿ ಸರ್ಡ್ ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ.
R3 ಗೆ ನೀವು ಹೇಳಿದ್ರೆ ಕ್ಲೇಮ್ಡ್ ಅಂತ.
ಹಾಗಾಗಿ
ನಾಸೀರ್ ಅಂತ ಇದೆ.
ದಟ್ಸ್ ರೈಟ್ ಮಲನ್. ನಾಸೀರ್ ಇಸ್ R4, ನೌಶಾದ್ ಇಸ್ R3.
ಹೇಳ್ತಾ ಇದೀವ್ರಿ. ನಿನ್ನಾದ್ರೂ ಇವತ್ತು ಇನ್ನೊಂದ್ಸರಿ ಕರ್ಸಿ. ಇನ್ನೊಂದ್ ಯಾವ್ದು ಆಗಿತ್ತು ಎಲ್ಲ ಬರಿತಾ ಕುತ್ಕೊಂಡ್ರೆ ಅದೇ ಒಂದು
ಅದ್ರ ಜೊತೆಗೆ ಸ್ವಾಮಿ ಯಾವತ್ತೋ ಮಾಡಿದ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಅನ್ನ
Law Counsel for the appellant brings to the notice of the court that respond number 4's name is wrongly shown in the cause list. Registration correct the same henceforth in the cause list. And his submission is found correct ಅಂತ ಬರ್ಕೊಂಡು. Okay. Order son 1 of 2024 by the in compliance with the interim order of this court. ಇಲ್ಲೇ ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಟ್ರಿಬ್ಯುನಲ್ ಬಂದೆ ತಮ್ಮ ಆರ್ಡರ್ ಇದು.
Deposited
on 20/12/2023.
award amount before the tribunal. Under the above application, respondent number 1 and 2, the claimants are seeking release of the same. ಇದು ಬರೀ ಕ್ವಾಂಟಮ್.
Yes madam.
Appellant's counsel clearly concedes for release of the amount on the ground that challenge is only on the quantum. Therefore, the tribunal is hereby directed to release the amount in deposit to the claimants in accordance with their shares in terms of the impugned award at the disseminate. Okay. I number 1 of 2024 is disposed of accordingly. Records in ಹೋಗ್ಬೇಕಾ ತಿರುಗಿ? Return the TCRs to the tribunal.
ಇಲ್ಲ TCR ಬಂದಿದೆ ಸ್ವಾಮಿ, ಅಡ್ಮಿಟ್ ಮಾಡಿದಿರಿ, ಹಿಯರಿಂಗ್ ಹೋಗ್ಬೇಕು.
ಅಲ್ಲ ಅದು ಅವ್ರಿಗೆ ಮತ್ತೆ ರಿಲೀಸ್ ತಗೊಳಕ್ ಹೋಗ್ಬೇಕಲ್ಲ ಈಗ.
ಹೌದು, that I will leave it to me. In fact, if he had been fair, immediately after vacation matter dispose ಮಾಡಬಹುದು.
Resubmit the records soon after the purpose is over. List of resubmission of the records. Yes.
Seal number 16, L. Shrikant Rao.
Milord, ಅದು ತಾವು ನೋಟಿಸ್ ಡಿಸ್ಪೆನ್ಸ್ ಆಯ್ತಾ ಸ್ವಾಮಿ ಇನ್ನೊಬ್ರು ಸಾತ್ರಿಗೆ?
ಅಲ್ಲ 4 ಯಾವ್ದ್ರಲ್ಲಿ ಇಟ್ ಈಸ್ ಹೆಲ್ಡ್ ಸಫಿಶಿಯಂಟ್, ಅದು ಅನ್ಕ್ಲೇಮ್ಡ್ ಅಂತ ಬಂದಿದೆ, ಇದ್ರಲ್ಲಿ ಬರ್ದಿಲ್ಲ ಅವರು.
I am grateful. Obliged.
Number 16.
Milord, I appear for the appellate in this case.
beg to appear for the first.
Matter is, the appeal is filed challenging the quantum as well as finding on negligence, Milord.
ಏನದು ನೆಗ್ಲಿಜೆನ್ಸ್?
3 vehicles are involved in the accident. And the insured vehicle is a car and the petitioner's vehicle is a bike and the other vehicle is tipper lorry. My car was overtaking and it hit the petitioner vehicle. Subsequently, the lorry ran over the left leg of the petitioner, as a result of which he sustained fractures.
Yes, of
And as far as the quantum is concerned,
was filed against whom?
I'm sorry,
Charge sheet was filed against whom?
charge sheet is filed against the driver of the car.
Car only.
ಮತ್ತು ಕ್ವಾಂಟಮ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀನಿ, ಯಾಕಂದ್ರೆ ಈವನ್ ಆಫ್ಟರ್ ದ ಆಕ್ಸಿಡೆಂಟ್ ಹಿ ಇಸ್ ವರ್ಕಿಂಗ್ ಆಸ್ ಎ.
Have you examined the driver of your
ಇಲ್ಲ
car?
ಮಾಡಿಲ್ಲ ಅಸೋಸಿಯೇಟ್ ಪ್ರಾಜೆಕ್ಟ್ ಮ್ಯಾನೇಜರ್ ಅಟ್ ಬೋಸ್ಟ್ ಕಂಪನಿಯಲ್ಲಿ ಕೆಲಸ ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಎವಿಡೆನ್ಸ್ ಇದೆ.
ಅದೇ ನೋ ಫಂಕ್ಷನಲ್ ಡಿಸಬಿಲಿಟಿ ಅಂತನಾ?
ಅಲ್ಲ ಅವ್ರ ಡಿಸೇಬ್ ಪಾಪ ಇದೆ, ಹಿ ಹಸ್ ಸಫರ್ಡ್ ದ ಡಿಸಬಿಲಿಟಿ. ಫಂಕ್ಷನ್ ಅಲ್ಲ ಇದು ಇದಿಲ್ಲ
ಆಗಿಲ್ಲ ಅಂತ
ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ ಅದು
ಫಂಕ್ಷನಲ್. ಎಷ್ಟು ಹೌ ಮಚ್ ಯು ಡೆಪಾಸಿಟೆಡ್?
30,000 ಮಾಡಿದ್ದೀನಿ, ಅದ್ರಲ್ಲಿ 50% ಕೊಟ್ಟು ಇನ್ 50% ಡಿಪಾಸಿಟ್ ಮಾಡಿ. ರೆಕಾರ್ಡ್ಸ್ ಮೇ ಬಿ ಕಾಲ್ಡ್ ಫಾರ್ ಇಟ್ ವುಡ್ ಬಿ.
May I make one submission?
ಅವ್ರದ್ದು ಒಂದು appeal ಇದೆ.
It's a case of amputation and he lost the job and he lost his family and 9 years. And he claimed for 35 crores he claimed. 35 crores he claimed. driver was not examined. It was just pushed along. 9 years he is there without a job, without family, and he's been suffering. And he is in need of money to support
ಇನ್ಕಮ್ ಕಡಿಮೆ
himself.
ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
But it was submitted that he has admitted in his evidence that
No.
he's in some employment.
It's all this.
They have the deposition copy.
ಹೌದು ಹೌದು.
Okay, records have been
Only
called.
notice ಅವ್ರಿಗೆ.
Records have been called. ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ
Now he is saying that.
ಅಲ್ಲ ಇನ್ಕಮ್ ಕಡಿಮೆ ತಗೊಂಡಿದ್ದಾರೆ ಪಾಪ. That's ಕೊಡ್ತೀವಿ.
no, my submission is the entire amount may kindly be released.
8 of 20.
8 of 24. ನಾನು ಕನ್ಸಿಡರ್ ಫಾರ್ ದ ಅಪೆಲೆಂಟ್ 1619. ನಾನು ಕನ್ಸಿಡರ್ ಫಾರ್ ಇನ್ನೂ ಯಾರಿಗೂ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ. ಅಪೆಲೆಂಟ್ ಸಬ್ಮಿಟ್ಸ್ ದಟ್ the negligence on the part of the insured vehicle and the quantum, you are disputing the quantum also.
ಕ್ವಾಂಟಮ್ ಅದೇ ಕ್ವಾಂಟಮ್
ಇನ್ನು ಕಡಿಮೆ ಆಯ್ತು ಅಂತ ನೀವೇ ಹೇಳಿದ್ರಿ.
ಅಲ್ಲ ಇನ್ಕಮ್ ತಗೊಂಡು 12,000 ತಗೊಂಡಿದ್ದಾರೆ ಪಾಪ. he was earning more.
Then why are you challenging?
ಅಲ್ಲ ಚಾಲೆಂಜ್ ಕ್ವಾಂಟಮ್ ಅಂದ್ರೆ ಅವ್ರು he is continued in the work.
Exactly. That in other words he has no loss of future earning.
Loss of future earning ಇಲ್ಲ ಅಂತ ಅದೊಂದು ತಪ್ಪು ಕೊಟ್ಟಿರೋದು ಅಂತ.
Functional disability only. What was his qualification?
he is a associate professor in
No, not.
ಅಲ್ಲ associate project manager in Bosch company.
He has claimant also has preferred an appeal.
that's it.
Yeah,
Good.
respond on claimant. However, he concedes for release of the 50% of the amount in deposit. Satisfied that the admit ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಆಗಿಲ್ಲ.
My submission may.
ಅವ್ರದ್ದೊಂದು ಅಪೀಲ್ ಇದೆ.
Heard. However, in view of the constitution of the Royal Council for the appellant, they have deposited 20 lakhs and order.
30 lakhs.
Tribunal, before tribunal.
ಅಲ್ಲ ಇಲ್ಲೇ ಕಟ್ಟಿದೆ ಹೈಕೋರ್ಟ್.
50% of the amount in deposit to respond number 1 digitally on furnishing the required documents. 2 of 2024 is disposed of accordingly. ಏನು ಇನ್ನು ನೀವು 3, 5, 6 ಅವ್ರಿಗೆಲ್ಲ ನೋಟಿಸ್ ತಗೋಬೇಕು ಅಂತ ಇದೆ, ಪ್ರೊಸೆಸ್ ಮಾಡಬೇಕು ಅಂತ.
ಎಸ್ ಕೊಡ್ತೀನಿ ನೋಡ್ಕೊಡ್ತೀನಿ ಮಾಡ್ತೀನಿ.
Second time, finally, 2 weeks time is granted to the vehicle in respect of his point 3, 5 and 6. We'll admit and call for records.
ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಅದು ಕನೆಕ್ಟೆಡ್ ಅಪೀಲ್ ಇದೆ ಅವ್ರದ್ದು ಬಂದ್ಬಿಟ್ರೆ ಐ ವಿಲ್ ಟೇಕ್ ನೋಟಿಸ್.
It is submitted that this matter is connected to MFA number.
2412 of 24.
List both the matters together.
The amount may, entire amount in deposit may kindly.
ಬೇಡ ಬರ್ಲಿ.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ he claimed 35 crores.
Not reduced according to him.
ಇಲ್ಲ, it's not there.
ಅಲ್ಲ it is
not
in
there.
the evidence.
Application after the
ಬರ್ಲಿ.
records are received.
611. Till number 17.
With that liberty, man. With it liberty to file application after the records.
He can file records with hearing because he is submitting that you have given some admission.
No,
Because we don't
50% is, no,
50% in
50%.
17 awaiting service of first respondent. 19. ಬರ್ಬೇಕಲ್ಲ records.
In this case,
Registry shall verify the status of service of notice and and list all.
my lord,
22.
temporary injunction.
2210.
Not to alienate ಕೇಳಿದ್ವಿ.
ಅಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿದೆ ಈಗ ಒಂದ್ಸರಿ ಏನು ಕೇಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಎಕ್ಸ್ಪರ್ಟ್
2210. Still number 18. Devrajyan.
Respond by filing the suit before trial court. You file the suit in respect to 3 properties, my lord. Filing the suit at rupees 40,50,000.
Then what is that second sit to appeal memo ಹಾಕಿಲ್ಲ ನೀವು?
ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ
Filing of the second.
ಇಲ್ಲ, the restriction is less than 15 lakhs, my lord. Violation of the suit is less than 15 lakhs. The matter should be placed before single bench. Since the violation should be shown in trial court was 40,50,000, they want the clarification in respect to that. As such, matters placed with the court, my lord. Kashif Masidi,
What was the suit for?
suit for specific forms, my lord. Right, Lakshmi, attention to page 55, my lord. 55, the judge. 55, my lord.
What is the value of?
54, my lord. The suit is filed in respect of 3 sites, my lord. 74, 75, and 76. Each side measuring 30 feet in 50 feet. So as for the first respondent, each side valued at rupees 30 lakhs 50,000. Now, subject matter of this appeal is in respect of one site, site number 74.
How it is valued before the trial court?
In respect of three sites, they valued at rate of 13 lakhs 50,000 each site and paid the court fee for 40 lakh 50,000. Now, the subject matter of the value of the property before this court is 13 lakh 15,000 in respect of one site. ಅಲ್ಲಿ ಮೂರು ಸೈಟ್ ಇರ್ತೈತಿ ಇಲ್ಲಿ ಒಂದು ಸೈಟ್ ಇದೆ.
Correct, ಮಧ್ಯದಲ್ಲಿ delay ಇದೆ ಅಂತ ಹೇಳಿದಾರಲ್ಲ, ಅದಕ್ಕೆ ಏನ್ ಹೇಳ್ತೀರಾ?
I am not a party with trial court, my lord.
Even if you are not a party, you have to file an application. That may be a ground for condonation of delay.
Yes, my lord.
But you have to file an application. for
I
that.
came to know about the execution of the decree of this suit when they filed a.
To get the point, that may be a ground for you to seek
Yes, my lord.
condonation of delay.
I'll file a concern necessary application before the single bench court, my lord.
Because you are saying it comes to the. For the purpose of court fee and jurisdiction, it is valued at rupees 40 lakhs 50,000.
That is in
For the
respect,
trial court.
in respect to three sites, my lord. 74, 75, and 76.
Seeking to set aside the entire decree.
ಇಲ್ಲ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ the trial court has
There in the prayer column of the appeal memo,
only in respect of 74 months, site number 74.
all for the record, set aside the judgment and decree on the file of so and so, having decree in favor of first respondent in respect of suit schedule property, bearing site number 74,
74.
permitting to, but they are not separately valued it.
I valued it separately at 30 lakh 50,000, my lord.
Your appeal may be restricted to that.
Yes, my lord.
For the purpose of jurisdiction, it comes to the division bench only, before the division bench.
In connected matter, it came before single bench, my lord. In respect of site number 76, the prepared appeal that is placed before single bench, my lord, basing on same value.
How that was placed by registry's note?
Yes, my lord.
But
I'm not a party to that case. In respect of other site owners, my lord.
now consider the appellant submits that the matter lies before the single judge. As he has sought relief only in respect of
Site number 74.
the subject matter of the suit. 74, only there is the schedule A property.
Yes, madam.
Yeah, that may decide only the people. But for the purpose of jurisdiction, the suit was valued for rupees 40 lakhs 50,000. And therefore, the division bench, the matter lies before the division bench only. Counsel submission in that regard is rejected. Now, counsel for the appellant submits that he was not a party to the suit. Therefore, limitation does not apply. That may be a ground for him to seek condonation of delay, but that does not itself enable him to file with appeal without filing a delay condonation application. Therefore, that submission is also overruled, rejected. 2 weeks time is granted to do the purpose.
Number 19, Sushant PA.
Come and please your lordships for the appellant.
Non-filing of?
My lord, I may make a
IA 1
submission.
of 2024. What is IA 1 of 2024?
My lord, for condemnation of delay, the submission made to the registry.
Mode cast title ಅಂದ್ರೆ ಏನದು?
My lord, we had mistakenly filed a short cast title. And we had to replace it with a comprehensive cast title.
Cast title.
Please, my lord, the
yeah.
full cast title, which would have the seal of the court.
Second cast title, IA.
Please, my lord.
Parties to IA, ಅದನ್ನ mention ಮಾಡಿಲ್ವಾ?
Please, we have, my lord, we have.
Not done that.
But then,
IA 1 of 2024, we are not finding that.
my lord, we have. Submission is.
IA 1 of 2024. Double cast title ಹಾಕಿಲ್ಲ ಅಂತ. ಅವ್ರು old cast.
The earlier cast title which contained the seal of this honorable court.
Where is it earlier?
That came to be misplaced during compliance, my lord. That is the submission that we have written.
You make it here now, at least here.
My lord, we can make it, but then we had a seal when it was filed for the first time. The earlier cast title would bear the seal of the court by the registry while accepting the papers. And when the new cast title came to be stitched, the earlier cast title came to be misplaced, my lord.
Who
And-
has misplaced it?
My lord,
You are our registry
No, my lord, it's on us, my lord.
Yeah,
We
but
have made that submission.
will
before.
permit you to make a cost title here also. Here also, double cost title is not there. You can make that.
My lord,
Permit you to do that. There ends the matter.
please, my lord, I'll oblige. My lord, if the matter could be passed over and we'll,
In the process of complying the office objection, the cost title of the application which was originally filed, thing is permitted to correct the cost title in IA number 1 of the.
my lord, I'll ಮಾಡಿದ್ದೀವಿ. My lord, if I may,
Is
Make
what is
a-
the other limitation para? 013. This is the only objection.
please, my lord.
And then what is the matter now?
My lord,
OS
the appellant before your lordship,
delay is against or delay ಇದೆ.
my lord,
How
of
much is
19 days.
19 days. Defendant number 4
Please, my lord.
is
The plaintiff is the mother of the defendant number 4. The plaintiff files a suit for declaration and the relief of injunction against her son, the defendant number 4. But then the learned trial court would grant the relief of eviction against the defendant number 4. A prayer or a relief that was never prayed for, nor were there any pleadings by the plaintiff before the learned trial court.
see the decree 7670. You say there was no prayer for possession.
Please, my lord, not against the defendant number 4. It was a prayer for injunction. My lord,
Declare that plaintiff is the absolute owner of the suit schedule property,
please,
suit schedule A property, suit schedule B, C, D properties.
please.
Direct defendant number 1 to 3 to vacate and hand over the possession of B, C, D properties,
Please.
which totally comprises the suit schedule A property to the plaintiff. Defendant number 4 was not party to the proceeding earlier.
My lord, we were the sole contesting defendant.
The order of injunction restraining defendant number 4 or anybody entering on the schedule A property.
My lord, the cause for this submission is,
Order directing defendant number 1 to 3 to pay damages till the date of, yes.
if I may address the points in brief about the factual foundations. 1993, the defendant number 4 gets married and he receives a certain sum of money from his father-in-law to purchase a property, a residential house. That is the pleading of the defendants. But the plaintiff said that the mother purchased the suit schedule property, which is a residential site, my lord. And subsequently,
Yes.
small residences are built where they could yield rental income. Come the year 2011, the plaintiff and her husband drop a will consisting of all their properties, which were around 10 in number, my lord, and they divide it amongst their 4 children. All 4 children are individually put into possession of the properties that were designated in the will. 5 years later, in the year 2016, the husband-wife canceled their will. Immediately thereafter, they filed this suit for declaration.
It means father and mother.
Father and mother of the appellant herein.
Okay.
The plaintiff and her husband.
What forced them to do that?
My lord, if I may, outside the pleadings, a bitter spat between the in-laws that would lead to litigation such as this.
They are entitled to cancel the will during their lifetime. No?
Please, my lord, we are not disputing that. But then the true cause for the filing of the suit is this, which was my submission that a bitter spat between the in-laws, the son gets in the crossfire. My lord, the appellant before your lordship has his family residing in the suit schedule property. They suppress this fact. The appellant has a daughter who is 24 years of age, who has finished her medicine and is on the verge of getting married, and a son who is 18 years of age, who is qualified to get into medical school. The appellant before your lordship is a tailor. Now, the family's contention, which is again a submission outside pleadings, is that the plaintiff and her husband would want to see the appellant's family on the streets. And they have,
Will do that.
my lord, which is the case here. They have filed an execution. The appellant told me, instructed me that the reason there's a 19 days delay is because he visited his parents every day and begged. Not considered, and 90 days later.
It was not sent for mediation before the trial.
My lord, no, my lord.
You did
In
not
fact,
seek-
I would urge
You did
this,
not seek mediation.
my lord, I would urge this honorable court if the matter could be relegated to
Seek
mediation.
Right court also.
My lord,
You are there before.
my
the
lord,
right court.
I was not, my lord. The suit. I was not. My lord, if I may be permitted to rely on,
Now they have filed execution petition.
please, my lord, which is coming up soon after vacation. My lord, if I may be permitted to rely on these authorities, the honorable. It was a relief never sought for. Neither was there a foundation in the pleadings.
Yeah, order 7, rule 7, court can mold the relief.
My lord, my only submission and my endeavor to impress on your lordships is that without the specific without a specific relief,
That court is trying to interfere.
that is the issue framed. But then the defendant and his family are already in possession with.
There were 2 suits, no, 3066 was by.
My lord, the appellant had filed a suit for injunction.
That is dismissed.
My lord, please, with the common judgment, and he would file his appeal.
Here on the other position will be done in part of the payment of the position. Continue. But heard the appellant's counsel. Then an office objection really.
My lord, the only.
Compliance.
Please.
Issue notice. Limitation para of appeal along with counsel submission. What is that limitation para? Hmm?
90 days.
The instant appeal has been presented outside the prescribed time and craves leave of this court to do so by a separate application. ಹಾಕಿದಾರಲ್ಲ application. ಅದೇ ಹೇಳಿದ್ವಲ್ಲ ಕರೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅದನ್ನ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಆಫ್ ದ ಅಪ್ಲಿಕೇಶನ್. You correct it now.
Please, my lord.
The appellant has filed a separate application for condonation of delay. Office objection regarding para 26 of the appeal memo does not survive. Heard the appellant counsel issue notice to the respondent. You have made others also respondents.
My lord, these were pro forma respondents. These were my tenants. But then they were ex parte that did not contest the case. They vacated the.
Execution number.
My lord, if I may be permitted to furnish it.
Execution petition number so and so in delivery warrant ಆಗಿದೆಯಾ?
My lord, my information is that they have received the summons.
Appellant is likely to be dispossessed, considering the relationship of the parties and the facts of the case. Interim stay of the execution of decree till next hearing date only. Till next
Please,
hearing date. List on
2310.
20.
Grateful, ma'am.
Number 20, Raghu Prasad BS.
Notice was ordered and it is still not served, my lord.
Awaiting service of so and so are 1 to 3.
Notice on the delay application notice was
List on let it come.
2410.
Ready.
Seal number 21, Token Patil, Pavan Kumar Bayan.
For the appellant in this case.
Respondent number 1, your lordship.
Is that second set of IA 1 of 2024 is
For
not?
furnishing of my lords, PF my lords.
No, second set of IA 1 of 2024 is not filed. Yes. To issue notice.
Yes, I will do the needful my lords. Weeks time may be granted.
Who has moved it?
We have moved it, my lords.
Why?
There's one other matter which is pending before my lords. MFA 3734 needs to be connected with this matter.
Give the number. At request, 10 days time is granted to do the full copy furnished.
I will do it.
He submitted that this matter is connected to MFA number 7, so list both the matters together after 2 weeks. Yes.
Seal number 22, GS Marlaya, HC Shivramu.
Notice to respondent more, or may kindly be dispensed.
Claimant's appeal,
Yes, my lord. Company appeal.
insurance. Appeal ಯಾರು manager ಅಷ್ಟೇ ತೋರಿಸಿದಾರ. Respondent number 4.
Four may kindly.
Who's respondent? Liability is not in the.
No, only quantum is challenged. 1 to 3 appeared.
Delay no idea. He was respondent number 1 before that, isn't it? Ex parte no agilla.
Illa 1 to 3
The
appeared.
records show that respondent number 1 had not contested the matter before the tribunal. The appellant is not disputing the liability under the insurance contract. Therefore, notice to respondent number 1 is dispensed with. Respondent number 4 is dispensed with as paid for. Respondent number 4 and because trial court was respondent. The IA 1 and 2024, who has moved it?
Stay may kindly be granted. 1 to 3 Sivaram is appeared. Last time. Yeah.
Ram, let's see, let me bring it up. Delay, how much delay is there? Control ಮಾಡ್ಬೋದಾ?
Control.
In administrative reasons?
Yes,
What
madam.
is an I number? 1 and 2024. Heard accepting the reasons. Reasons assigned for the delay. Delay of 18 days in filing the appeal is confirmed in the interest of justice. Admit call for PCRs. Interim stay ಕೊಟ್ಟಿದ್ವಾ ಈಗ ಮೊದಲು?
ಇಲ್ಲ stay in not granted. 50% ready to.
Pending ಇರುವಾಗಲೂ ಕೊಡ್ತಿರ್ತಾರೆ. How much is awarded?
73 lakhs.
Interim stay of the execution of the informed award subject to appellant depositing 50% of the award amount before tribunal.
Tribunal.
Mysore.
Mysore.
For tribunal within 4 weeks
Yes, ma'am.
from the date of this order.
Yes, ma'am.
Okay. List of the receipt of TCS.
Number 23,
Yeah, disposed of accordingly.
so number 23, PD Surana.
This subsection, no practice to be correctly.
Other day, my lord wanted to know the office to verify the deposit made by me in the earlier appeal.
Either.
Earlier appeal, like 2 crore 46 lakhs 29,021 is deposited.
So
In fact, it is a,
counsel for appellant has not mentioned the number of days with regard to 12% additional market value. And further, as per office
please
calculation.
kindly see.
369. ಅದೆಷ್ಟು ನಾವು ಮಾಡಿದೀವಿ ಒಂದು 248 rupees ವ್ಯತ್ಯಾಸ ಬರುತ್ತೆ ನಿಮ್ದಕ್ಕೆ ಅವ್ರಿಗೆ ಇನ್ನು 50% ಆಗ್ಬೇಕಂದ್ರೆ ಇನ್ನೊಂದು 748 ರೂಪಾಯಿ ಕಟ್ಟಬೇಕು ನೀವು ಅಷ್ಟೇ.
I will pay it one.
ಆಯ್ತು ನೆಕ್ಸ್ಟ್
Execution is filed. I'll take out hand summons. Meantime, stay may be granted.
as per the office note, the amount deposited is only short of rupees 248 rupees, short of rupees 248. ಅದು ಒಂದು ಕಡೆ ಇದ್ದ. You have deposited
2 crore 46 lakhs 29,021. That is exceeds the award amount.
ಅಲ್ಲಿ ಎಲ್ಲಿ
Only what remains is only balance of interest.
where do we find that?
In the MFA, earlier MFA, 7537.
7537.
37.
Have you filed it here?
May I pass on the order, my lord?
ಕೊಡಿ ನೋಡಿ ಅದನ್ನೇ ಮಾಡ್ತಿಲ್ಲ.
Order and also the copy of the DD.
Respond to the office of section 2. So, the value of the appeal to be stated as per section 23(1). That was the office of. My report already registered directed to place the matter. It is submitted that appeal is valued at 3 crores 15 lakhs 43,000 in order.
Because I have overvalued it because the trial court did not deduct that amount.
ಅಲ್ಲ ಅದಕ್ಕಿಂತ lower counsel for the appellant submits the. ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
I was directed deposit within 10 days. DD is enclosed. Copy of the DD.
ಇದನ್ನ ಕಾಪಿ ಹಾಕ್ಬಿಟ್ರೆ ಮುಗಿದು ಹೋಗುತ್ತಲ್ವಾ, ನಾವು ಅದನ್ನೇ ತಗೊಂಡ್ ಬರ್ತೀವಿ. Because otherwise those records have to be put up again.
I will obtain certificate copy.
ಅಲ್ಲ ಇದ್ರದ್ದು ಕಾಪಿನೇ ಹಾಕಿ. 2 crores 6 lakhs.
46 lakhs 29,021.
In the name of registrar. ಇದನ್ನೇ ಕಾಪಿ ಹಾಕಿ ಅಷ್ಟೇ.
ಹಾಕಿ.
Lower counsel for the appellant submits memo the previous ತೆಗೆದ್ಬಿಡಿ. Lower counsel for the appellant submits memo with copy of the order in MFA number 7537/2015 into bracket LAC and DD.
Copy of the DD.
Copies ಅಂತ ಹಿಂದೆ ಬಂದಿದೆ.
ಇದನ್ನ ಆಫೀಸಲ್ಲಿ ಹಾಕಿದ್ರೆ ನಾಟ್ ಲಿಜಿಬಲ್ ವಾಪಸ್ ಹಾಕ್ಬಿಡ್ತಾರೆ. ಅದೊಂದು ಪ್ರಾಬ್ಲಮ್.
46 lakhs 9,000 ಎಷ್ಟು ಅದು?
ಅಲ್ಲ 2 crore 46 lakhs 29,021.
ಹೌದು ನಮಗೂ ಓದಕ್ ಬರ್ತಾ ಇಲ್ಲ ನೋಡಿ. considering the same his objections overruled. Okay. ಏನು execution ಹಾಕಿದಾರಾ?
ಹಾಕಿದ್ದಾರೆ.
Delay ಇದೆ.
Delay is technical because award was not drawn by the court. The
But ಅದು
first
count
judgment ಅಲ್ಲಿ, judgment was amended, thereafter the award is drawn.
Issue notice to the respondents.
Emergent notice ಕೊಡಿ.
Present activity. Interim stay of ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ ಈಗ?
Only interest is due ಅಷ್ಟೇ.
Execution of the impugned award till next hearing date, because there is delay. Will be only till next hearing date.
611. Number 24, B. Pradeep.
Additional receipt for having deposited remain amount of 1,06,000.
All the amount has been deposited, but
Deposit within 2 weeks ಅಂತ
how the
ಬರ್ದಿದ್ದಾರೆ.
correct, that's the, kindly say, we are deposited, one patch is
ಅಲ್ಲ,
35
ನಿಮ್ಮ
lakhs.
The advocate on record has made a submission that remaining amount the appellant will deposit within 2 weeks ಅಂತ.
2 weeks is there, but another amount has been deposited, 2,93,664. There is no amount will be come out for the delay. ಅದಕ್ಕೋಸ್ಕರ.
On the verification receipt for having remaining 1,06,000.
38 lakhs deposit ಮಾಡಿದೀವಿ. Again and again they are this one for the deposit ಅಂತ ಹಾಕ್ತಾ ಇದ್ದಾರೆ. ಅದಕ್ಕೋಸ್ಕರ.
Advocate on record ಏನೇ ನಾವು deposit
ಅಲ್ಲ ಅದನ್ನ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿ ಅದಕ್ಕೆ that's why I shape like calling upon the company as to what is the deposit made by the company collected. After collected, that's why I submitted before this court. Kindly see.
ಯಾರು ಇದರಲ್ಲಿ ಪ್ರದೀಪ್ ಪಿ ಆರ್ ಯು ಆರ್
ಪ್ರದೀಪ್ಗೆ ಮೇಡಮ್.
ಈ ಪ್ರದೀಪ್ ಮಲ.
ಮತ್ತೆ ಅವ್ರ ಅಡ್ವೊಕೇಟ್ ಆನ್ ರೆಕಾರ್ಡ್ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತಾರೆ.
ಅದಕ್ಕೆ ಕಳಿಸಿದ್ದು ಯಾಕಂದ್ರೆ ಮೆಮೋ ಡಿಪಾಸಿಟ್ ಬಂದಿದೆ ಅದು ರಾಂಗ್ ಆಗಿದೆ ನೋಡಿ ಅಂತ
ಅಂಡರ್ಟೇಕಿಂಗ್ ಮಾಡಿದ್ದಾರೆ ಡೆಪಾಸಿಟ್ ಮಾಡಿಸಿ. ವಾಟ್ ಇಸ್ ದಿಸ್ DCA
ಲಯಬಿಲಿಟಿ ಮೇಲೆ ಬಂದಿರೋದು.
ಡೆಪಾಸಿಟ್ ಮೆಮೋ ಇಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. ಡೆಪಾಸಿಟ್
ಹಾಕಿದೀವಿ.
ಫೈಲ್ ಫಾರ್ ಎಷ್ಟು ಅಮೌಂಟ್ ಗೆ?
38 lakhs.
35 lakhs. ಚೆಕ್ಸ್ ಬೇರಿಂಗ್ ನಂಬರ್ so and so.
35 plus
2,93
ಮಾಡಿದೀವಿ. ಅದಕ್ಕೋಸ್ಕರ ಸಫಿಶಿಯಂಟ್ ಆಗುತ್ತೆ.
ನಾವು ಇದನ್ನೇನು ಡಿಲೇನೂ ಇದೆಯಾ?
ಡಿಲೇ
ಇಲ್ಲ, ಡಿಲೇ ಇಲ್ಲ, ಬಟ್ ಸ್ಟಿಲ್ ಸಬ್ಸ್ಟಾನ್ಷಿಯಲ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಮೇಲೆ ಮಾಡ್ಬೇಕಲ್ಲ.
ರಿಲೇಶನ್ಶಿಪ್ ಹೌದು ಸರ್.
ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ದ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್.
ಅವ್ರು ಇದ್ರಲ್ಲ.
ಇಲ್ಲೇನೋ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ, 2 ವಾರದಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿ ಅಷ್ಟೇ. ಇಂಟ್ರಿಮ್ ಸ್ಟೇ of the execution of the impugned award till next hearing date, subject to appellant depositing is 1,06,660 within 2 weeks before this court. List on date
711.
Call for TCR summary. Call for TC. ಅಲ್ಲ ಅದು ಬೇಡ, ಅವ್ರು ಬಂದಿಲ್ಲ, ಅವ್ರು ಹೇರ್ ಮಾಡಿದ್ಮೇಲೆ ಮೇಡಮ್ ಸಬ್ಸ್ಟಾನ್ಷಿಯಲ್ ಕ್ವಶನ್.
List number 2, frauders. Seal number 1. Yes, Anil Kumar.
Lordship appearing for serial number 1.
Early hearing filed by the appellant.
List number 2, fraud.
Sorry. There are list number 2.
List number 2, seal number 1. Yes, Anil Kumar. Ajay Kumar Patil.
Lordship appearing for appellant, kindly grant us 2 weeks time to comply. There were certain objections which had to be fulfilled in idea number 3 of 2022-23.
Condonation of delay in filing LR application. 2012 appeal. And on hearing the party known that I one of is for condonation of delay. However, the application it is mentioned to bring the LRs of the appellant. We are not complied that also. Application is filed in 2022.
Lordship, there were certain objections which has not been complied. Kindly give grant us 2 weeks time, Lordship.
2022 is not complied. Therefore, I number 1 of 2022. 1 of 22. Already correct ಮಾಡಿದಾರಲ್ಲ ಇಲ್ಲಿ, ಇದನ್ನು ಕರೆಕ್ಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಬರೀತಾರೆ. Order dated 26/7/2023. ನಾವೇನ್ ಹೇಳಿದ್ವಿ ಅದರಲ್ಲಿ ಅವರ್ ದ ಅಪ್ಲಿಕೇಶನ್ ಇಟ್ ಇಸ್ ಮೆನ್ಷನ್ ಟು ಬ್ರಿಂಗ್ ದ ಕರೆಕ್ಟ್ ಮಾಡಿದಾರಲ್ಲ ಅದನ್ನ ಅಪೆಲೆಂಟ್ ಇದನ್ನ R8 ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಇವ್ರ್ಯಾಕೆ ಹೀಗ್ ಬರೀತಾರೆ ನಮ್ಮ ಇದ್ರವ್ರು? You have corrected that. Respondent.
Lordship, as per my senior's instruction, there were certain objections in IA number 3 of 2022.
No, it was
which
on
we have
IA
now.
number 1 of 2022. You had wrongly mentioned the rank of the parties. Whom you want to bring on record? Respondent number 8 or appellant? Tell us. See, we had directed them to mention the name of respondent number 8. ಅದನ್ನ ಬದಲು ಅವ್ರು ಅಪೆಲೆಂಟ್ ಅಂತ ತಪ್ಪಾಗಿ ಬರೆದಿದ್ರು, ಅದನ್ನ ಕರೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅವರು. Who was respondent number 8? ನೋಡಿಲ್ಲ. Application respondent number 8. 2012 ಅನ್ಕೊಂಡು. They are not even 8 ನಂಜುಂಡಪ್ಪ, ಲೇಟ್ ಆಫ್ ಸನ್ ಆಫ್ ಅವ್ರ ಮಕ್ಕಳು ಹೆಂಡತಿ ಮಕ್ಕಳನ್ನೇ ಮಾಡಿದ್ದಾರೆ. Lord Counsel for the appellant has complied the office objection on IA 1 of 2022. Despite that, the registry has mentioned that office objection is not complied and listed the matter for dismissal of IA 1 of 2022. Registrar Judicial shall the said office objection is overruled. Registrar Judicial is requested to seek the explanation of the consent for such lapses. Notice was ordered or not ordered? Respondent number 8.
Not
IA notices were ordered or not?
No, Your Lordship.
Issue notice of IA number 1 to 3 1 to 3 of 2022 for the proposed loss of deceased respondent number 8. List on
811. Seal number 2, Mantesh Shettar.
File it or not? Conceal and register judicial forgive here. Participation notice. No representation for the appellant. Non-filing of the paper books in the sole respondent. 2024. Finally, 2 weeks time is granted to do the needful in respect of the respondent. List after 2 weeks. Yes.
Seal number 3, T. Prakash, MM Ashoka.
Sir, I represent the appellant.
Who ಮಾಡಿದ್ದಾರೆ ಬಂದಿಲ್ಲ.
Respond on the last, yes, madam.
So the appellant's counsel has moved this matter. He is absent. ಅದಾದ್ಮೇಲೆ ಬರ್ಕೊಂಡು.
Yes, madam. I represent the appellant in this case, madam. On the last occasion, madam, a submission was made with the other side to the effect that they have already entered into second marriage after the passing of the ex parte judgment and decree. I have clarified it and I filed a memo. There is no such second marriage and he is living in an illegal relationship with one Rekha. Soon after passing of the ex parte judgment, I have filed an appeal within the limitation period. And subsequently, there is also a stay.
So according to you, there is no marriage.
No marriage, no second marriage.
There was already an interim stay.
Yes, my lord, there is already a stay.
No, stay was granted on 15th March, my lord. But the judgment was passed on 14th September.
Proof of your marriage.
Yes, ma'am.
Where is the proof of your marriage? Proof of marriage, have you filed any proof of marriage or
No,
subsequent to the
that
request?
question is not posed.
That he is living with one lady illegally.
No,
And
he was
further, my lord,
submitted
this is a
last time we made a submission that
Yes,
is
my lord.
already married.
Yes, my lord, that is the false submission that has been made.
I think anyway, but
Anyhow, yeah,
therefore, counsel for the appellant is directed to clarify the status relating to respond in this matter, to pursue this matter in accordance with law.
Yes, my lord, I filed a written memo along with a birth certificate to show that he is living with one lady illegally.
Even before the decree.
Even before passing of the judgment itself, he has given birth to a child. The
No.
birth certificate may also be gone through. That shows that on 25/7/2023, 27/2023,
27.
date of birth.
Rekha PR,
Yes, the judgment is dated 14/9/2023.
9. But we'll take it on record, that's all. Do you admit or not? This is your child, this birth
That is
certificate.
the birth certificate.
That's
Have you got to say anything on this?
to ascertain.
What is?
Uh,
His name is.
There,
what is
if
like
your
that
lordship
is also
goes
shown.
through the averment made in the appeal memo,
Friend,
But further, my lord, further, it's a case for remand, my lord, because the judgment is passed an ex parte judgment. It could be, matter could be remanded.
memo filed by the counsel for the appellant along with the death certificate of Sunday
ಕಾಣ್ತಾ ಇದೆ ಸ್ವಾಮಿ, ನವೀನ್ ಮೊಲೆ ಕಾಣ್ತಾ ಇದೆ
of one district
ಬೇಕಾ?
is taken on record.
Yes.
ಮತ್ತೇನಾಗ್ಬೇಕು ಇದ್ರಲ್ಲಿ?
Yes, my lord.
CD, ಇದರಲ್ಲಿ CD delay condonation application not pressed.
Yes, my lord, that is not present because it is within the period of limitation.
Correct?
Yes, my lord.
Office
yeah,
is-
yes, that is even the office.
Within the period of limitation.
Since the administrative notice in time, I have 1/23 is not specified by the appellant's counsel and the same is disposed of accordingly. Stay is already there.
Yes, my lord, stay is there, my lord. That has to be extended further.
Records interim
And
stay.
further, this could be remanded back to the family court because this was not decided on merit.
After the vacation, we can list it.
Yes.
It was expert imagine.
Yes, my
But
lord.
they appeared before the court, my lord, engaged the counsel. Later on, they stayed away from the proceeding. The court has granted ample opportunity.
Additional evidence also you have filed.
Pardon, my lord?
Additional evidence also.
No, my lord, the question is, my lord,
Application for additional evidence ಅಂತ ಇದೆ ಅಲ್ಲ?
Allah, they have filed it.
Where is the interim
no,
order?
I
When it
not
was
filed.
passed?
Yes, my lord,
That on 15th
could be
March,
seen.
2024.
yes, my lord, 13 told two thousand
ಇದೆ
twenty-three.
last time
13 told
extended.
2023 it was stayed.
Extended till further orders. Okay. IA 2023 is disposed of accordingly. Okay, records ಬರ್ಬೇಕಾ? Admit call for.
Record, but
My lord, may not be required because I will,
How
file
the-
only the order sheet.
Agreeable for remanding the matter?
no, my lord,
They are not agreeable, so we have to
they,
see
they
the.
appeared before the court.
Call- What are you going to lose? You have an interim order now?
Yes.
Let me call for TCS, list after receipt of TCS. Yes.
List number 1, hearing on IA. Bill number 25, Shripad V. Shastri, this is Sitaram Rao. Madam, ಇದು ಬೆಳಗ್ಗೆ adjournment ಕೇಳ್ತಾರೆ.
ಯಾರು adjournment ಕೇಳಿದ್ರು? ಸೀತಾರಾಮ್ ರಾವ್ ಕೇಳ್ತಾ ಇದ್ರಲ್ಲ
ಅವರು
ಅವರೇ ಕೇಳಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಹೌದು.
2017, court hall moved in MFA 20, you had moved it.
No, my lord.
MFA 2463 of 2017, they had moved in your appeal.
ಹೌದು.
Vacating ಹಾಕೊಂಡಿದ್ದಾರೆ ಅಂತನಾ?
ಹೌದು, ಶ್ರೀಪಾದ್ ವಿಶ್.
As request, ಅವ್ರಿಗೆ no representation for the appellants, adjourned, yes. 2017 final hearing ಇದು
ಹೌದು, ಫೈನಲ್ ಹಿಯರಿಂಗ್.
ಅವರಲ್ಲಿ ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡವ್ರು ಇಲ್ಲ. Adjourned, no representation for the appellants. This for final hearing on matter admit ಆಗಿದೆಯಾ?
ಅಡ್ಮಿಟ್ ಆಗಿದೆ.
ಕನೆಕ್ಟೆಡ್ ಅಡ್ಮಿಟ್ ಆಗಿದೆ ಇದು?
ನಮ್ದು ಅಡ್ಮಿಟ್ ಆಗಿದೆ.
ನಿಮ್ದಾಗಿದೆ, ಇವ್ರದ್ರಲ್ಲಿ
ಅವ್ರದ್ದು ಗೊತ್ತಿಲ್ಲ.
This for final hearing on date ಹೇಳ್ಬಿಡಿ.
ಅಡ್ಮಿಟ್ ಆಗಿದೆ ಮೇಡಮ್.
ಅಡ್ಮಿಟ್ ಆಗಿಲ್ಲ?
7/11.
ಅಡ್ಮಿಟ್ ಅಂತ ಬರ್ಕೊಳ್ಳಿ. ನೋಡಿ ಚೆಕ್ ಮಾಡಿ ಸರ್, ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಅಡ್ಮಿಟ್. This for final hearing on
7/11.
7/11, I have 1/2024 to dispose of. Yes.
Number 26, KG Sadashivaya, KV Satish.
Recording already created.
I'm extremely sorry, Parnod.
Is that?
At the time of complaints of office objections, the matter was listed before this court, my lord. At that point of time, along with the application,
I have 1/2019. I have 1/20 does not serve and dismissed accordingly. ಏನದು
but the office objections, the matter was listed before this one.
18 or 19 ಯಾಕಂದ್ರೆ ನಮ್ದು ಆರ್ಡರ್ ಎಲ್ಲ ಏನೋ
19.
ಬಂದಿದೆ.
In that application, the office was objections to directing to,
2018 is for TI.
yes. For that application, my lord, office has objections was there, for which, my lord, I have been directed to produce the sale agreement to the application.
1/19 ಏನದು? ಎರಡೆರಡು ಬರ್ದಿದ್ದೀವಿ ನಾವು. ಅಲ್ಲ, 1/2019.
For recalling the,
So recalling ಗೆ ಇನ್ನೊಂದು recalling.
Because of this mistake not committed by me as well as the office, my lord. It is both have committed.
What was the office objection in IA one
My
of?
lord, all the objections have been complied. Only last objections which was raised by the court.
2019 will
Yes,
see.
my lord.
Yes,
That is,
6/12/2019.
my lord, I have been directed to
6/12/2019, it was dismissed for non-prosecution. ಅದನ್ನ recall ಮಾಡೋದಕ್ಕೆ IA 1 of 2018 ಹಾಕೊಂಡಿದ್ರಿ.
yes, my lord.
19 TI application.
Yes, ma'am.
Non-compliance of office objection on IA 1 of 2019. What is
That, in
office
that
objection?
application, my lord,
Second set of IA to be filed.
necessary
IA should be
corrections.
shown by competent authority, before competent authority.
Yes.
ಅದನ್ನ ಕಂಪ್ಲೈ ಮಾಡಿರ್ಲಿಲ್ಲ.
ಎಲ್ಲ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ ಈಗ.
ಈಗಲ್ರಿ ಅವಾಗ
ಹೌದು ಸ್ವಾಮಿ ಮಾಡಿಲ್ಲ.
ನಮ್ದು ಅದು IA 1 of 2018 ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ, ಅದು ಕರೆಕ್ಷನ್ ಮಾಡಬೇಕು. Yes, what do you say?
My lords, it was from 2019 onwards, my lords, they did not comply, my lords. Your lordship has noted already.
Corona was.
Twice it has been dismissed.
File was misplaced.
For non-compliance. ಇದು ಯಾವತ್ತು 6/12/2019 ಗೆ. ಅಲ್ಲ ಈ ರಿಕಾಲಿಂಗ್ ಮತ್ತೆ ಎಷ್ಟು ಸರಿ ಹಾಕ್ಬೇಕು ನಿಮ್ಗೆ?
Sorry, my lord, because of the reason that, my lord.
6/12/2019 ನಲ್ಲಿ ಇನ್ನು ಕರೋನಾ ಬಂದಿರ್ಲಿಲ್ಲ ಅವಾಗ.
ಅಲ್ಲ, my lord, no, I was unwell when, my lord, for that reason I have stated, my lord.
Lords, I have now taken an decree
And
for
file was
ejectment.
misplaced.
This is a suit for arbitration, my lords, was referred regarding specific
I have paid
performance. He
more than-
came in as a tenant, then he agreed to purchase the property, then he did not perform his contract. It was
I have paid more than
so
39
his
lakhs,
claim
my
for
lord.
arbitration for specific performance was rejected. Then the district court confirmed that order. My lords, I even tendered the amount, whatever was to be refunded to him. That
I have
also he
paid-
refused. And in the meanwhile, in 2018, I have filed a suit for,
2024 ವರೆಗೂ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ. How long?
because my
I'm
suit for
sorry,
ejectment was pending.
I am sorry, extremely.
appear ಆಗಿದ್ದೀನಿ, ಎಷ್ಟೊಂದು ಕೇಸ್ ಆಯ್ತು.
But true, my lord, I am extremely sorry, my lord. There are so many reasons for that, my lord.
Sorry.
My lord, I have paid, my lord, I have paid
Correct, you cannot
39
branch
lakhs.
proceedings like this.
My lord, true, my lord, I have paid,
18 ಅದು arbitration.
kindly consider, my lord.
Arbitration suit of 2015.
May I submit, my lord.
Because my
I have
suit
paid
for ejectment was
One
pending.
minute, 1 minute.
My suit
Paid-
for,
Oh, now you have complied the office
Yes, my lord, I have complied everything, my lord.
my,
I have complied everything, my lord.
recalling the order dated 2/8/2024. Comply ಮಾಡಿದಾರ ನೋಡಿ orders on IA 1 of 2019 subsection.
My lord, the one IA is to be considered by the court because, my lord, the
ಆಮೇಲೆ ನೋಡೋಣ ಮತ್ತೆ ಇದನ್ನ IA 1 of 2019 ಮೇಲೆ ಕಂಪ್ಲೈ ಮಾಡಿದಾರ ನೋಡೋಣ.
ಮಾಡಿದ್ದೀನಿ.
In the order dated, in the first sentence of order dated 2/8/2024. Due by typographical, due to typographical error. It is typed as IA 1 of 2018 instead of IA 1 of 2019. Therefore, the same is corrected. Comply ಮಾಡಿದಾರ? ಇನ್ನೂ ಕೊಟ್ಟಿಲ್ಲ ಅಂತಲ್ಲ ಸೆಕೆಂಡ್ ಸೆಟ್.
My lord, only one IA, my lord, for the.
IA 2 of 1 of 2019 was to recall the earlier dismissal order.
True, my lord.
ಅದರ ಮೇಲಿನ office objection comply ಮಾಡಿಲ್ಲ ಅಂತ IA 1 of 2019 dismissal.
We have given the,
Call
my lord, sorry, my lord, I have given that document to be supplied to the court. It has been court, but while submitting the document, my lord, it was attached along with that, my lord. It was not the part of the record.
Sorry, we can't, ಹೀಗೆಲ್ಲ ಮಾಡಿದ್ರೆ ನಾವು
My lord,
ಮಾಡಕ್ಕಾಗಲ್ಲ.
I am extremely sorry, my lord. You let me kindly appreciate all the office objections have complied, my lord.
ಅದೊಂದೇ ಸೆಕೆಂಡ್ ಸೆಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅನ್ನೋದು. ಯಾವ್ದು ಆರ್ಡರ್ ಡೇಟೆಡ್ 5/12/2019. ಅಲ್ಲ ಅದನ್ನ ಇದನ್ನ ಒಂದು ಮಾಡಿಲ್ಲ ಅಂತ ನೋಟ್ರಿ ಮುಂದೆ ಸ್ವೇರ್ ಆಗಿ ಕೊಡಿ ನೋಡೋಣ.
Memorandum of facts.
ಇಷ್ಟೊಂದು ಟೈಮ್ ಕಳಿಬೇಕಲ್ರಿ?
My lord, I am sorry, my lord. There is a mistake on my part, my lord. For that reason, my lord.
ಕರೆಕ್ಟ್, ಈಗಲೂ ನೀವು ನಾಟ್ ಇದನ್ನ.
But today, if at all any objections are there, my lord, let me kindly appreciate, my lord.
Sorry.
Allah, it is filed, my lord. May I submit, my lord? May I submit, my lord? Office objections, memorandum of application has been filed. True, my lord. True, my lord. True, my lord. Kindly accept that aspect, my lord. You let me kindly appreciate, my lord. Memorandum of facts has been filed, my lord, along with that.
the non-removal of office for non-compliance of the office objection. IA 1 of 2019 was filed to recall the said order. Till this day, the same.
Madam, we have complained, madam. Office may kindly be very directed to verify that, madam. I have complained. But memorandum of facts, you will me kindly see, madam. We have filed memorandum of facts, madam. For that man, that was not accepted.
2024.
Office may kindly be directed to verify the records, madam.
Therefore, IA 1 of 2019 was compliance, subject to compliance ಅಂತ ಮಾಡಿದ್ರು.
ಎಲ್ಲಿದ್ದರು?
ಇದರಲ್ಲಿ ಇದಕ್ಕೆ ಬಂತು. ಇದೊಂದು ಬಾಕಿ.
But only objection was that the non-furnishing of the relevant documents to the
even the office subsections, though time was granted to comply the office subsection on IA 1 of 2019, the peremptory order dated 37/2024 in that regard was not complied. Therefore, the same was dismissed. To recall that this application is filed, IA 1 of 2024 was filed, even that is dismissed on 2/8/2024. Again, to recall that order, ಈಗ ಯಾವ ಹಾಕಿರೋದು orders and I2 of 2024. The above application is filed. The records show that ಯಾವಾಗ arbitration ಶುರು ಆಗಿದ್ದ ಅವಾಗ purpose defeat ಆಗೋಗುತ್ತಲ್ಲ arbitration ಅದು.
I have completed the office objections, madam.
The arbitration proceedings.
But since they are paid more than 40 lakh.
2012, my lord, CMP.
Proceedings commenced in the year 2012.
But I paid more than 40 lakhs, madam.
This is not the way of doing this.
I am sorry for that, madam. I am extremely sorry for that.
The arbitrator's award is upheld.
Award is on 23rd June 2015.
Unsuccessfully.
But partly allowed, madam.
Yes, number 119 of 2015. Specific performance of the contract is dismissed.
Malad, for the reason, Malad, time was limited, was 15 days was directed to comply the that is the farmer.
It's modified to the little extent that plaintiffs are entitled to interest 34 lakhs.
Interest only
date for payment of
18% ಮಾಡಿದ್ದಾರೆ.
From the date of agreement on ಮಾಡಿದ್ದಾರೆ, not from the date of claim.
Malad, now, Malad, one opportunity is given, Malad. I will rectify all the things and
okay. Well, arbitrator's award was partly confirmed, granting awarding rupees 34 lakhs with interest at 18%. Since
along with cost also.
So
Along with
since
cost.
2018, the respondents have not, I'm sorry, this matter is going only in the compliance only. This is nothing but abuse of the process of the court.
Sorry, Malad.
There are no grounds to.
But one more opportunity may be given, Malad.
As the same is dismissed.
Malad, we have complained.
Cost act dismissed ಮಾಡ್ತೀವಿ ಹಾಗೆ.
Malad.
Dismissed with cost of fees 10,000 payable to the High Court Legal Services.
Sorry, Malad. Let me kindly appreciate, Malad.
Whatever may be our personal regards for you, but in this case, we can't do anything.
At least cost, Malad, cost is.
This is nothing but abuse of.
I'm sorry.
It is.
I have complained, Malad.
To the court also.
Malad, I am sorry, Malad. I have complained.
Comply ಮಾಡ್ತೇನೆ.
I have complained, Malad. I have complained, Malad. Only the documents have not been supplied to the court. That has been considered, Malad.
ಆಯ್ತು, ಎಕ್ಸ್ಕರ್ಸ್ ಕೊಡ್ಲಿ ಬಿಡಿ, ಅವ್ರು ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ರಿಕವರ್ ಮಾಡ್ಕೊತಾರೆ CLC ಅವರು. Next.
For a respondent.
Number 27.
Filed by respondent.
27/2024. What is the order?
Seeking the.
Pray for a week's time to file my objection statement. The appeal has, the Honorable Court was pleased to pass an order of stay of the judgment passed. They have sought for permission to seek if there are any changed circumstances regarding the demand drafts. I have obtained information from my client. I pray for a week's time to file my objection statement.
So who obtained the demand draft?
They have sought for modification of the interim order.
Settlement arrived in CC number so and so is paid by the appellant and appellant has purchased DD. The counsel appearing for response, he has no information. You are seeking modification?
Yes, ma'am.
They have not deposited. Last time you have said you will take instructions from your client. What instruction you got? According to them, in CC case, this matter was settled for rupees 50 lakhs. ಏನಾಗಿದೆ?
ಈಗ ಅವರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ, ಅಕಾರ್ಡಿಂಗ್ ಟು ದೆಮ್ ದ ಪೇಮೆಂಟ್ ವಾಸ್ ನಾಟ್ ಮೇಡ್ ಬೈ ಮೀ ಅಂತ. ಬೈ
ಆಗಿದ್ದಾದ್ರೂ
ನಿಜ, I have produced a certified copy itself, which is available before your lordships at ink page 75.
seeking modification of the order. What is that mean? Applicant. Who has filed this application?
The respondent.
Respondent. Applicant ಅಂತ ಬರೆದಿದ್ದಾರಲ್ಲ, respondent ಅಂತ ಬರೆಯೋದು application. Please
Lord, in pursuance of
and impose conditions. What is that condition you want?
Lord, the suit for specific performance was dismissed. A sum of 38 lakhs was directed to be refunded to the plaintiff, that is the respondent before your lordships. Lord, according to us, in a settlement before Lok Adalat, that amount has been paid.
That settlement.
Please, madam.
Proof.
It is there before your lordships at ink page 61. Compromise before the Lok Adalat. A contention was raised by them that it was not followed, for which we have produced a certified copy which shows that amount has been paid. Now, according to them, the payment was made by somebody else.
Paid or
Yes, exactly. In terms of the compromise of the local, the peculiar circumstances of this case is, I was not a party in that case. It was between the respondent and one Govindacharyalu. So they are saying amount was paid by Govindacharyalu, not you. There are certain other terms also which Govindacharyalu had agreed. But we have made a statement before this honorable court that Anshumalin Kumar Shah. Yes, he is the defendant, appellant before your lordships. My lord, there is a
That case was between Bharat Chandra and one Govind Rajulu,
Yes.
not these parties.
Yes, but this suit has been mentioned there. But all of them are close friends.
Where is that mentioning in this?
Yes, my lord. I will take your lordships. Ink page 61. It starts from ink page 6. One nimsham.
No mention of this suit in 61 and 62.
It is there. It is there.
Where?
I will show it before your lordship.
Sure.
Before the local. Kindly take ink page 67. Yeah, it starts from 61. I'm sorry. In this case, between Bharat Chandra and Govindacharyalu, the settlement was arrived at. Kindly take ink page 67, my lord. Paragraph number 3. It is agreed by the complainant that he will withdraw the suits in OS number 1131 of the report. This is the suit which has now been decreed partly.
Complainant was not a party in that.
No.
Complainant was not a party in the suit. How does he withdraw that?
This case is different.
My lord, in that case,
Because the event will close it. Otherwise, they have paid it.
we have already paid it. That is our contention. No, my humble submission is,
You clarify this.
no, my humble submission is, I am in possession of the documents to show what they have stated in the affidavit that Govindacharyalu has paid it is incorrect. I will file it along with my objection statement. It may be taken up on the reopening day.
The Passover to clarify this. You want to take instruction and clarify it?
Senior Bhatta, kindly pass.
Yeah,
Yes.
senior.
My lord, in the absence, my lord, they have filed,
Indemnity.
my lord, my submission is, I may be granted a week's time to file my objection statement. Because without the objection statement and production of these documents, the application may not be able to be decided, my lord.
We'll passing it.
Very well.
Objection ಹಾಕಿದ್ರೆ we are hearing.
ಹಾಕಿದ್ರೆ ಟೈಮ್ ಕೊಡ್ಬೋದಾ?
please.
ಹಾಗಿದ್ರೆ ಹೇಳಿ.
Please, Milan. Can I have 16, Milan?
Now, counsel for appellant seeks time to. Who has moved it? File counter to.
They have moved it.
They have moved it.
Yes. I have been served with the copy of the IA through post. I will file my objections.
List on.
16, Milan.
16. ಮೊದಲೇ ಹೇಳ್ಬೇಕು ಇಲ್ವಾ?
Number 28, K. Shyam Sundar.
I prefer this appeal against the ex parte judgment and degree in OS number 6516 of 2014 dated 24/3/2018, my lord. No summons were issued and no notices were issued to the appellant.
Why
Sub-
did you not file application under order 9/13.
No, only I came to know
You
when.
could have filed there also, if you say your notice was not served on you.
Only when execution 241 of 2021, when deliverance was issued, he came to the spot to their house. Subsequently, I was consigned to file writ petition 20,649 of 2022 dated 29/12, wherein stay was granted. Subsequently, I filed this revision RFA, my lord. Even your honor may kindly see the judgment of page number 18, my lord. In the judgment, the appellant, defendant number, appellant's name Chandrasekhar is mentioned, his father name not known to the plaintiff. And subsequently, petition number, respondent number 2, 3, 4 are residing in the same address as stated. Page number 18, my lord. Wherein the appellant name is mentioned as Chandrasekhar, but father name not known to the plaintiff. And this appellant has been granted the site 30/20 by the BDA, Akkupatra, and subsequently he is leaving it to
Down here. And the city civil court.
execution 241 of 21 is pending, my lord.
How much delay is there?
Delay 986 days. Subsequently from 2014. Previously, this respondent one had filed 4 suits in the year 2009. It was dismissed in 28/10/2011, my lord. Subsequently,
Yeah, order 9/13 for
no notices are served on me, my lord. Subsequently, only on the paper.
For order 9/13. Issue notice to the respondent. Suit was of the year 2014.
From 2014 to 24/3, judgment was on 24/3/2018, my lord.
You claim that you are as a tenant in the property.
No, I am the owner, my lord. It was been granted by Akkupatra by the state government of Karnataka in the year 1972. From 1972, I am residing in the same address, along with 2 children and his wife, my lord.
ಇಲ್ಲಾದ್ರೂ ರೆಕಾರ್ಡ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ? ಏನು BDL ಅಲಾಟ್ಮೆಂಟ್ ಲೆಟರ್ ಏನಾದ್ರೂ ಇಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ?
ಇವಾಗ ಈಗ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬೇಕು. Akkupatra, everything is there, and I also paid up to date tax receipts, everything, my lord. And what water connection is there, and
ಎಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಿ ಅಂತ?
ಅಲ್ಲ ಇನ್ನ ಈ ಕೇಸ್ ಇನ್ನ ಬರಲಿಲ್ಲ. Ex parte judgment decree was taken by the first respondent. Subsequently, I could not appear before the court below.
We will not grant any unconditional interim order because there is 985 days delay is there. You deposit certain amount, then we will grant interim stay.
The last month they have paid 2 lakhs stamp duty.
ಯಾವ್ದಕ್ಕೆ?
ಇದರಲ್ಲಿ ಇದೆ ಕೇಸ್.
ಅದಕ್ಕೆ ನಾವು ಹೇಳಿದ್ವಿ ಸಿಂಪಲ್ you could have filed on order 9. There seems to be something amiss in this.
ಸ್ಟೇ ಮೇಲೆ ಡೆಪಾಸಿಟ್ ಮಾಡಿಸ್ತೀನಿ, ಸ್ಟೇ ಮೇಲೆ.
ಎಷ್ಟು ವ್ಯಾಲ್ಯೂ ಎಷ್ಟಿದೆ ಪ್ರಾಪರ್ಟಿದು?
Property value.
Suit was pending since 2014. You said they had filed multiple cases also earlier.
From 2014, the judgment was on 2018, my lord. Subsequently, after that, they have filed execution in 241 of 2000.
Depositing the sum of this file, interim stay to the interim till next day rate, subject to the appellant depositing the sum of this 5 lakhs before this court within 4 weeks. From the date of this order, list on
8/11.
8
Case number 29, HV Devraju.
Here for the appellant, the 27 days delay is there. But the office note that the respondents entered in appearance, their name has not been shown.
Advocate for appellant, these are the wakalat of respond number 4. Who has filed a?
The respondents already entered up.
1 to 4, Naradji Deepak and
Their name may be shown immediately after occasion, may kindly be listed.
they should show their name in the, though one Naradji Deepak has filed wakalat for respond number 1 to 4. Registry has not shown his name in the cause list. Registrar judicial shall seek the explanation of the concern. The name of Naradji Deepak level counsel shall be shown in the published for respond number 1 to 4. List on
2310.
Negligent, why they are doing this?
Case number 30, Chandrakant R. Gaule.
My lord, you'll also kindly permit me to appear, my lord, through video conference, my lord, as appellant in the above appeal. The application, my lord, 1/24 is for restoration of the appeal. Your lordship, my lord, dismiss the application, my lord,
dismiss the appeal on the ground that no steps have been taken to the objections were raised on the IA. The only objection according to me was service of notice to the other side. I have done it, my lord. I have thereafter.
Complied. Therefore, IA 3 to 25. Since respondent was the sole plaintiff, an abatement of the appeal does not serve.
It is thereafter, my lord, he has been served with the IA.
14/8/2024. Why you keep doing like this?
No, what happened was, my lord, your lordship had granted some time, my lord, for compliance, without, in the absence of which, my lord, the appeal would stand dismissed, my lord, was the preemptive order passed by.
Why inviting them here? In his
Pardon?
absence, he should come to the court.
Yes, my lord, I shall come.
Then why do
Today
you
there
come
was
to
some
the
difficulty. Your lordship may call it immediately after vacation, my lord. I shall come there personally and argue with you.
Position is already taken according to the position.
Maybe he would have taken the position, my lord. What happened was there was some mistake on my part, my lord, to prepare the appeal well within time and move the matter for stay. Anyway, my lord, that would not make the appeal, my lord.
Present application is also not maintainable because there are two.
My learned friend, my lord, he is not entitled to oppose this application for restoration. I am extremely sorry, my lord.
Why he is not entitled? He is a party.
Yeah, it is between the court and the appellant, my lord. That's how I would like to put it.
Heard this jurisprudence anywhere.
No, this application, my lord, this application for restoration is between the court and myself and the appellant counsel.
Where is that?
This judgment, my lord, is against the dead person.
Show us the law where it says that a party on record should not be heard.
Well, you lost me hearing, my lord. There is no difficulty. You lost me hearing.
Yes, now show us the law when you say they should not be heard.
Well, my lord, you lost me hearing, my lord. There is no difficulty.
No, itself.
Now when you say again, you say hear him. Yes, what do you say?
My lord, the caveat was filed, my lord, before this court on 6/1/2023, January. He has filed the RFA on 29/3/2023.
29?
March 2023.
Filing of the appeal.
Filing of the appeal. At the time of filing of the caveat itself, I had mentioned the LRs of the respond number 1.
So LRs had filed the caveat?
Yes, LRs only had filed the caveat.
It was filed
So it was there in his knowledge.
It was filed on?
6/1/2023, January. He has filed the appeal on 29/3/2023. Before he could file the appeal, I had already intimated him the
So
caveat.
against the dead person.
Against the
that
dead
you were
person.
trying to
Yes.
say.
In the trial court also, I had intimated, I was fair enough. Before the judgment, I had filed a memo reporting that the plaintiff is no more and he has been died in Kolkata. My memo was taken just and when the matter was
Before the trial court, on hearing the matter, he died or before hearing?
before the judgment.
On 3/12/22, my lord, he is dead. He is reported to have died, my lord, on 3/12/22.
We have heard you, let him submit.
Well, my lord.
When the matter was posted for judgment, my lord, after 3 or 4 hearing date, he died.
Yes.
So as per order 22 rule 6, there is a judicial order last time I had given.
If it was.
So once it was heard, so there was no necessity for the trial court to bring the LRs on record. Even though I made an effort by filing a caveat saying that he is no more and these are the persons who are the LRs of the respond number 1. After knowing that the death was reported on 1/6/2023 by filing a memo before this court also. Till that period also, they have not brought the LRs on record. Now he says that in the application, the address which has mentioned to him, the caveat was not served to him. I have an acknowledgement to show that on the same address, the caveat RPID was posted. But it is all bogus address which he has been giving before the court. It is not an authenticated address. Even in the execution proceedings also, we try to serve him the copies.
That is all about his conduct or etc. For restoration, what do you say? One thing.
Restoration, it is not maintainable, my lord. Because he has filed on the dead person, the appeal is not itself.
For
declaration and possession.
So even if possession is taken, Declaration part remains now for decision.
Yes, it remains, but the manner in which the application has been drafted, it is not maintainable, man.
What is that manner in which it is drafted?
They say that the caveat when I had filed before this court, it was not reached to them. And I had not communicated to them. It is not my duty to communicate. Already when I file a caveat petition before this court, it is his duty to check out in the office.
But
Your
was
Lordship,
that non-compliance on those IAs
he had not served me the copy of the LR application
on you?
on me. Delay application was not served, abatement application was not served. These are the office objections. And even today, he has not complied the office objections.
IA ಮೇಲಿನ office objection, IA ಮೇಲಿನ objection. So IAs were rejected. ಏನಂತಾರೆ? What was that?
For pending LRs received R1. That is second set IA papers to be filed.
ಈಗಾದ್ರೂ ಕೊಟ್ಟಿದ್ದಾರೆ ಸೆಕೆಂಡ್ ಸೆಟ್ IA papers ಕೊಟ್ಟಿದ್ದಾರೆ ಅಲ್ಲಿ IAದು. At least now we have section 1, 3 to 5.
They have written in the affidavit that it has not been complied.
I have served him, my lord. I have got the acknowledgement, my lord, for having served him, my lord, sent the applications, my lord.
You are not even aware what are the office objections.
Only thing is that, my lord, applications, LR application was to be served on him.
Second set to the other member of the bench.
I am sorry, my lord. I shall do that, my lord.
And you keep raising so many objections.
I shall do that, comply with application object. These objections, my lord, there are no objections raised on number 24. Anyway, my lord, I will ensure that all of the objections.
Application now we have not yet complied those.
That I am not aware, my lord. I shall do that, my lord, during this vacation.
Office objection on IA 3, second set of IA 3 to 5 of 2023 was not submitted. Therefore, those applications and consequently the appeal was dismissed by order dated 14/8/2024. So, even now, those office objections are not complied. As a precondition for hearing on IA number
1 of 24.
1 of 24, appellant's counsel 10 days time is granted to comply those office objections on IA 3 to 5 of 2023 and payment of cost of rupees 5,000 payable to the respondent within payable within 10 days, 10 days allowed, 2 weeks money. Within on or before next hearing date, list on date. Failing which IA 1 of 2024 shall stand dismissed.
2810.
Much obliged.
Number 31, Deepak J.
Partition suit, my lord, wherein notional partition has been granted, my lord. There is a delay of 768 days, my lord.
Notice.
My lord.
69 days, how many years?
768, my lord.
ಅದು ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು?
What has happened, my lord? He has approached the other forum, my lord. Page number 65, my lord. He's filed an RA, my lord. The valuation of the property is around 52 lakhs, my lord. And as per the contention, my lord,
Valuation slip ಎಲ್ಲ ಇತ್ತಲ್ವಾ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಲ್ಲಿ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ?
by
Issue notice to the respondents. List on
811. So number 32, Sanjeev PL. Chandrasekhar B.
This case, my lord, file application for raising of amount, my lord.
I request, my lord,
Application
friend
for
has,
raising of amount.
Release of the amount. ಎಲ್ಲಿದೆ ಅದು?
Lord,
By
I'm
mistake,
sorry, my lord, they have not yet deposited, my lord, that is what the cost.
Deposited before.
ಅಲ್ಲ
Office objection ಏನು ನಾನು ಡೆಪಾಸಿಟ್ ಮಾಡಿ
ಅಲ್ಲ ಆಗಿದೆ ಇಲ್ಲಿ ಬಂದಿರೋದು ಆಗಿಲ್ಲ ಅಂತ if it is deposited.
Law counsel for respondents wanted to submit that
1824 ಅಲ್ಲಿ ಮಾಡಿದ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
amount is deposited, therefore office objections would comply. Raised as spaced IA1 of 2024 filed by council for respondent number 1 and 2 for withdrawal of the amount. Yes, what do you say for that?
Lord, may I request, my lord, for 14th, it could be listed, my lord, that could be disposed of. Once and all.
Delay ಇದೆಯಲ್ಲ, what do you say for a delay? There is 72 days.
Our death case may not, amount may be.
ಮೊದಲು ಡಿಲೇ ಕಂಡೋನ್ ಆದ್ರೆ ನಿಮ್ಗೆ ಇಲ್ಲ ಅಂದ್ರೆ ಅಪೀಲ್ ವಜಾ ಆಗುತ್ತೆ, ಅದನ್ನು ಹೋಗುತ್ತೆ.
ಇಲ್ಲ, delay condone, delay condone.
Managing Director, KSRTC.
Yes.
KSRTC.
Why you want adjournment for this thing?
My lord.
Hearing on that application?
Sorry, my lord.
Why you want the time?
No, no, I'm not asking time, my lord. I'm only saying, my lord, 14th, if it be listed, my lord, finally it might be disposed of. Only for that ground.
Appeal is controlled. I2 of 2023 is disposed of accordingly. Yes, you are on which point? Challenge is on what ground? ಯಾವ ground ಮೇಲೆ challenge ಮಾಡಿದ್ರು? Who is this Shankarappa Hallur? Driver examined it since driver of the bus.
Exam ಮಾಡಿದರೆ ಮುಂದೆ ಹೋಗ್ತಾ ಇದ್ದ ಬೈಕ್ಗೆ ಹಿಂದಿಂದ ಬಂದು ಡ್ಯಾಶ್ ಹೊಡೆದಿದ್ದಾರೆ. Contributory it may be the challenge.
Case of death,
Death ಮೇಲೆ. Father and mother are the
how much is awarded?
awarded 32 lakh 51,000. They deposited 19 lakh 83,000.
Contributory negligence.
They're exhibited, they're accepted the accident. They are going in front of the
But they have examined the driver of the vehicle.
driver of the vehicles. Documents produced shows that they are he is going in front of the road bus and met with an accident. Even conductors and all those evidence are there.
Release ಮಾಡೋದಕ್ಕೆ amount.
Lord, 14th, it's a huge amount, my lord. For that reason, that is all.
Correct, ಅದ್ರಲ್ಲಿ part of it, other it can
Part,
be released.
part of it, my lord, might be released, my lord.
Total amount is
32 lakh.
32 lakhs, my lord.
you have deposited half of it.
19 lakh 83,000.
50% ತಗೊಳ್ಳಿ ಅಷ್ಟೇ. Lower council president consists for release of 50% of amount in deposit deposited before this court.
Tribunal.
For the tribunal.
Therefore, tribunal shall release 50% of amount in deposit to the claimants according to the ratio of their shares as in terms of the amount. IA which is equal to 1 of 24. 24 is disposed of accordingly. In a prayer or notice, only 2 responses are there.
Only 1 and 2.
All parties, yes.
List along with the claimant also filed appeal.
These both matters together.
Much obliged.
Number 33, Prakash M. Patil, H. Ramachandra Reddy.
Prakash and Patil. But I was given understanding that Prakash Patil is not in station. And also the vacating is filed, the stay has been granted after hearing the caveat.
When was this?
The caveat wasn't present on the date. Your Lordship.
21/3/2000.
Copy was served upon us.
Even before notice was issued.
Our caveat put up
Is filed.
very well. I don't have any instruction to submit because I am a proxy.
Verification of the order.
You last me have it after vacation. Specific performance suit ante they will stay.
No, declaration, Your Lordship. They have filed a suit for specific performance.
There were 2 suits.
Please, Your Lordship. One suit has been filed by,
Pending before this court.
please, Your Lordship. Another appeal has been pending. RFA number 2152 of 23, Your Lordship.
It is listed today only.
No, Your Lordship. That must be tagged along with this.
ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿರೋದ್ರಲ್ಲಿ 2 ಮ್ಯಾಟರ್ಸ್ ಯಾವುದು ಸಪರೇಟ್ ಆಗಿದೆ.
RFA 2165 of 23 has been listed today. And in that appeal, an ad interim order as prayed for in I number 1 of 2023 has been passed, Your Lordship.
So, which is that connected matter? Tell us, we can list both the matters.
Please, Your
together.
Lordship.
We can hear this
Please,
application.
Your Lordship, they may be at least permitted to file the objections, Your Lordship. They may be directed to file the objections. We have filed an application to vacate the interim order. We have served a copy upon them as well. We have filed
application.
We have filed, Your Lordship.
ಅಲ್ಲ ನಮಗೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಬೇಕು ಅಂತ ಹೇಳಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. I will instruct him to file.
They may be
Also,
directed.
the record is not there. If they want to file, let them file. Otherwise, we'll hear you.
Please, Your Lordship.
We submitted that this matter is connected to RFA number so and so. List both the matters together on and soon after vacation.
Date may be fixed, Your Lordship.
21.
Public.
Cell number 34, Satisha DJ.
Delay of 280 days. The husband petition, matrimonial.
2018 matter. Yes, it is 13-1-1A.
Please.
Issue notice to the respondent. List on
11. Cell number 35, Y Hari Prasad, Aswaraj.
My lord, I'm appearing for respondent 1 to 4. My lord,
Appellant, my lord.
I intend to file objections, my lord.
Your lordship may kindly say, the delay I have explained, my lord, along with the detail affidavit to file.
File objections to your
Allah,
My lord,
ಏನಾಗಿದೆ ಅಂದ್ರೆ, your lordship may kindly see last hearing order, kindly see the order sheet.
service of notice ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಹೌದು.
Now he wants to.
ಈಗ ಅರ್ಜೆನ್ಸಿ ಏನು ಅಂದ್ರೆ ಇದರಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಫೈಲ್ಡ್ ಬಿಫೋರ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್. It is posted on 14/10. ಸಾಹೇಬ್ ರಿಪೋರ್ಟ್
14/10 ಗಿಂತ ಮೊದಲ ಯಾವಾಗ ಓಪನಿಂಗ್ ಡೇ ಯಾವಾಗ?
14/10 immediately after. ಇದರಲ್ಲಿ I have deposited 1,91 lakhs. Your lordship may kindly see in the page number 11 of ink, page number 11 of paper, appeal memo. 1,95,43,492 ಕಟ್ಟಿದೆ. 3 ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಗಿದೆ ಈ ಕೋರ್ಟ್ನಲ್ಲಿ ಬಿಫೋರ್. ಇನ್ನೊಂದು 40 ಲಕ್ಷನೋ 50 ಲಕ್ಷನೋ ಇರುತ್ತೆ ಅಷ್ಟೇ. My contention is 2 things, my lord, regarding merit. That is one, the sale deed is marked, which sale deed is 1.5 kilometers away. And another one is, my lord,
First submit on the delay.
delay.
My lord.
He wants to file application to that.
In the affidavit I have detail mentioned, my lord.
There is delay of more than. My lord, there is a delay of.
Have you appeared in this case, learner counsel for respondent?
I am appearing for respondent 1 to 4, my lord. There is a delay of more than 8.5 years.
When did you?
I will file detailed objection, my lord. I will file detailed objection.
Execution case is listed on 14th.
14th.
You hold your hand till next hearing date.
My lord, now, but last time I filed wakalat. After I filed wakalat for the first time, the case has been listed.
Last time means when did you file? 30th August only.
No, I have filed, my lord. I have filed wakalat on August 30th. Thereafter, it is coming up today. But I am going because, my lord.
Filed the counter in the.
My lord, 1 week time may be granted, but soon after the case it may be posted. I will file objection because there is a delay of more than 8.5 years.
ಅಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಇದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸರ್.
Deposited?
1 crore 19.
Deposited 1 crore
95 lakhs 43,000.
95 lakhs they have deposited, my lord. And what my learned friend has submitted, the trial court has well considered while passing the award, because the property is situated in the same locality in which the property in question has been situated. I will convince your lordship regarding merits of the case. So for a delay is concerned, my lord.
Submits that appellant has deposited 1 crore 94 lakhs and odd, and the respondents have initiated a execution proceedings, and the same is listed on 14/10. Learned counsel for respondent, though opposed application, application for condonation of fee. Opposes grant of stay. So He has filed wakalat on 38/2024. So far, counter were not filed. Under the above circumstances, interim stay of the execution of the impugned award till next hearing date.
August.
They are sure I have deposited.
Deposited. Before this court only, before trial court, everything deposited.
1510.
1510.
1510.
15.
Cell number 36, Mrs. Shivannegowda, Chandrasekhara B.
I have filed the application to take out the notice to the owner of the vehicle. Paper publication.
Or to by way of paper publication.
Now I have noticed that second set was not filed in that. A week's time we were granted, I'll produce the second set of the.
Subsection raised ಮಾಡಿದ್ದೀರಾ? Permission to withdrawal of the amount.
Liabilities under the challenge, my lord. DC is himself, the injured himself was the riding the motorcycle.
Yes, 1/2024 ಅದರದೇ ಹಾಕಿಲ್ವಾ?
ಅಯ್ಯೇ ಅಲ್ಲ.
Second set.
ಪಬ್ಲಿಕೇಶನ್ ಆಗಿದೆ ಅನ್ಕೊಂಡಿದ್ದೀನಿ.
ಇಲ್ಲ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಒಂದ್ ಸೆಟ್ ಹಾಕಿದ್ದಾರೆ, ಎರಡನೇ ಸೆಟ್ ಹಾಕಿಲ್ಲ ಅಂತ.
ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಅಲ್ಲ, ಐದೇನೆ ಸೆಕೆಂಡ್ ಸೆಟ್ ಹಾಕಿಲ್ಲ. ಇನ್ನು
ಅಪ್ಲಿಕೇಶನ್ ದಟ್ಸ್ ವಾಟ್ ಐ ಆಮ್ ಮೇಕಿಂಗ್ ಸಬ್ಮಿಷನ್. ಅದಕ್ಕೆ ಎರಡನೇ ಸೆಟ್ ಹಾಕಿಲ್ಲ ಅಂತ ಅಬ್ಜೆಕ್ಷನ್ ಇವತ್ತು ನಾನು ನೋಟಿಸ್ ಮಾಡಿದೆ.
ರಿಲೀಸ್ ಕೇಳ್ತಾ ಇದಾರಲ್ಲ, ಅದಕ್ಕೆ ಏನ್ ಹೇಳ್ತೀರಿ?
But there is a delay of 79 days in the filing appeal. As per the MLC record, my lord, deceased himself was the injured himself was the riding the motorcycle at that point of time. For the self-negligence, my lord, the claim petition is not maintainable. Therefore, my lord, the liabilities under challenge, they are not entitled to get any compensation.
Spinal cord fracture. He went admitted in the hospital, several hospitals. Delay in filing a
The injury?
Spinal cord injury.
He is under a ventilating stage, my lord.
But
So he is represented for his next friend. ಯಾರೋ ಎವಿಡೆನ್ಸ್ ಪೃಥ್ವಿರಾಜ್ ಅಂತ, ಪೃಥ್ವಿರಾಜ್ ಭಾಸ್ಕರ್ ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದು ಇವಾಗ ಆಫ್ಟರ್ ಥಾಟ್.
ಇಲ್ಲ,
ಫೈಲಿಂಗ್ no document were play. Anyhow, my lord, the document indicate he himself was riding the motorcycle for his own negligence.
23 appeal, you should find the second set.
ಅಲ್ಲಿ ಇವತ್ತು ನಾನು ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ, ಅದನ್ನ ಹೇಳಿ. ವೀಕ್ಸ್ ಟೈಮ್ ಏನ್ ಮಾಡೋದು ನಾವು ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಮಾಡಿದೆ, ಬಟ್ ಸೆಕೆಂಡ್ ಸೆಟ್ ಹಾಕಿಲ್ಲ ಅಂತ ಅಷ್ಟೇ.
Liability is in dispute. Negligence and apparent liability is in dispute. Therefore, IA2 of 2024 is referred for consideration till next hearing date. Finally, 1 week time is granted to comply the objection on IA1 of 2024. Failing which application shall stand.
Please.
If ಮತ್ತೆ ಅದು ನಮ್ಗೆ ಹಿಯರಿಂಗ್ ಬರ್ಬೇಕು, ಮತ್ತೆ ಇದಾದ್ಮೇಲೆ
ಕಾಲಲಂಗ್ ವಿತ್
ಕರೆಕ್ಟ್
ಕಾಲಲಂಗ್ ವಿತ್ 4786 85 of 24 ಮೇಲೆ
ನೀವು ಅಪೀಲ್ ಹಾಕಿದ್ರಾ? It is submitted that this matter is connected to NVF number
47.
Both the matters together are
2510.
2510.
Much.
Cell number 37, Basavana KM.
And IA1 of 2024 and appeal against respondent number ಎಷ್ಟಾಗ 2 shall stand dismissed. Basavana KM. Kothal Mudu, no representation. CD of 594 days. 184 days in filing LR application for setting aside. No representation for the appeal. Notice ಹೋಗ್ಬೇಕಾಗದ್ದು. IA notice ಹೋಗ್ಬೇಕು, appeal notice ಹೋಗ್ಬೇಕು. There to bring the loss of disease respond number 6.
Defendant
No representation for the appellant. Issue notice of the appeal and IA number. ಅದು ಡಿಲೇ ಇದೆ ಇದರಲ್ಲಿ. appeal issue notice of IA1 notice of IA1 of 2024 and IA3 of 2024 to the respondents and the proposed loss of disease respond number 6 list on
defendant.
ತಪ್ಪಾಗಿದೆ. ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ ಒಂದು ನಿಮಿಷ ನೋಡೋಣ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 6 ಅಂತ. The name of respondent number 6 ಕಾವ್ಯ ಅಂತ ಇದೆ. ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 6 was on ಕೀರ್ತಿ ಅಂತ ಇದೆ. ಎಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಯಾಕೆ ಇರೋದು ಮತ್ತೆ ಅದು ಹೇಗದು Deceased loss of defendant number 6. ಅವ್ರಲ್ಲಿ ಪಾರ್ಟಿ ಇರ್ಲಿಲ್ಲ, ಅವ್ರನ್ನ ಆಲ್ರೆಡಿ ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ ಇಲ್ಲಿ. ಯಾರು? Defendant died leaving ಸೋಮ 20, ಅವ್ರನ್ನ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 20 ಅಂತ ಮಾಡಕ್ ಹೋಗ್ತಾರೆ, ಅಲ್ಲೇ ಮಾಡ್ಬೋದಿತ್ತಾನೆ. ಅಲ್ಲ, ಡಿಫೆಂಡ್ ನಂಬರ್ 6 ವಾಸ್ 1 ಕೀರ್ತಿ. ಹಿಂಗ್ ಮಾಡ್ಕೊ. No representation for the appellant. In I number 3 of 24, the ranks of the parties is not properly mentioned. The said officer, said objection shall be complied within 2 weeks. List after 2 weeks.
Seal number 38, SV Bhatt.
Lord, I prefer the appellant, my lord. 38 and 39 are connected, my lord, arising out of the same judgment. 39 is rejection of my counterclaim and 38 is against granting of a decree, my lord. Sorry, 38 is granting of a rejection of counterclaim. 39 is granting of decree for partition, my lord.
Yes, yes, yes.
There is a 2 days delay in the connected matter. There is about 28 days delay in the first matter, my lord.
Both are filed by you only. Okay.
My lord, respondents 4 to 13, my lord, they are.
Produced it in the connected matter.
Yes, my lord.
Of a certificate copy of the judgment and the ಕೇಳಿದ್ದಾರೆ.
Yes, my lord, that was produced in the other connected matter, my lord. That is the reason why I sought for dispensation.
Arise out of common judgment. Common judgment. Therefore, they shall be listed together. Since the certificate copy of the judgment is produced. Dispensation madam. Produced in RFA number 276 of 2024. Production of the same in RFA number 275 of 2024 is dispensed with. IA number 1 of 2024 in RFA number 275 of 2024 is disposed of accordingly. Okay.
I may be permitted to serve the notice on the council appearing before the trial court.
ಹಾಕಿದ್ದಾರೆ ನಮ್ಮ ರಿಜಿಸ್ಟ್ರಿ ಅವರು ಅದನ್ನ ಲಿಸ್ಟ್ ಮಾಡಿಲ್ಲ, ಯಾರು ಕೊಡಿ.
Pardon, my lord?
Somebody has filed caveat.
Yes, I suppose the caveat was caveat expired, I suppose, my lord. That's the reason why that has not been noted.
ಇಟ್ಟಿದಾರಾ ಇಲ್ಲೇನೋ ಇದೆ CP ಇಲ್ಲ ಇದು CD ಅಂತ consolidation of preliminary.
90 days time was expired, I suppose.
Who has 90 days ಆದ್ರೂ ಹಾಕಿರ್ತಾರೆ.
Right, my lord. I'm for a moment I am not saying anything. I may be permitted to take out notice to the council, my lord, insofar as the respondent want to see.
In the cause list. See, sometimes to defeat the CPs, appeal may be filed belatedly. CP.
Office has not noted the caveat for the reason that it was more than 90 days, my lord. That is the reason.
They cannot do that. Office cannot do that. It is not a judge.
I may be permitted to serve the notice on them, my lord. No problem.
ಯಾರು ಹಾಕಿದ್ದಾರೆ ಅಂತ ನೋಡಕ್ಕೆ ಅವ್ರ ಹೆಸರು ತೋರಿಸೋದಕ್ಕೆ ಹುಡುಕ್ತಾ ಇದೀವಿ. CS ವಿನೋದ್ ಅಂತ ಯಾರೋ ಹಾಕಿದ್ದಾರೆ. Though the caveat petition was filed in the matters, registry sitting over the same as a adjudicating authority has not noted the name, same has not noted that and showed the name of the caveat as counsel in the cause list. Registrar judicial shall seek the explanation of the consent for that.
I may also be permitted to serve the copy of the appeal memo to him, my lord, and also the IAS.
Caveat as counsel's name shall be shown in the cause list.
And insofar as respondent number 4 to 13 are concerned, my lord.
Henceforth, appellant's counsel is permitted to serve a notice on
Respondents 1 to 3, the caveat are.
ಅಲ್ಲ ಸೋಮಶೇಖರ್ ಅನ್ನೋರು ಕೇವೇಟ್ ಹಾಕಿದ್ದಾರೆ.
ಅವರು ಒಬ್ರಿಗೆ ಮಾತ್ರ ಹಾಕಿದ್ದಾರೆ. ದಟ್ ಇಸ್ ದಿ ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್.
ನಿಮ್ಮ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಇಸ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಅಲ್ವಾ?
ಹೌದು. plaintiff is respondent number 1.
ಕೌನ್ಸಿಲ್ ಅಂತ ಬರ್ಕೊಂಡ್ಬಿಡಿ. ಬೇರೆಯವ್ರಿಗೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಲ್ವಾ?
ಬೇರೆಯವರಲ್ಲಿ notice number to the respondent number 2 and 3 notice may be ordered. Respondent number 4 to 13, my lord, notice may be dispensed. They did not contest. They are
Where
only
have
the
you filed
laborers who
memo
have
for
been made as
dispensation?
parties and no
Where
relief
have
has
you
been
filed
granted.
memo for dispensation? ಹಾಕಿಲ್ವಲ್ಲ ನೀವು?
14th, I have not filed the memo, but I am making submission. No relief has also been granted by the court, trial
File
court.
ಮಾಡಿ memo file ಮಾಡಿದ್ರೆ ಹಾಕ್ತೀವಿ.
Right, no relief has been granted by the trial court also, my lord, insofar as they are concerned.
Till number 40, D. Vijay Kumar, Jagdish.
High level.
Please, my lord.
For the respondent number 125, my lord, I filed an application for trial of amount, my lord. Already deposit before the trial.
My lord, I am for the appellant, my lord.
Our question,
My lord, I have to get the information whether they have deposited or not.
Deposited, my lord.
Deposited,
for withdrawal ಹಾಕಿದಾರಲ್ಲ ಅವರು.
Already deposited before the trial.
That the amount is deposited, therefore office subsections should comply. What do you say for this release of the amount? Yes, counsel for appellant. It is involving
Only negligence and my lord, quantum is concerned, my lord.
ration negligence. private
Against,
liability.
charge sheet against the deceased, case at BMTC bus, my lord.
My lord, 50% of the 50% may be permitted to withdraw subject to result of the appeal.
So he was proceeding on motorcycle.
Motorcycle, I am the proceedings.
How much is charge sheet was filed against?
Against the BMTC driver, bus driver.
ಎಷ್ಟು award ಆಗಿದೆ?
My lord, the award amount of rupees
35 lakhs?
35 lakhs 10,100. 50% of
50% of 50% may be permitted to withdraw.
50% release ಮಾಡಿ ಅಂತಾರೆ.
Please.
Oh, they are related, my wife and.
Wife and minors, my lord, and father and mother of the deceased. 1 to 5.
19 years ಅಂತ ತೋರಿಸಿದ್ರಲ್ಲ.
ಅಲ್ಲಲ್ಲ, my lord, is the brother of the sisters of the deceased. H-Yashoda.
They are not entitled for compensation.
Parents ಇದಾರಲ್ಲ.
Parents ಇದ್ದಾರೆ 4 and 5. 1 and 3 are the wife and children's.
So ಈಗ ವಿಡೋ ಇವ್ರಿಗೆ ಕೊಟ್ರೆ ಸಾಕಾಗುತ್ತಾ?
ಹೌದು.
Application is filed on behalf of all of them.
All 1 to 5.
ಎಲ್ಲರಿಗೂ ಅಪೋರ್ಷನ್ ಮಾಡಿದಾರಾ?
ಎಲ್ಲರಿಗೂ ಮಾಡಿದ್ವಿ.
Compensation amount, petitioner number 1 is 30%.
30% and
20%.
20% to 60%.
Petitioner number 3 is entitled to, I think
10%. Petition number 5, 4 and 5 is
apportionment seems to be incorrect ಅಲ್ವಾ?
ಕೆಳಗಡೆ ಕೋಟಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. 10% ಮಾಡಿ.
ವಿಡೋಗೆ ಜಾಸ್ತಿ ಕೊಡ್ಬೇಕು.
ಜಾಸ್ತಿ ಕೊಡ್ಬೇಕು. ಹೌದು.
ಆಮೇಲೆ 4 and parents ಗೆ ಏನು ಕೊಟ್ರೆ ಅವ್ರಿಗಿಬ್ಬರಿಗೂ 10%.
ಅಲ್ಲಿ ಪಿಟಿಷನ್ ನಂಬರ್ 3 ಗೆ 30% ಮಾಡಿದ್ದಾರೆ.
Widow should be,
Should be,
widow
ಹೌದು.
and minor child should be given the major.
Correct. ತಪ್ಪು ಮಾಡಿ.
So ಈಗ ರಿಲೀಸ್ ಮಾಡೋದು ನಾವು ಓನ್ಲಿ ವಿಡೋ ಅಂಡ್ ಇವ್ರಿಗೆ ರಿಲೀಸ್ ಮಾಡೋದು.
ಆಯ್ತು.
Admit call for TCRs. ಇನ್ಯಾರಿಗೆ notice ಆಗಿದೆ?
ನೋಟಿಸ್ ಆಲ್ರೆಡಿ ಆಗಿದೆ. TCR ಬಂದಿದೆ.
ಮಾತಾಡಬೇಡಿ.
ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ ಸರ್.
ಮತ್ತೆ ಹೋಗ್ಬೇಕಾಗುತ್ತೆ.
ವಾಪಸ್ ಹೋಗ್ಬೇಕಾಗುತ್ತೆ. TCR.
Orders and I to now consider for the appellant concedes for release of 50% of the amount in deposit. ಎಷ್ಟಾಗುತ್ತೆ ಅದು? ಮೈನರ್ ಬೇರೆ ಇದೆ. 50% ಅಂದ್ರೆ
16
16
15 lakh 15 lakhs 5,000.
ಎಷ್ಟು 16 lakhs ಆಗುತ್ತೆ. 16 lakhs ಅಲ್ಲ.
ಇಲ್ಲ 35 lakhs.
My lord, stay will have to be extended, my lord.
ಏನು?
Stay has to be extended.
Tribunal is given by directive to release 50% of the amount in deposit. Or 30% ಆದ್ರೆ ಬರೋದಿಲ್ಲ
ಮೈನರ್ಗೆ
ಇಲ್ಲ ಅವ್ರು 3 ಜನರಿಗೆ ಕೊಡ್ತೀವಿ ಅದನ್ನ ಆಮೇಲೆ ಡಿಸೈಡ್ ಮಾಡ್ಬೋದು. ಕ್ಲೈಮೆಂಟ್ ನಂಬರ್ 1 ಮತ್ತೆ ಯಾರು?
ಕ್ಲೈಮೆಂಟ್ ನಂಬರ್ 3, 4 and 5. 3, 4 and 5.
Digitally according to their shares in terms of the impugned award and invest the rest of the amount in FD for a period in any nationalized scheduled bank for a period of 1 year.
1 year, 5 years.
I number 2024 is disposed of accordingly.
TCR return.
Registration shall return the TCRs to the tribunal. Soon after the purpose is over, tribunal shall resubmit the records. Interim order granted. Limited by time ಕೊಟ್ಟಿತ್ತಾ interim order?
ಇಲ್ಲ, absolutely ಇಲ್ಲ.
Further
orders
ಆಗಿದೆ ಅಲ್ಲ?
ಆಗಿದೆ.
ಅವ್ರಿಗೆ ಏನಾಗಿದೆ ಅಂತ ನೋಡ್ಕೊಂಡಿರೋದಿಲ್ಲ ಅಷ್ಟೇ.
Much obliged.
Please.
Jayakar Shetty H.
Notice has to go, my lord, there is a delay.
Yes, for specific performance.
Specific one decreed, my lord,
Decreed. Okay. Issue notice to the respondent.
please.
List on.
11.
In the meanwhile, records may be called.
Delay then. Record se Yes, next.
Seal number 42, Kalyanar, Gautam Chand SP.
Lord, after filing the appeal on 21/6/2024, I filed LR application.
I have no objections to allow LR application.
Appeal was filed by. He died after filing the.
After filing, my lord, 21/6/2020.
Application is in time. Application in time is there.
In time, in time. There is no delay.
He died on 21/6.
21/6/2020,
Filed it on 26.
in time.
Pending this appeal, appellant number, appellant died.
Sole appellant,
on
sole appellant.
Therefore, his daughter, you know.
Daughter.
Daughter has filed the above application, order on I number estimate.
2 of 20.
So, come on record as is all. Response also consists to allow the application. Under the above circumstances, the application is allowed. The applicant is permitted to come on record as legal representative of deceased appellant. Appellant's counsel shall amend the cost title of appeal memo and furnish the copy of the amended appeal memo.
Please.
I number
So
estimate.
stay is concerned, I will
24.
file an application
2
for.
of 24. 42.
2 of 24 is disposed of accordingly. Must stay the
I will file objections.
counsel for response 6 time.
And notice has to go to the other respondents.
There are others also.
There are
Others
other
also.
respondents.
Others also.
Feel it in time, yeah, it should.
In time.
2 to 6. List down.
12/11. Seal number 43, Jayasima KP.
34 days delay.
Appellate my lordship, notice may be delay ಇದೆ, my lordship.
ಎಷ್ಟು ಕಡಿಮೆ delay ಇದೆ ಅಂತ.
Sir,
34 days delay.
yes, my lordship, the
Why?
counter appeal is pending, disposed. After that, this appellant is filed and one more appeal, the delay, my lordship.
Counter appeal is disposed.
Yes, my lord, that is 13/16 of 2015, that is
The
the,
other parties had preferred appeal.
yes, my lordship.
Appeal ಏನಾಗಿದೆ ವಜಾ ಆಗಿದೆಯಾ?
Allowed, that is partly allowed.
Allow ಆಗಿದೆಯಾ?
Allow ಆಗಿದೆ.
Issue notice to the respondents. List on.
13/11.
Oblige.
Seal number 44,
In this case, my lord, only 17 days delay. I have sought my lord interim order. The 17 days delay, my lord. Filing.
They have filed.
No,
finally-
this is first time coming. my lord.
ಅವ್ರು ಫೈನಲ್ ಡಿಗ್ರಿ ಪಿಟಿಷನ್ ಹಾಕೊಂಡಿದ್ದಾರಾ?
ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಏನಾಗಿದೆ ಫೈನಲ್ ಡಿಗ್ರಿ?
That is, my lord, pending before the trial court. That,
Stage of that case.
that is, notice has been issued to the parties. Therefore, my respectful submission is stay of, my lord.
Correct, delay the notice ಹೋಗಿ ಬರ್ಲಿ.
17 ದಿವಸ ಇದೆ.
According to you also, even in
Status.
final degree proceedings, there is no progress.
Status quo.
Issue notice to the
ಅಲ್ಲ,
respondent.
my position cannot be disturbed because I am in position of
ಪೊಸಿಷನ್ ಹೇಗ್ ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ತಾರೆ? ಫೈನಲ್ ಡಿಗ್ರಿ ಹಾಕ್ಬೇಕು, ಆಮೇಲೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕ್ಬೇಕು.
immediately after vacation.
ನಾವೇನು ಕೇಸ್ ಕಂಡಕ್ಟ್ ಮಾಡಿಲ್ಲ ಅನ್ನೋ ತರ ಹೇಳ್ತಾರೆ.
Immediately.
You expect too much from us.
4/11.
411. ಅಂದ್ರೆ ನೀವಂದ್ರೆ ನೀವು ಮೂವ್ ಮಾಡ್ತೀರಾ, ಇರೋದಿಲ್ಲ.
ಇಲ್ಲ, ನಾವು
ನೀವಂದ್ರೆ ನೀವಲ್ಲ, ಇವತ್ತು ನೋಡಿದ್ರೆ ಎಷ್ಟೊಂದು ಕೇಸಲ್ಲಿ ಆ ರೀತಿ ಆಗಿದೆ. ಕಂಪ್ಲೈ ಮಾಡಿರೋದಿಲ್ಲ, ಮೂವ್ ಮಾಡೋದು.
Seal number 45, H.
ಮತ್ತೆ.
Devraju.
ಅದು 26th or 27th ಕೊಡು. 4. ಮತ್ತೆ.
ಒಳ್ಳೆ ನೋಟಿಸ್ ತಗೊಂಡ್ರ ದಿಸ್ ಆಲ್ಸೋ ರೆಸಿಡ್ಯೂ ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ದ
45 and 46 both.
ಲಿಸ್ಟ್ ಆನ್
13/11. Seal number 46.
The same act.
Same.
ಇದರಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿಲ್ವಾ ಇನ್ನು?
ಇನ್ನು ಹಾಕಿಲ್ಲ.
ಎಲೆಕ್ಟ್ರಿಸಿಟಿ.
ಹೌದು.
ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ದ ರೆಸ್ಪಾನ್ಸ್ ಲಿಸ್ಟ್ ಆನ್
1311. Till number 47, Somshekaraya RP.
Though there is insurance, my lord, and insurance is directed to deposit and to recover the amount from the. Right.
Notice
Yes,
ಹೋಗ್ಲೇ ಆಗಿದೆ.
notice it.
Delay ಇದೆಯಲ್ಲ ಅದನ್ನ.
ಹೌದು.
ಅವ್ರು ಇನ್ನೂ ಡೆಪಾಸಿಟ್ ಮಾಡಿ ನಿಮ್ಮ ಹತ್ರ
ಹೌದು.
issue notice to the respondents.
1311.
13.
48, Ajitesh Shetty.
It's a husband's appeal against Malots the decree of dismissing Malots his application for divorce. Malots, there is a connected appeal Malots which the husband has filed, questioning Malots the judgment passed on the counterclaim filed by the respondent wife Malots seeking restitution of conjugal rights. Malots, the FR may I just pass.
Dismiss.
This is against dismissal of his petition for divorce.
Stay really.
Illa, I can't press that.
You do not press I 2024.
ಇದ್ರಲ್ಲಿ ಆಗಲ್ಲ.
Lord also for the appellant submits that he doesn't press I 2024. Therefore the same is disposed of accordingly. ಅವ್ರು ಅಪಿಯರ್ ಆಗಿದಾರ ಕನೆಕ್ಟೆಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ?
ಇಲ್ಲ, ಅದನ್ನ ಇದರ ನಂತರ ಅದು ಹಾಕಿದ್ದು.
ನಂತರ ನೋಟಿಸ್ ಮಾಡೋದಾ?
ಅಲ್ಲ, ನಂತರ ಅಂದ್ರೆ ಅಪೀಲ್ ಹಾಕಿದ್ದು.
Right. No, do you want us to issue notice in this case?
Lordship may kindly order me to take out notice. And in the meantime, my lords, if my lords were to.
All right, we'll connect it. But
Very
ordering notice FR number ಇದೆ ಅಂತಲ್ರಿ ಇನ್ನು.
ಆಯ್ತು ಹಾಗಾದ್ರೆ.
Issue notice to the respondent, list on
1411.
14.
Grateful.
Till number 49, P. Lakshmi Rao.
Represent the appellant, my lord. This is by case at it, there is a 22 days a delay. And there is a direction by the court to deposit within 30 days. But appeal was filed thereafterwards. 15,90,000.
Issue notice to the respondents, no? Sole respondent. Two respondents.
Two respondents
They
and
went-
children of deceased.
The respondents, interim stay of execution of the improved award till next hearing date, subject to appellant depositing 50% of the award
Yes.
amount before the tribunal within 4 weeks from the date of this.
Yes.
List on
1411. Till number 50.
That is also similar, my lord.
Same, huh?
It's a 25 days delay. If
25
the
days.
incident is separate.
No, but these are separate awards only.
How?
How much is awarded here?
It is 30 lakhs,
31 lakhs 28,000. Same.
31 lakh 28,000.
Same. Date could have been.
1411. 51, Manjula Tejasvi.
Lordship,
Environment.
Your Lordship, insurance companies in appeal challenging the liability, Your Lordship. There is a delay of 22 days. The same may kindly be condoned. And I'll be depositing 50% of the award amount, Your Lordship.
Respondents?
Yes, Your Lordship.
Respondent notice ಹೋಗಿಲ್ಲ.
Yeah, ಇಲ್ಲ ಸ್ವಾಮಿ, stay in first time ಬರ್ತಾ ಇದೆ, stay ಆಗ್ಬೇಕು sir.
For respondent number 1 to 4 in this case.
ನಾವೇನು interim stay ಮಾಡಿದ್ರೆ subject to deposit ಅಂತ ಮಾಡ್ತೀವಿ.
Yes, Your Lordship.
Because you are disputing the liability.
Yes, Your Lordship. Yes, Your Lordship.
And what?
The deceased himself came and dashed into the backside portion, hind portion of the insured lorry.
That is negligence, but you are not disputing liability.
Contributory,
Liability is not
the charge sheet, the liability is not there, Your Lordship, negligence. ಹೌದು ಸ್ವಾಮಿ, ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು.
Fifth respondent again, you are insured person.
True, Your Lordship. True, Your Lordship. We have examined the driver also. ನಾನು first time ಒಂದ್ಸರಿ ಹೋಗ್ಲಿ ಅಂತ ಸುಮ್ನೆ I don't want to take the risk, Your Lordship. Next time if it doesn't appear, then I'll be filing a memo for it.
Fifth respondent. 5613. Interim stay of execution of the improved decree till improved award till next hearing date, subject to appellant depositing 50% of the award amount before the tribunal. ಇಲ್ಲೇ ಮಾಡಲಿಲ್ಲ
ಇಲ್ಲೇ ಮಾಡಿ.
ಇಲ್ಲೇ ಮಾಡಿ before this court. ಇದು ಯಾವ this is from which place? ಚಿತ್ರದುರ್ಗ.
ಚಿತ್ರದುರ್ಗ district.
Yes, Your Lordship.
Before the tribunal within 4 weeks from the date of this order.
And amount may be released in favor of the.
Your Lordship.
Or deposit ಆದ್ರೂ ಮಾಡಿದ್ರೆ because there is delay in filing.
Cell number 52, Shripad Shastri.
ಶಾಸ್ತ್ರಿ ಅವರಿಲ್ವಾ? 77 days. ಇದು ಏನು ಮೂವ್ ಮಾಡಿದ್ದಲ್ಲ. Issue notice to the respondents, list down
1411. Number 52, 53, Ashok
That's-
Patil.
53 and 54, they go together. Because we were not unmade parties belongs before the trial court.
And so therefore, my lords, we have sought for permission to prosecute the appeals.
They arise out of same judgment, no.
Same judgment, against the same judgment.
Parties are different.
Parties are different.
Appellants are different.
Appellants are different. They were supposed to be made parties before the trial court, but the first respondent, who was the petitioner before the trial court, did not make us parties.
Who was the appellant here in this case?
Appellant, lords, is the purchaser from the legatee who got the lords the probate as early as lords in 1993.
You are here for it.
I am for the caveator first respondent.
Yes, sir.
I was the original petitioner before
In
the,
both the cases, you appear for the first respondent.
yes, please.
He was the petitioner before the trial court.
Trial court.
But he didn't wish to.
There is a delay of 101 days.
I'm waiting for some time to file my objection.
54.
53 and 54.
Therefore, they shall be listed together. So, ಇದರಲ್ಲಿ ನಾವು ಆಫೀಸ್ objection ಆಗ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ, delay condonation.
Objections ಏನಿಲ್ಲ ಇದು.
I have objections. I'll file my objections. I'll also, what happened was there were two P&Cs. There were two wills, two P&Cs. So two revocation petitions were filed. In fact, the appellants herein were parties in the other petition. But I don't know whether they have, I may just pass on this.
Objection you want to file,
Let
file
them-
that.
I'll file it along with.
It's along with that.
Yes, I'll do that.
And
You are appearing for a owner. You know,
there are three other respondents.
seeks time to file counter to IA 1, 3 ಇದೆಯಲ್ವಾ? IA 1 to 4.
ನಾಲ್ಕಿದೆ.
He shall file the same in the registry within 2 weeks. Uldar notice order ಮಾಡಲ್ಲ?
Yes.
In both the cases, same
Yes,
number of
same respondents.
Issued respondents.
2 to 4.
2 to 4. List down.
711.
Please.
Say number 55. P. Vijay Kumar.
39 ಆಗಿದೆ ನೋಡಿ ಇಲ್ಲ ನಾವು. 50.
55. P. Vijay Kumar.
ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಆಯ್ತು ಬಿಡಿ, ಹಂಗಂದ್ರೆ ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ಳೋಣ. ಇಫ್ ಈಸ್ ನಾಟ್ ಪ್ರಿಪೇರ್ಡ್.
Your lordship, your lordship.
ಇವ್ರು ಎರಡೆರಡು ಡಿವೈಸ್ ಓಪನ್ ಮಾಡಿ ಇಟ್ಕೊಂಡು.
Good afternoon, sir.
ಹೇಳಿ ಸರ್.
Serial number 55.
55 ಕಾಲ್ ಮಾಡಿದ್ವಿ, ನೀವು ಏನು ಮಾತಾಡ್ಲೇ ಇಲ್ವಲ್ಲ ಸರ್, ಅದಕ್ಕೆ ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ಳೋಣ.
Okay, thank you.
ಮೇಡಮ್, ನಂಬರ್ 2 ಅಲ್ಲಿ ಬೇರಿಂಗ್ ಐಎಂ ಮತ್ತೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
ಇದಾದ್ಮೇಲೆ ಲಿಸ್ಟ್ 2. ಪ್ರಭು, ಇದನ್ನ 3 ಸೆಪರೇಟ್ ಕೊಡ್ತೀನಿ.
ಕೋರ್ಟ್ ಆಫ್ ಮೇಡಮ್ 2
ಅಲ್ಲ, ನೀವು 3 ಸೆಪರೇಟ್ ಕಳಿಸ್ಕೊಡ್ತೀನಿ.
2:30 ಇದೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
Serial number.
ಅದೇನ್ ಗೊತ್ತಾ, ಟೇಕನ್ ಆನ್ ರೆಕಾರ್ಡ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ನೀವು ಕೊಟ್ಟಿರ್ತಾರೆ,
ಇಲ್ಲಿ ಮೇಡಮ್ ಮೇಲ್ಗಡೆ ಇಟ್ಟಿದೆ. ನಿಮ್ 2:30 ಪಾಸ್ವರ್ಡ್ ತೋರಿದ್ರೆ ಇದೆ ಕಂಟಿನ್ಯೂ ತೋರಿದ್ರೆ.
ಪಾಸ್ವರ್ಡ್ ಒಂದೇ ಒಂದು. ಇದು ಪಾಸ್ವರ್ಡ್ ಒಂದೇ ಒಂದು ಕುಂತಿದೆ, ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. 60 ಮ್ಯಾಟ್ರು ಇಸ್ಕೊಂಡು ಹೋಗೋಣ. ಇವತ್ತು ಪೂಜೆ ಎಲ್ಲ ಇದೆಯಲ್ಲ, ಹಾಗತ್ತೆ ಮೇಡಮ್ ಮುಗಿಸ್ತಾರೆ ಅಂತ ಅನ್ಕೊಂಡ್ರೆ ಫಾಸ್ಟ್ ಆಗಿ ಹೋಗ್ತಾ ಇದ್ದೀನಿ. ಥ್ಯಾಂಕ್ ಯು. ಅದು ಟೆಕ್ನಾಲಜಿ ಅಲ್ಲ, ಇವತ್ತೆಲ್ಲ ಒಂದು 3 ಅದು ಬ್ರಾಂಚಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಮಾಡಿರ್ತಾರಲ್ಲ, CP ಲ್ಯಾಬ್ಸ್ ಆಗಿದ್ರೆ ಅವ್ರ ಹೆಸರು ತೋರಿಸ್ಬೇಕು, ತೋರಿಸ್ಬಿಟ್ಟು ಅದ್ರ ಕೆಳಗಡೆ ಲ್ಯಾಬ್ಸ್ ಅಂತ ಬರೀಬೇಕು. ಅದನ್ನ ಮಾಡಿಲ್ಲ, ಅದೊಂಥರ 2 ಕೊಟ್ಟಿದ್ದಾರೆ. ಒಂದು ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿದ್ದಾರೆ, ಡಿಸ್ಮಿಸಲ್ ಪೋಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿಲ್ಲ ಅಂತದಕ್ಕೆಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಒಂಚೂರು ಆ ಫೈಲ್ನ ಸೆಪರೇಟ್ ಆಗಿ ತೋರ್ಸಕ್ಕೆ ಹೇಳಿದ್ದಾರೆ ಚೇಂಬರಲ್ಲಿ, ಅವ್ರು ಬಂದಾಗ
Madam, serial number 57.
57 ಇನ್ನು ನಾಟ್ ಯೆಟ್ ರೀಚ್ಡ್. ಉಪೇಶಿ, ಇದು ಪ್ರಭುಗೆ ಸೆಪರೇಟ್ ಆಗಿ ಕೊಟ್ಬಿಡಿ. ಇದು 3 ಸೆಪರೇಟ್ ಪ್ರಭುದೇ, ಇದು ಪ್ರಭುದೇ, ಸೆಪರೇಟ್ ಆಗಿ RJ ಬಂದಾಗ ತೋರ್ಸೋದಕ್ಕೆ ಫೈಲ್. ಅವತ್ತೇ ಬರೆಯಪ್ಪ. ಅವ್ರ ಹತ್ರ ಅದಕ್ಕೆ ಇವತ್ತಿಂದ ಹಾಕಿದ್ದ, ಬೇಡ ತೆಗಿಯಕ್ಕೆ ಹೇಳಿದ್ರು.
ಅದು ಬ್ರಾಂಚಿಗೆ ಹಂಗೆ ಸರ್ ಕೊಟ್ಬಿಡೋಣ ಫೈಲ್.
ಅದ್ ಹಂಗೆ ಕೊಟ್ಬಿಡಪ್ಪ.
ಸರ್ಕಾರ ಕೊಟ್ಟಿದ್ರು.
ಅಲ್ಲಿದ್ದೆ ತಗೋ ನೋಡು ಅಂತ ಹೇಳಿ.
ಪ್ರಭುಗೆ 3 ಫೈಲ್ ಕೊಡ್ತೀನಿ.
ನಮ್ಗೆ ಕೋರ್ಟ್ ಆಫೀಸರ್ಸ್ಗೆಲ್ಲ CJ ಇದನ್ನ ಕರೆದಿದ್ದಾರೆ 3rd October. Honorable Chief Justice has directed to impart training in the said matter to concerned officials and stakeholders. ಯಾವತ್ತು 3ನೇ ತಾರೀಕು 12:15 ಎಲ್ಲರೂ ಹೋಗ್ಬೇಕು. ಹ್ಮ್ 12:15 ಹೋಗ್ತೀವಿ.
ಡಿಸ್ಪ್ಲೇ ಅಲ್ಲ?
ನಿಮ್ದ ಯಾರ್ದು ಗೊತ್ತಾಗಿಲ್ಲ, ಫೈಲ್ ಒಂಚೂರು ನೋಡ್ಕೊಂಡು ಹೋಗಿನಿ.
ಇಲ್ಲ ಅಂದ್ರೆ ಇವ್ನ ಸ್ವಲ್ಪ ಈ ಕಡೆ ತಳ್ಬೇಕು.
ಏನ್ ಗೊತ್ತಾ?
ಆ ಕಡೆ ಡಂಪ್ ಮಾಡ್ಬೇಕು.
ಸೀಲ್ ನಂಬರ್ 15 ಅಲ್ಲಿ ಇಲ್ಲಿ R3ಗೆ ಅವರು ಅನ್ಕ್ಲೇಮ್ಡ್ ಅಂತ ತೋರಿಸ್ತಾರೆ. ಇಲ್ಲಿ ನೀವು ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಅದೇ R4 ಅದು ನಜೀರಾ ಕೇಸ್ ಸರ್ವ್ಡ್ ಅಂತ ತೋರಿಸ್ಬೇಕು. R4 ನೌಶಾದ್ ಕೇಸ್ ಸರ್ವ್ಡ್ ಅಂತ ತೋರಿಸ್ಬೇಕು.
ಫೋಟೋ ಸರ್.
ಸರ್ ಹೇಳಿ ಸರ್.
ಹಾ, ಸ್ವಲ್ಪ ಮೈಕ್ ಹತ್ರ ಇಡಿ, ಅದ್ ಕೇಳಿಸೋದೇ ಇಲ್ಲಮ್ಮ.
ನೀವು ಒಬ್ರೇ ಸರ್.
ಸಾಹೇಬ್ರ ಮೈಕ್ ಹತ್ರ ಇಡಿ, ಅದ್ ಕೇಳಿಸೋದೇ ಇಲ್ಲ. ನೋಡಿ, ನಾನು ಬೆಳಗ್ಗೆಯಿಂದ ಕಾಯ್ತಾ ಇದ್ದೆ ಈ ಕೇಸ್ಗೆ. ಪಾಸ್ ಓವರ್ ಎಷ್ಟಿದೆ ಮೇಡಮ್?
ಸರ್ ನಾನ್ ಕಾಲ್ ಮಾಡಕ್ ಕೇಳ್ಸಲ್ವಾ ನಿಮ್ಗೆ? ಮೂರ್ ಸಲ
ಹಾ.
ಕಿರ್ಚಿದೀನಿ.
ಹಾ.
ಡಿ ವಿಜಯ್ ಕುಮಾರ್ ಅಂತ. ನೀವು ಅದನ್ನ ತಿರುಗಿಸ್ಲೇ ಇಲ್ಲ, ನಾನೇ ಮಾಡ್ಲಿಲ್ಲ. ಮೇಡಮ್ ಮಾತಾಡೋದಲ್ಲ, ನಾನ್ ಕಾಲ್ ಮಾಡಿದ್ದೆ.
ಜಸ್ಟ್ ಒಂದು ಲೈನ್ ಎಲ್ಲ ಇದ್ದೆ, ಬಟ್ ಇದೊಂದು ಮೀಡಿಯಾ ಇದು ಆಫ್ ಮಾಡ್ಕೊಂಡಿದ್ದೆ ಅಷ್ಟೇ. ನಾನು
ಡಿವೈಸ್ ಆನ್ ಮಾಡ್ಕೊಂಡು
ಮ್ಯೂಟ್ ಮಾಡಿದ್ದೆ ಅಷ್ಟೇ, ಬಟ್ ಇದ್ರಲ್ಲಿದೆ ವಿಡಿಯೋ ಕಾಲ್ತಾ ಇತ್ತು, ಆಡಿಯೋ ಮಾತ್ರ ಇದಾಗಿತ್ತು. ಅದು ಓಪನ್ ಮಾಡೋಷ್ಟ್ರೊಳಗಾಗಿ ಸಾಹೇಬ್ರು ಇದ್ಬಿಟ್ಟು. ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಎಚ್ ಡಿ ಜಗದೀಶ್ ಕೇಸಲ್ಲಿ ಎಷ್ಟು ಪರ್ಮಿಟ್ ಮಾಡಿದ್ರು ವಿಡ್ರಾಲ್ಗೆ?
ಲಿಸ್ಟ್ ಒನ್ ಲಾಸ್ಟ್ ಐಎ ಒಂದು ಮ್ಯಾಟ್ರ್ ಇದೆ. ಅದಾದ್ಮೇಲೆ ಅಡ್ಮಿಷನ್ ಲಿಸ್ಟ್ 2 ಐಎ, ಅದಾದ್ಮೇಲೆ ಲಿಸ್ಟ್ 1 ಅಡ್ಮಿಷನ್. ಅದೆಲ್ಲ ಏನ್ ಜಾಸ್ತಿ ಹೊತ್ತಿದೆಯಲ್ಲ. ಅಷ್ಟು ಒಳಗಡೆನೆ ಎಲ್ಲ ಗೊತ್ತಾಗೋಗಿರ್ತದೆ.
ಬೆಳಗ್ಗೆ ಹೊತ್ತು 2 hours ಮಾತ್ರ ಬೇಕು. Memo for posting after vacation. You can move there only. Why you want to move before us? Morning also you mentioned yesterday's matter. Sorry, ಅದು ತಗೊಂಡು ಕಳಿಸ್ಕೊಟ್ಬಿಡಿ after vacation. ಅವ್ರು ಹೇಳಿದ್ರು ಅದೇ ಮಾಡ್ತಿರ್ತಾರೆ after vacation. If you want to move before the vacation court, you go and move there. Sorry, then we can't help you. Yes.
Past over matters, number 5.
No. Final hearing matters, we will not be able to take up. Any of you are waiting for final hearing? Not wait. Yes.
Past over matter, list number 1, seal number 5.
Appear for the appellant.
Anand Ram K, Ravishankar Shastri ji.
Apologies for first round.
Why plus fast forward?
I was in another court.
Fast forward ಕೇಳಿದ್ರಾ? ಏನದು ನಾನ್ ಕರೆಕ್ಷನ್ ಆಫ್ ಕಾಸ್ಟ್ ರೇಟ್
But that will not arise because initially 34 appellants got filed through a power of attorney holder. The power of attorney holder died. But after his death, now 7 appellants have executed the wakalatnama. So I have filed the wakalatnama on those 7 appellants. And rest of the appellants, I am seeking transposing as pro forma respondents.
Now 7 appellants means which are the 7
For
appellants?
appellant number 1, appellant
You have
number,
filed application for
I have filed application for transposing.
8, 2 to 11, 15, 16 and 20. There the appellants were not filed wakalat.
Those are the appellants who have not executed the wakalat.
Then notice has to go to them.
All the respondents Marty, then we not know.
How can we do that without hearing them?
Very well.
Because now they are not represented through anybody. Here transposition. Delay. Recalling applications ಅದೆಲ್ಲ ಮುಗಿದೋಗಿದ್ದಾವೆ.
Recalling ಎಲ್ಲ ಆಗೋಗಿದೆ.
IA 3 of 23. One of restoration. ಬೇರೆ ಬರ್ದಿದ್ದಾರೆ. ಏನಿದೆ resubmission ಏನೋ ಬರ್ದಿದ್ದಾರೆ ನೋಡಿ. Transposition. Because even if you make them respondent, notice has to go.
Notice has to go.
So let the notice of this IA go to them. Issue notice of IA number 3 of 23 to
appellants 2 to 11, 15 and
appellants
16.
2 to 11, 15, 16 and 20 to 34.
20 to 30.
20 to 34. List on
12, 11. Seal number 55.
But the office objection may be overruled. The first office objection in the list.
My lord, I am for the appellant, my lord.
One ನಿಮಿಷ.
No query. Yes.
My lord, I am for the appellant. Appeal by the Reliance General Insurance Company challenging the negligence and liability. There is no negligence on the part of the private bus. It is only due to the negligence of the opposite vehicle. Police have filed a false criminal case, my lord, and awarded 37 lakh to 27,000. As per the sketch, my lord, our bus is on the extreme left side of the road.
Interim stay of impugned award till next hearing date, subject to interim stay of execution of impugned award till next hearing date, subject to appellant depositing 50% of the award amount before the tribunal within 4 weeks from the date of this order. List on
13, 11.
13 11.
Much obliged.
List number 2 for hearing on IA. Seal number 4. KG Shantaraja. PM Halaswamy.
For representation for the appellant. 2019. Admit 8 weeks time was granted and 28/6/2023. 23 on 40 then no representation for the appellant. Finally, 2 weeks time is granted. Original suit have here.
Suit, my lord, this is suit for partition. Aye.
Okay.
The only issue was, my lord, whether their wife and the children of the deceased Ravi Shankar, my lord, two brothers, property was bequeathed in favor of two brothers, my lord.
Now, they have not filed paper books for
Yes, ma'am.
more than 1 year. Last when this order was passed, 28/6/2023, and they do not appear also. Finally, 3 weeks, 3 weeks time is granted to file the paper books, dealing which appeal shall stand dismissed. Yes.
Cell number 5, T. Prakash, Donor Thai Bakun.
It's a suit for specific
Respondent.
performance. Look, there is a delay of 272 days in filing. I have also filed an
Only one
application.
respondent.
One respondent.
Yes.
Look, it's a suit for specific performance, and the suit has been dismissed on the ground that we were not having we did not show the ready to.
Readiness and willingness.
Yes, madam.
The entire suit is dismissed. Now
Yes,
refund
the
is
entire
ordered.
suit is dismissed, my lord. At least 10 lakhs, whatever we have paid, that should
Refund
have.
is also.
They have not sought for that, my lord.
No, that is the relief. That has not been given at least. She is a lady, widow lady, and she has paid the money. At least money should have been returned along with the interest.
Such other relief ಅಂತ ಕೇಳಿರ್ತಾರಲ್ಲ.
Yes, please.
Direct defendants
other-
to execute registered sale deed. In the event defendants fail to execute the sale deed, it may be executed through the court commissioner.
Yes.
Permanent injunction. Grant such other reliefs ಅಂತ ಇದೆ ಅಲ್ಲ ಅದ್ರಲ್ಲಿ. So you want to hold the money as well as.
At least
No, my
they
lord.
should
that,
return our, at least they should return our money along with interest, my lord. Now, my lord,
That's what is delay.
now they are trying to
Please, sir.
alienate the property, my lord. I have sought for an
Right.
interim order of injunction.
We are not alienating the property, my lord.
Let them give an.
72 days. Condone ಮಾಡ್ಬೋದಾ?
Maybe cut down because no valid reason also, my lord, but only the reason is that the advocate
Woman age 53
not communicated the order, that's it.
ಅಂತ ಹೇಳಿದಾರಲ್ಲ
It
ಈಗ.
is a widow, my lord.
He is very much present until the judgment is pronounced, my lord, before the court.
She is a helpless lady, my lord. She lost her husband also during the process.
In the last date of hearing, she was very much present in the court. That is reflected in the order sheet also, my lord.
ಜಡ್ಜ್ಮೆಂಟ್ ಏನಾಯ್ತು?
Judgment is
Judgment ಆಯ್ತಾ ಅನ್ನೋದು ಗೊತ್ತಾಗ್ಬೇಕಲ್ಲ ಅವ್ರಿಗೆ. Partition 1/2023 had accepting the reasons assigned to explain the delay of 72 days in filing the appeal is. ಇಬ್ಬರಿದಾರಲ್ವಾ? There are, who is the second one? Son.
Hello, son, son.
So now she is not the sole plaintiff.
Yes, please.
She is not the sole plaintiff. Son is also there.
But son is there, my lord, but he
But
was,
you have showed his name in the application.
she was taking care of the case, my lord. That is the reason.
He is also one of the plaintiff in before trial court, my lord, second plaintiff.
ಇಲ್ಲಿ whether is appellant or not.
Appellant, she is the appellant.
She ಅಲ್ಲ, he son.
Son was also the plaintiff before the lower court.
Delay of 75 days in filing the appeal is condoned in the interest of justice. Admit all parties here. Paper book shall be filed within how many days? 4 weeks?
4 weeks, ma'am.
4 weeks. You undertake that you are not going to
Yes,
alienate?
No, I will undertake, my lord.
Response counsel undertakes that she is also 70 years old.
And also 17.
Or
Yes,
anybody claiming through her, not
Yes.
only the respondent.
please.
Yes.
Respondent or anybody claiming through her, do not alienate the suit property in any manner till further orders. The
Yes.
submission is recorded and IA 2023 is disposed of accordingly.
Yes.
List after 4 weeks, already
Please.
filed the papers.
List number 1
Great.
for admission, cell number 56.
With the file.
Rajat H.
I am for the respondent, my lord. I am for the respondent.
Yes, you are very much audible to me. Serial number is two? Yes. Non-filing of sir, counsel for R2. Copy is served on you?
Recently I received, my lord.
Alert counsel for respondent to submit that he has received the copies. office obstruction stood compliant. Yes, what is the matter?
Case of a death, my lord.
You are on quantum. Mean what? What is the error in the quantum? Notional income ತಗೊಂಡಿದ್ದು
Notional income to be taken. That's
Personal income ಕಡಿಮೆ ಇದೆ.
ಕಡಿಮೆ ತಗೊಂಡಿದ್ದಾರಾ?
ಕಡಿಮೆ.
ಲೋಕ ಅದಾಲತ್ತಲ್ಲಿ ಆಗ್ಬೋದಾ?
ಲೋಕ ಅದಾಲತ್.
ಆಗ್ಲಿಲ್ಲ.
The appellant has signed, my lord, but the insurance company has not.
ಇಲ್ಲ, in consortium, everything is now settled. How much is taken by the?
HCR may come.
ಎಷ್ಟು ತಗೊಂಡ್ರೆ? ಯಾವ year the accident ಇದು?
2019, madam.
2019. How much should have been taken?
14,000, my lord. 14,000.
ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ ಲೋಕ ಅದಾಲತ್ತಲ್ಲಿ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಅವರು.
ಅಲ್ಲ 14,000 ತಗೊಂಡು ನಾವು ಮಾಡ್ಬೋದು.
ಮತ್ತೀಗ ಆಗ್ಲೇ ಹೋಗಿತ್ತು ಲೋಕ ಅದಾಲತ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ. ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿ ಅವ್ರು ಸೈನ್ ಮಾಡ್ಲಿಲ್ವಂತೆ ಜಾಯಿಂಟ್ ಮೆಮೋನ. ಹೋಗ್ಲಿ ಬಿಡಿ, ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡ್ತಾರೆ, ಇನ್ನೊಂದಿಷ್ಟು ವರ್ಷ ಪೆಂಡಿಂಗ್ ಇದ್ರೆ ಆಯ್ತು.
ಅಲ್ಲ ತಾವು ಮಾಡೋದಾರು ಮಾಡಿ, ತಾವು ಮಾಡ್ಬಿಡ್ಬೇಕು.
Number 57, MB Chandrachuda, GS Prasanna Kumar for R1.
Senior held up in another court, your kindly after vacation.
ಏನ್ ಪೋರ್ಟಲ್ ಮೂಡ್ ಅಂತ ಇದೆ?
Respondent ಮಾಡಿದ್ರೆ ಸರ್ ನಾವಲ್ಲ.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಮೂವ್ ಮಾಡಿದಾರ? ಯಾರು ಮೂವ್ ಮಾಡಿದ್ದಾರೆ? ಪ್ರಸನ್ನ ಕುಮಾರ್, GS ಪ್ರಸನ್ನ ಕುಮಾರ್. Memo counsel correspondent on those who the matter is absent as requested by appellant's counsel, list after 2 weeks.
My lord, kindly extend interim order earlier.
Sir?
Yes, sir. Also.
That's right. Emergency notice ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಎಲ್ಲಿದೆ interim order?
Stay.
Till next week of hearing. Drawing up of the final. Interim order is extended till next week.
Number 58, Radha BP, K Prasanna Shetty for R1 to R4.
Appearing respondent 1 to 4, my lords. My lords, I have filed a memo, my lords, to remand the TCR to TCR.
What of the TCRs?
Yes, my lords. As per interim order, my lords, they have deposited the amount.
Number 3424.
Yes, my lords.
CH. Release order is passed?
Yes, my lords, it is passed.
Release order probably ಈ appeal ಅಲ್ಲಿ ಮಾಡಬೇಕಲ್ಲ, 3028 ಅಲ್ಲಿ.
3424
ಹೌದು, ಇದ್ರಲ್ಲಿ ಮಾಡಿ 3028.
Yes, my lords, I have filed a memo in 3028, my lords.
ನೀವು ಅದ್ರಲ್ಲಿ ಮಾಡಿಲ್ಲ, 3424 ನಲ್ಲಿ ಮಾಡಿದಿರಿ ಅಂತ ಇದೆ ಮೆಮೊ. ಅಲ್ಲ
Moved in 3.
ಇಲ್ಲ, ಕರೆಕ್ಟ್.
ಅಲ್ಲ ಮೂವ್ ಮಾಡಿಲ್ಲ, ಬಟ್ ಮೆಮೊ ಫೈಲ್, my lords.
All.
Yes, my lords, in 3028 insurance appeal, my lords, to remand the TCR.
When the release order was passed, claimants are permitted to withdraw it. As per the order.
That was 6422, my lords.
Claimants are permitted to withdraw.
6422, my lords.
22,
Yes, ma'am.
withdraw rupees 17 lakhs deposited to the tribunal. Therefore, return the TCRs to the tribunal to facilitate release of the amount. Soon after the purpose is over, the TCR shall be resubmitted.
Yes.
List of the resubmission of the records. Memo is disposed of accordingly.
Yes. Welcome.
Number 59, Tyagaraja B, PG Vijay Kumar Swami.
Yes. Yes, what is it?
Your lordship, notice has been sent to your lordship, even after KV.
Somebody has appeared, Vijay Kumar Swami.
Your lord.
KV
Regularly was not appeared, that's why last occasion has taken the steps.
Again notice was issued.
Issued your lord.
ಏನಂತ ಬಂದಿದೆ? Notice issued to respondent, postal track report, item delivered.
Yes, ma'am.
As per the postal endorsement track report, postal track report, as per the postal track report, notice sent to the respondent, and the second time also is delivered, but still nobody represents him. Okay. Yes, ಏನಿದು admit ಆಗ್ಬೇಕಿತ್ತು. What is restitution of
Second matter has to be admitted. First matter as admitted, your lordship.
Direct. Take back the plaintiff and read marital. ಎರಡು ಬೇರೆ ಬೇರೆ ಹಾಕಿದ್ರ ಅದರ
ಬೇರೆ ಬೇರೆ order.
ಸಪರೇಟ್ಲಿ ಅದು ಕೂಡ ಇನ್ನೊಂದು
6-3.
21 of 2018 ಸೇಮ್ ಕೋರ್ಟ್ ದಾವಣಗೆರೆ.
One. Separate orders has been passed, your lordship.
Why two before two different courts now?
Your lordship, husband has filed the divorce petition on the
Family court Davangere.
Davangere.
And his admit are
That has registered for conjugal, wife has filed your.
4th March 2022 and another one is 23rd August 2021.
Your lordship. Divorce petition has filed in the year 2015, your lordship. Conjugal rights has filed in the year 2018 before the Davangere family court. Your lordship. Separate courts has been, both are separate.
Which matter is admitted of same?
Second.
The connected matter.
6-1.
Admit. ಇದ್ರದ್ದು TCRs ಬರ್ಬೇಕಾ? ಇದ್ರಲ್ಲಿ 3230 ಬಂದಿದೆ.
ಅಲ್ಲ 326123
ಅಲ್ಲ ಅದು ಎರಡು ಬೇರೆ ಬೇರೆ ರೆಕಾರ್ಡ್ಸ್ ಅಂದ್ರೆ ಕಾಲ್ ಫಾರ್ TCRs. List after the recess.
Kindly extend interim order, your lordship. MFA number 3230.
Till further orders.
So number 60, Subbareddy KN, Rashmi George.
Lords, I had filed wakalat for our 6, 11 and 13. In spite of 6, 11 and 13. And actually in spite of my several communications, they are not responding, my lords. Hence I have issued a notice of retirement to their address. And I want to file a memo of retirement with the postal acknowledgement I have brought it.
You should
Kindly it may
file
be
in the
accepted.
registry. You file it in the registry.
Yes, my lords, because acknowledgement is not come back, that is the reason. I
Then
did
after
not-
receiving, you can file it.
Yes, my lords, because they are not at all communicating and so hence it's unable for
It
me.
has been dismissed, Lord.
Yours,
7-11.
order 7 rule. No. On what ground?
Lord, saying that this is land which attracts a PTCL Act, agreement of sale and specific performance is not maintainable. But prayer for a relief of alternative remedy, the court can always grant for return of money. And there are certain judgments which say it is maintainable.
It is maintainable. That now that act is retrospective effect that is stayed, no, no.
That is state.
Stay ಆಗಿದೆ. ಇದು ಯಾವಾಗ agreement ಆಗಿದೆ ಯಾವಾಗ?
So ಇಲ್ಲ, ಇದ್ರಲ್ಲಿ, after the act has come into force,
After the act came into force. ಯಾವ year?
2007 agreement.
Now that amendment with retrospective effect was brought just recently.
Yes,
no?
yes, holding that delay should not be a ground.
Shall apply even the earlier alienations also.
Yes,
That was somewhere in the.
it is before division bench.
Correct, ಅಲ್ಲಿ ಏನದು stay ಆಗಿದೆಯಾ ಆಗಿಲ್ವಾ?
ಆಗ್ಲಿಲ್ಲ,
Stay ಆಗಿದೆ ಅಂತ ಕಾಣಿಸುತ್ತೆ. Any of you are aware?
stay ಆಗಿಲ್ಲ.
ಆಗಿಲ್ವಾ?
Stay ಆಗಿಲ್ಲ.
Stay ಆಗಿದೆ. But anyway, that is under challenge.
That is under challenge.
You were told it was heard on. ಗೊತ್ತಿಲ್ವಾ
Yes,
ನಿಮ್ಗೆ?
ಇಲ್ಲ, it is pending before the division.
ಪೆಂಡಿಂಗ್ ಇದೆ, ಹಿಯರಿಂಗ್ ನಡೀತಾ ಇದೆ ಅಂತ ಹೇಳಿದ್ರು ಅವಾಗ ಯಾರೋ.
ಇಲ್ಲ, ನಡೀತಾ ಇದ್ದಂಗಿಲ್ಲ.
ಸ್ಪೆಷಲ್ ಬೆಂಚ್ ಅಂತ ಕಾಣಿಸ್ತು. Why two interim TI applications?
One to not to alienate the property,
One to not to alienate,
Yes.
another?
another is not to change the nature of land.
Nature of suits.
What is the property?
But property is,
55 bar 4.
it is 4 acres of land in
No, is it agriculture land?
agriculture.
Bangalore North. It is, today.
4 acres situated at Bellali village, Yelahanka.
All the respondents were the executants of the.
Yes,
document
yes, yes.
In 2007. Suit
Yes.
was filed in 2022. Why? 5 ವರ್ಷ ಆಗಿದೆ.
2019 suit.
ಇಲ್ಲ, OS 1269 of 2022 ಅಂತ ಇದೆ.
ಇಲ್ಲ, renumber
ಈ
ಆಗಿರ್ಬೇಕು.
ನಂಬರ್ ಆಗಿದೆಯಾ?
Renumber ಆಗಿದೆ.
ಈ ನಂಬರ್.
19 suit.
Date of filing IA that is. Got it, call for. Records are required. Or you are going to file, only what we have to see
Okay,
is.
short point.
You can file the paper book of plain written statement, IA objection, that's all.
At least let there be,
Records are required.
not necessary. We can decide. At least let there be status quo with respect to the land.
All. Status quo better, if alienation we can pass.
Yes.
If they do any changes, it is that their
Now
peril,
it
no?
appears that they want to change the nature of land.
Probably it is not being cultivated.
Cultivation ಇಲ್ಲ,
ಇರೋದಿಲ್ಲ.
sites ಮಾಡಿ ಮಾರೋದಕ್ಕೆ they are planning.
Not to alienate ಅಂದ್ರೆ ಅದಾಗುತ್ತಲ್ಲ.
ಅಂದ್ರೆ sites ಮಾಡ್ಬಿಡ್ತಾರೆ, they'll change the nature. This status quo.
The appellant's counsel shall submit the paperbooks containing pleadings. ಎಷ್ಟದ IA number?
IA number,
IA number 2.
yes.
Counter file to IA number 2. And the paperbook ಅಷ್ಟು ಸಾಕು. Okay. The response or anybody claiming through them are hereby restrained from alienating the suit schedule property or changing the suit schedule property till further orders. I have
Please.
been talking to the credit
Please.
report accordingly.
Obliged.
After 2 weeks.
Please.
Cell number 61, Aditya Narayan, Vasant Madhava, yes.
I appear for the appellant, Your Lordship. Lordship, I seek a adjournment in this matter. Senior is Ailwell. I appear for
This side also senior is appearing. Yaar appear
He was present before today, Your Lordship, but he was unwell and personal inconvenience. He had to leave immediately, Your Lordship.
Yes, sir.
Maybe I have it on 16th. Your Lordship.
A1 for stay. Who has moved it?
I had moved it. Your Lordship.
ನೀವೇ move ಮಾಡಿದ್ದೀರಾ? As requested. Who is the senior appearing here?
Aditya Narayan.
As requested by the appellant's counsel, list all. You want any particular date?
We had after 17, any day after 17.
2210.
22.
Please.
Cell number 62, Sunil Rao, George Joseph, Sanjana Rao.
I represent the appellant in this.
Yes.
The order under challenge, the order which has been passed by the trial judge on IA number 3, which was an application filed
Yeah,
with
order 7 to 11.
defendant number 5 and 6, under 7 rule 11A, B and D.
What was the ground?
The ground is no property is available and no cause of action. And there were 2 properties and several defendants. Only on the application of defendant number 5 and 6, the plaint has been rejected.
No,
Entire plaint has been
11A cause of action, no? B?
B
is barred by law.
Barred by law.
barred by law.
B?
B, my lord, I don't know.
Undervaluation.
Payment of insufficient.
Insufficient court fee also. That is also one of the grounds, not.
Undervaluation.
These were the grounds.
No determination. It is a suit for partition.
CPC.
Court fee has been paid 200 rupees.
Any alienations were challenged?
Yes, yes.
Where is the copy of the plaint or?
There is no alienation. We have not sold our property. We have executed a power of attorney in their favor.
Prayer in the plaint. Plaint is at page number?
Page, Lordship will see page, prayer at 87, my lord.
Power of attorney.
Prayer,
In order to get the land reconveyed from the BDA, that is the specific clause contained in the power of attorney, they say that the land has been allotted to them.
Right. No, plaint, prayer is at page number
Lordship, can you
89.
say?
Page 89?
89 is the prayer, my lord.
87.
Prayer.
Plain starts
I
at
have-
page
I have
73.
extracted.
Declare
I have
that plaintiff
extracted.
properties are the joint family properties of plaintiff and defense 1 to 3. Defense 1 to 3. Be
It
directed
commences
to
at page number
Prayer
87.
3, my lord. Prayer 3.
declare that reconveyance agreement dated 3/9/82 executed by defendant number 4 in favor of the president of society so and so was on the basis of power of attorney dated 4/10/18, which was executed by so and so,
Yes.
which would initially inure to the benefit of Muniswamappa and Shri Annayappa on their death, which would inure to the benefit of plaintiff and defense 1 to 3. Then to declare that, you have sought so many declarations, declare that same deed dated 19/11/2007, one executed by defendant number 4 in favor of sister, so and so. And reconveyance agreement dated 3/9/82. Was it your case that the case was barred by time also?
Barred by time also, and not this land acquired by the government. BDA acquired the land. BDA thereafter executed a conveyance. Thereafter a sale deed. All of that was executed at the time when those persons had executed the so-called GPA.
You
And
see, on plain reading of the plaint itself, it should reflect that
On the
there is no
plain
cause of
reading.
action or plaint is barred by time.
correct. It's on the face of it, bro. 1978 is the acquisition. 1982,
What is that injunction they have sought now?
or injunction was refused by the trial court.
The two injunction orders that I have sought is
Income
not to
and
alienate,
Creating,
The trial
not
court.
to alter the nature of the
it
property.
was submitted that you had not, you didn't have the benefit of injunction before the trial court? He's
Never.
submitting?
Your Lordship, may
Never
kindly
had
say, one second.
Putting up
We
the
have made an
purpose.
application, interim
All right,
application.
we can submit this.
We have made an interim application that has been rejected. When we have filed an appeal before this honorable court, at that point, when the appeal was pending, the plaint was ordered to be rejected. We have withdrawn it with liberty to challenge the said order also by way of filing the appeal.
Yes.
The only thing, the crucial aspect which has to be gone into in this matter is whether the sale deed which has been executed in favor of defendant number 5 is by the BDA is a sale in their favor or a reallotment, that is reconvey of the property as contained under section 38C2. Your Lordship, again, my land has been acquired and after acquisition, they have reconveyed it. They have not collected any value of the land except developmental charges. If it is so, it covers under section.
Was it under a registered document or what is that? Reconveyance.
Your Lordship,
Registered.
the thing is,
Allotment here.
reconvey,
Lordship, it is an allotment.
and sale are two different words employed in the BDA.
So even reconveyance also, once it is acquired, it becomes their property.
Ah.
To transfer interest, there should be
It is reconveyed,
reconveyance under a registered document or what is that? To
Yes.
registered document.
the plaintiff.
It will.
No, not to the plaintiff. It is to a church.
Respondent number 5 here.
to a
He represented before the BDA on the basis of the power of attorney that we have given. Under the power of attorney. Under the power of attorney, we have requested him to reconvey the property in our favor.
What is the position of the status of the property?
If there's a construction going on.
They are putting up construction and they are selling it.
That is with a
Your Lordship,
approved
can I
layout
say-
plan, approved plan.
Yes, approved plan, developed, project is almost completed. This is nothing but, my lord, an effort at trying to stop it by someone, my lord, who does not have any right. The person was not even born at the time, my lord, when the the GPA was executed, or the persons under whom she claims were alive till 2003 and 2005. They never made any claim. Suddenly, my lord, some great granddaughter comes and files a suit saying, I'm asking for partition of the property. And on that basis, they try to stop everything.
Let him argue his side. Yes. He was yes.
The GPA which we have executed is at page number 57 of the paper compilation that we have filed on the last date of hearing. Separate paper compilation is there and we have produced it. Page number 57. That's separate is there.
Separated. Yes, we got it, yes.
Your Lordship, may kindly see page number 57. It's the only document that we have executed. Our ancestors have executed these two documents.
57.
This document. Your Lordship, may kindly see the clause which has been embedded in the power of attorney is clause number 2. To get the scheduled property, this power of attorney was executed by Annayappa, son of Rashappa, and in favor of secretary, servants of Holy Spirit, that is respondent number 5. Muniswamappa and Annayappa are the executants of the document. The power that we have conferred, the power which has been conferred on the 5th defendant could be seen at para number 2 at the bottom.
Yes.
What is this?
To get the scheduled property reconveyed in our favor from Bangalore Development Authority or from the government. This is the authority that we have given. They wanted to appropriate the property by themselves by creating a sale deed.
But you have also authorized them to construct the hostel building, board home, etc.
Yes, ma'am.
Temporarily.
And then see para 10. my lord.
This is not a
Page
power
59.
of attorney
I'm
covered
sorry,
with
sir.
interest. I have not received 1 rupee also in
In
order to attract section 202 of the Contract Act.
So, yes,
No sale deed, no agreement.
yes.
Agreement is produced, sir.
It is my contention on the bare basis of the power of attorney, they have obtained the reconveyance,
No, we produce
which will endure to our benefit. That is the plaint that we have presented before the
trial court.
Yes.
And they said that the land has been regranted to us. They have not paid the value of the land except the developmental charges of rupees 14,000.
Yes.
And there are two properties. When there are two properties and many defendants, the court cannot reject the plaint on an application which has been made by one of the defendants. Entire plaint cannot be rejected. The rejection of the plaint at the outset is incorrect.
Yes.
And what has been the written way has been explained.
What was the date of this agreement of power of attorney? 4/10/82.
82.
Date of power of attorney is
So far this
1982.
power of attorney is not revoked so far.
Lordship, kindly see, it was under the process. Our they are the persons who had given the power of attorney passed away, and we have no knowledge about it.
And when they passed away?
2003 and 2005.
3 and 5.
And there is no booster in order to attract section 110 of the Limitation Act.
Yes.
The conveyance is not, we are not attacking the conveyance which has been made in favor of the defendant number 5. We have made a statement that it would inure to our benefit because you are a power of attorney holder.
Yes.
There is no challenge with regard to the document which has been executed by the BDA in their favor.
Yes. Yes, what is it?
Lord,
Yes, sir.
I'll give you lots of few facts. This is an acquisition in the year 1978.
1978?
1978 acquisition.
Yes.
Preliminary notification was issued. Then not final notification was issued. After the final notification was issued, possession of the property was also taken over by the BDA. No one challenged the acquisition. Then, my lord, we, not us, but respondents 5 and 6, who, my lord, is the church, a charitable society, made a request to BDA to allot the land to them of 2 acres for the purpose of building a hostel for girls.
Allotment or reconveyance?
It's allotment. It's allotment. And it is, I'll show you lots of how it is allotment, because there are documents to say. One survey number 52, my lord, was granted first by the BDA upon orders of the government. One survey number 52 was to be allotted, my lord, to this respondent 5 and 6. Subsequently, at a request made, government said, instead of survey number 52, give item number 2 of the scheduled property to them. I'll show you lots of those documents. Can I request, my lord, to kind
It's a suit also, 2 properties.
item number 1 and item number 2. Court has found, my lord, that item number 1 is a
21 into 50 feet is 1. Okay?
Yes.
The other one is 2 acres, 6 kunta.
We are item number.
Which 6 kunta?
Yes.
Only 6 kunta out of 2 acres, 6 kuntas.
No.
The other properties.
Land.
Item number, yes, my lord.
Land sharing survey number so and so, 2 acres, 6
Plain
kuntas, out of which 6
plain.
kuntas is the Kharab land. Okay.
Lordship may see the plain, my lord. There are 2 parts.
Yes.
Give me the plain. 73, my lord. Lordship may see 92. Item number 1, my lord, court has concluded, is a fictitious property. It doesn't exist.
No, but all these things, whether they can be
No, I'll show you, lordship, that on the face of it, my lord, the suit, in my respectful submission, nothing,
plaint can be rejected based on the allegations made.
the plaint itself. Lordship may see the plain. The my lord, completely fictitious suit. The suit itself, my lord, on the face of it, my lord, in my respectful submission, can't be accepted. Lordship may kindly see, and the prayers. My lord, the prayer is the sale deed executed by BDA in favor of one party inures to the benefit of the plaintiff. My lord, when BDA executes a sale deed in favor of one party, in my humble submission, either you should ask for cancellation of the sale deed and then a direct conveyance from BDA to them. I at least, my lord, with my limited knowledge, I've never heard of a scenario where the sale deed stands in someone else's name and it will actually inure to the benefit of someone else. There is actually an agreement to sell, which they've not placed before your lordships. There's an agreement to sell entered into respond number 5, respond number 6, and them. And they have received consideration under it. At that point in time, it appears, my lord, that to avoid any dispute,
It's not in the plaint.
they've not produced it.
We cannot see that.
No, I'm not saying that. I'm saying, no, when the injunction is ultimately refused, if your lordships are not ultimately going to decide this question, because now they are not interested in so far as the rejection of the plaintiff issue. They are more interested in trying to secure the property or to do something with respect to the property. The court, my lord, while considering the application for injunction, has made very strong findings against them. Can I pass on that?
You mean to say that this matter can be heard, injunction shall be now refused?
Injunction should be refused. My lordship may hear this, but in so far as injunction is concerned, I want to show your lordship, my lord, the findings that have come. May I just pass on that order, my lord? Rejecting the injunction request.
No, it was submitted that they filed an appeal and withdrew that with liberty to argue.
Yes, yes.
Where is that order?
That is in the MFA.
No, order copy, MFA order copy.
MFA, I don't have it right now, but I don't
You
dispute
have
that.
it order copy, MFA order copy?
MFA order copy, yes, sir.
But without producing that, if you make just a submission, how can you use?
We are not
fact,
disputing.
they have
We are not
admitted.
Not admitted, but I'm saying, please see the findings that have been made.
We have to see, even if they do not dispute it.
Your
What
lordship
was
may-
the liberty given to you?
Your lordship may kindly see, we have preferred an appeal against this order.
My lord, even when the matter was pending before a single judge in the MFA,
right.
no interim order was granted. As a matter of fact, it was heard on 2 or 3 occasions, by which time the plain got rejected, my lord, in which plain got rejected. Now, my lord, it's almost been 3 months since the plaint itself got rejected. Read to the order.
The MFA has, what had happened is,
15/6/24, my lord, is the order. Now, my lord, 3.5 months have gone by since this order was passed. And the injunction, my lord, was refused on 12th of March 2024. 12th of March 2024 is the refusal of injunction. Suit, my lord, was filed in 2023. July, I'm sorry.
How do you sustain this 82 days sale deed? You seek declaration of 82 document and
the one-
2007
in a suit
documents
for
in
partition, my lord.
2024.
In a suit for partition, unless the defense of Worcester has been taken by the other side, then only they will get a right. We have thrown you out. You have no right in respect of the property. There is no such defense of Worcester in the written statement
Right.
filed by them.
This
And
order 7 rule 11 stage.
irrespective of the length of time in filing the.
But we are not
suit.
finding a case to grant any interim order. This
Lordship-
matter needs, it seems it needs to be heard in detail.
But-
Only thing, you do not alienate the property.
Yes,
till
The
next
property is already done, lord. I'll tell you, lordships.
Alienation is already done.
Yes, yes.
The entire property is alienated.
No, my lord, there's a big construction that has come up.
We are not saying about construction. We say construction shall be subject to.
No, my lord, no, in the sense, my lord, these are all residential apartments which have come up. And with respect to many persons' agreements to sell, and money has been collected from them on the base of a sale of a
We with our experience little, we see that whenever these kind of joint development agreements are there, such kinds of claims arise, but now it seems we have to hear you in detail.
No, my lord, then, my lord, that puts us in an extremely difficult situation, because if your lordships, my lord, are going to interdict us by saying, don't alienate the property and don't do.
Next hearing date.
My lord, now, one interim order, my lord, ultimately, I'll tell you, lordships, what will happen. Insofar as this case is concerned, your lordship may even send it back then, because let it go back, my lord, let them argue their application. If their argument is,
No, why should send it back? If there is no merit, merit is there, we'll allow the appeal. Otherwise, we'll.
yes, my lord, no, my respectful submission is,
See, we have
his
to
position.
read the plain in detail and plain documents we have to read.
Yes.
What were produced along with the plain, what documents? So.
They produced these documents. They produced, my lord, the acquisition. My lord, please see this.
Let me take some.
Land is
time.
acquired.
Right, now both of you argue on this matter, how much time you require?
My lord, let me submit.
If you want the disposal at this admission stage only, how much time you may?
My lord, I need 20 minutes, my lord, at the most, nothing more than that. Now,
Others?
My lord, one second. I appear for R5. R5 have applied for allotment in BDA. And BDA has allotted
Let the property be kept intact.
88,000.
no, no.
Lordship,
Your lordship may kindly,
You are mad, you have argued, let them
Yes, madam.
argue.
Yes.
Yes.
BDA has allotted 88,280 square feet of land. What they have arguing is
How much? 80,000?
8,178 square meter, which is equivalent to 88,028 square meter.
To this church,
Yes,
allotted?
the society, fifth.
I asked you whether it was a reconveyance or allotment.
Allotment.
In pursuance of the resolution passed by BDA, it was allotted. It is
But what
produced.
efforts you did because power of attorney was given to you to take reconveyance? What efforts you did?
That is only one clauses where in document there are 13 clauses and that is only one clause. Your Lordship may kindly see clause number 10,
The allotment was in which year?
80,
Allotment was
1980.
1980.
80. BDA has allotted, your Lordship may kindly see the nature of the property. What the,
1982 power of attorney is executed. How the allotment could be in 1980?
Question to the acquisition, Lord. Once land was acquired and acquisition was completed,
Acquisition was for what purpose?
acquisition was for PTM layout.
BTM layout.
BTM layout. For
And
formation.
this property is in the midst of BTM layout. And the nature of the land acquired is 88,028 square feet. Their prayer in the partition suit is 2 acres, 6 kundas. So it does not tally.
2 acres?
2 acres, 6 kundas. That is the prayer in their partition. But the BDA has
Same survey number?
same survey number. The BDA has allotted us 88,028 square feet. So the nature of the property itself is different.
You are saying that property is not identifiable.
Not identifiable. It is in the midst of,
This is all, see, all this has to be on merits. Evidence shall be
Yes.
recorded for that.
yes,
Now, the plaintiff is rejected under Order 7, Rule 11A. The plaintiff shall not disclose the
Yes.
cause of action.
yes.
The other one is
But-
barred by law. What is the bar of law?
But the government has allotted me a property wherein I am exercising my rightful
You
ownership.
filed application, respondent 5 file
Yes,
application.
I filed the application for rejection.
So you were not the applicant.
I'm not the applicant. I'm not the applicant. I'm the developer who's not claiming under them.
You are the joint
I'm the
developer.
joint development developer who's
And
claiming
you're-
through and under them.
And your,
And not on that basis, not several sale deeds, I'm sorry, several agreements to sell have been
So what
executed.
was that bar of law you pleaded?
I'm sorry,
What was that bar of law you pleaded?
the bar, my lord, was.
See, there is
Limitation.
under 3 heads. It was sought under 3 heads.
there is no
Please,
cause of action.
cause of action.
There is no cause of
The
action.
E is for bar of law.
Limitation,
Bar
limitation.
of law, my lord, is land is acquired.
B
and
is
they-
under
therefore, you
valuation.
cannot make a claim with respect to a land which is acquired.
That bar of law,
Now Supreme Court has held, when there's acquisition of property, a suit not to challenge an acquisition can't arise.
they are not challenging.
But
They are
what-
not challenging the.
I know that.
Not
But
challenging.
what they are saying is that the sale deed executed by BDA in favor of respondent 5 and 6 inures to their benefit. That cannot can't be. You must either ask for cancellation of that sale deed and ask for BDA to execute the sale deed in their favor. It can't be a scenario where you say a sale deed executed in 2007 in favor of someone else actually inures to their benefit.
When the sale deed was executed?
2007.
But you, just now you said 1980. allotted
That's
in
what I'm
1980.
saying. It's a reconveyance agreement.
Agreement.
It's called a reconveyance
If
agreement.
it is a reconveyance, then it should go to them, Alva.
My lord, that's why I said headings, my lord, can't, your lordship will have to look at the document to see what it says.
Show us the document.
Yes,
where
lordship
it
may look
is.
at the document.
Page-
Please see, my lord, page 9, page 60, is it an answer? Is ours?
If at all we have to look into the documents produced by the defendants, then it is
Not
not a case
defendant,
for.
produced by them,
Page
produced
number?
by the plaintiff.
Page number?
Which page?
Are you aware which is that reconveyance deed executed by the
Yes,
BDA?
I don't know if they have produced it,
Yes, they have produced it. Page number
Page-
66, Your Honor.
page 92 or 66, my lord, I'm not.
66, 66 2.
It is agreement of reconveyance,
Yeah,
right?
that is the one.
The reconveyance.
It's called an agreement of
This
reconveyance
party has applied for reconveyance of.
of the lands in the scheduled area for residential girls hostel purposes. And whereas second parties agree to reconvey the first party to an extent of land in 2 acres and 7.
Where is the question of reconveyance? If
That-
they want to allot, they should allot.
No, I'll show you lordship the allotment letter now.
Here on towards the second part of the second paragraph. is-
Reconveyance question arises if they were owner of the property.
Absolutely.
No, Your Honor,
Correct. Now, my lord, please see,
authority resolution number 513 dated 15/4/1982. In pursuance of this resolution, this allotment has happened. In that resolution,
That resolution?
may I pass this on? I have it.
Is it there? I have produced if you.
I find it.
62, page number 62. The paper comparison.
62. Our prevalence for the construction of residential housing.
62 year. It's an allotment.
It is only a reconvey.
No, it's a lot.
It was resolved to allot 2 acres of land.
But they could have said it's allotment only, then why is it reconveyance?
At that point in time, Lord, now a document is executed by the BDA.
See, this, whether, this acquisition proceedings was concluded.
Yes, yes. It came to BDA, land became the property of the BDA.
Where is that order?
That they have produced. They have produced the final notification, Lord, is that page number
Preliminary and final declaration
42.
was issued.
42.
One second. Preliminary and final declaration was issued by the BDA.
Hmm.
Taking note-
Compensation was paid to you?
Yes.
Compensation was paid to them?
No,
Yes.
The material shows where the compensation was
Ashma
paid.
kindly see, even if the
But they're
BDA
not-
wants to reconvey.
As far as they-
They don't have a case at all, that they have not received
Where is
compensation.
that compensation paid to them? If compensation was paid to them, of course, even if it is not stated, they are,
Your,
cannot claim it.
your lordship may kindly take page number 8, here,
8 of
8 of the
compilation or
compilation.
page number 8.
This document is produced by
Page number 68 is clear with regard to it.
8 Your Honor. BDS name has come in RTC. BDS name has come in RTC.
If it comes in the RTC, that is not sufficient. You should show that they were paid compensation.
They should show that they have
Not the
not
case,
received.
Lord. It's not
But
the case, they've
with-
not taken
without
copy.
bargaining, page number 68,
16,
page number 68, clause number 2. Reconveyance deed.
68. huh?
Court has, the authority says that you are not entitled for compensation. Page number 68, madam,
Just a minute.
clause number 2,
Even the compilation is so.
paper compilation, reconveyance agreement.
Yes, sir.
No compensation.
The first party is not entitled to any compensation.
Yes.
Who is the first party here?
First party, my lord, is the sister Elisian, President and Regional Superior. of the
On my
Society of
behalf, they
Service.
have represented.
First
On my
party.
behalf, they have represented.
Respondent
as the
number
format
5.
on the old.
Respondent number 5,
No compensation has been paid.
Chief
compensation is
President
payable
and
to-
Regional Superior of Society.
yes, respondent number 5. No compensation is payable to respondent number 5.
Fine.
That is what is mentioned.
Then it does, then this land acquisition is not completed if that is the case.
No, Your Honor.
Unless the compensation is paid to the owner of the property, how
Lord,
it gets.
Under the Land Acquisition Act, my lord, possession is taken under section 16 only after compensation is paid.
Show us where some award will be passed. some
Award is
other-
there. Lord, now, Lord, in my humble,
Where is that?
if
award?
that is the question, Lord, then the question of acquisition should be before your lordship.
If all these
Go and
things have
challenge the
to be
acquisition.
investigated, then it doesn't become under order 7 rule 11.
Plaintiff has no
If
case at
something
all.
has to be investigated after, examining the records, order 7 rule 11 does not apply.
Your lordship may set it aside and send it back.
Yes, send it back, not for consideration of this application.
No. Set it aside and send back, the court consider the matter on merits.
He is, yes, what is a senior counsel is agreeable that it can be,
Till disposal of this one.
that you can go and file an application, not here. He is agreeable for remanding the
problem
matter.
My problem is, the applications which we have filed has been dismissed. And we have taken up in the forum of MFA. When the MFA was pending before this honorable court, that is before the learned single judge of this honorable court, this impugned order has been passed.
Correct, how can
One
he,
second, madam.
after allowing the appeal, how can
I
he
may be
pass it?
permitted
They have to
to,
go before the trial court only.
I may be permitted to re-agitate on IA number 1 and 2, which I have filed.
Yeah.
It's
If they
rejected.
want to file the.
No, my lord.
Otherwise,
Can oppose that.
No, it has been rejected on merits. If the matter
So
goes
both of
back,
you are
suit
not
goes
coming
back.
to
Then
the
Ashma,
council.
get your last.
Then we'll list it after vacation.
This honorable court. can
We
take-
are not going
it
to
can
pass
take
any.
this situation into.
You have come before this court only questioning order 7 rule 11 application. Now he is saying that it can be set aside and remanded for going for the trial. Issues were also framed.
no, my lord, issue is not framed.
And in
Injunction
such an
application
event,
is argued
one second,
extensively,
in such an event.
and the
I
court
may be-
practically
I may be
says they have
permitted
committed
to-
fraud.
Maybe, but that.
I understand, Lord.
If it
Order
was
7 to
some-
11, maybe there's a case. I didn't file the application, but insofar as I'm
Your
concerned, it
Lordship,
doesn't matter.
in
go
the,
back.
in the trial court, I have taken a contention.
Yes,
In the
Sujesh,
genealogy, it is mentioned M.A. Gopala. But in the document, and
Learned Counsel, Order 7 Rule 11A, that, I mean, it clearly says that on reading of the plaint itself, it should be barred by law or barred by, it should not disclose cause of action, etc. If you have to probe into the matter, then it doesn't become Order 7 Rule 11 application. All right, sometimes this to camouflage the real intention,
Yes.
drafting that, those things are there.
illusion is there.
But
Anyway, this case will not, let it go to trial. I have no difficulty. But the manner in which it has been done, Lord, in my respectful
That
submission, is
needs
most
to-
shocking.
that's why we asked you what was the bar of law. Now you said land was acquired. You are not able to show us that compensation was paid to them.
From the plain plot, they've not produced anything, because I have to show it from the plain.
And there is no avowment paid.
What they have said,
The
plain.
plain, they've said acquisition is completed, possession was taken, everything is done. They are not in possession.
Forward
Admit
has
it.
been passed.
They admit they are not in
where they have
possession.
said- Where they have said that. the
Not even a single sentence is made
which
that they have
paragraph
not.
of the plaint?
Page 73, my lord, please see.
Yes.
Your Lordship,
Please see para 8, my lord. Para 8 at page
Brief
79.
of the court, my lord. In the
Says-
event of remanding the matter, because of the impugned order, I have withdrawn the MFA. I may
You
be
go and renew that MFA only.
He can renew it.
May be
Court
resolved
has
in my
given them
favor to renew it.
Forget us not, court itself has granted them liberty to renew it if
That's
the.
what we asked you to show
Yes,
that
That
MFA.
is sufficient, madam.
Show us the MFA order. We asked you
Yes,
to
yes,
show that order.
My lord, may see page 79, not para 8. It is submitted that defend number 4 and 7.
Final declaration to acquire.
Item number 2, the scheduled property, in case number so and so, scheduled property of so and so. Copy of notification produced herewith for kind perusal to the honorable
This
court.
is declaration.
Yes, not under, Lord, your lordships know that under the BDA Act, unlike the Land Acquisition Act, land vests with the government upon issuance of the final notification. KIDP Act, BDA Act provides that land vests with the government upon final notification being issued. Payment of compensation is a much later event. Your lordships know, my lord, in Nagbhushan's case, Supreme Court said that when land vests with the government, acquisition so far as the land is complete. Possession and payment of compensation are not relevant at that point in time. Which is the same principle which was applied, my lord, in the case of BDA by the Supreme Court and said, which is why they said that the provisions of section 24(2) of the new Land Acquisition Act does not apply to BDA Act and KIDB Act. Because my lord, under the Land Acquisition Act, property vests with the government only after possession is taken. But under the BDA and KIDB Act, land vests with the government upon final declaration. And there is a specific provision for that both in the KIDB Act as well as the BDA Act.
Best in the government, whether they can, divest the owners without paying anything.
Yes, my lord, that is the law.
No, that
In
is- that
Nagbhushan's
does
case,
not
I can
seem
show you,
to be
lordships.
the law. There should be consideration paid.
Lord, in Nagbhushan's case, Supreme Court has said that land vests with the government.
What context Supreme Court had said that?
Beg your pardon, my lord?
In what context?
In the
Supreme Court had
context
said
of, my lord, the question was, when does land vest with the
being
government?
scared of, loud voices, we have kept our, this thing only
I was.
away.
I was.
Not- We are, keeping these systems under the impression that all lawyers are soft spoken. Sometimes we have to, instead of that, replace it by silencer. ನಮಗೂ ಹಾಗೆ ಆಗ್ಬಾರ್ದಂತ ದೂರ ಇಟ್ಟಿರ್ತೀವಿ ನಾವು. Yes.
No, my lord, the question in Nagbhushan's case before the Supreme Court was, can a person challenge acquisition on the ground that compensation is not paid? That was the question. Supreme Court said, in the case of KID Act, Industrial Area Development Board Act, as well as the BDA Act, the question of compensation is not which stops the acquisition process. Land vests with ಇನ್ನೂ ಆಗಿಲ್ಲ. ಬಂದಿದ್ದಾರೆ?
See, show us that order, MFA order. Now, they said it can be sent back. ನಿಮ್ಮ ಮೊಬೈಲ್ ಅಲ್ಲಿ ಹಾಕಿದ್ರೆ
I will make
ಸಿಗುತ್ತಲ್ಲ
available,
ಡೈಲಿ
madam.
ಆರ್ಡರ್.
My lord, I will make available.
Can you show us,
My lord, I will make available in the course of the day itself.
read that order? ನಿಮ್ ಮೊಬೈಲ್ ಅಲ್ಲಿ ತೆಗೆದ್ರೆ ಸಿಗುತ್ತಲ್ರಿ ಅದು?
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಚಿನ್ನಪ್ಪನವ್ರೆ?
And what was that liberty given to them
At least, Suma.
Withdrawn, withdrawn.
without any liberty?
Since it has become infectious, they are withdrawn.
Then
I don't know if,
we'll say whatever remedy is available to them, they can seek that.
Yes.
wait,
It's all just exceptions.
yes, yes.
But
MFA number 2833 of 2024 and 2830 of 2024.
This notice is not given to others also. 1935, this is serial number 62. 62. Can we set aside this order without notifying the other parties?
Because not the applicant is before my lord. So far as the applicant is concerned, applicant is before.
Applicant is only one applicant.
Applicants are there before my lord. R5 and R6 are there.
Defendant number 5 and 6.
5 and 6.
Who are defendant number 5 and 6?
They are the owners of the property.
Here, R5 and R6.
R5 Society of
Yes.
Holy Spirit and
R6
6
was-
is the Society of Servants. So
Yes,
you
one
represent
and-
both
one
of
and-
them?
Yes, yes.
Let me
Heard.
read the operative portion of the order which has been
Yes,
passed
read
by
that,
the
read.
Supreme Court. Since appeals are being disposed of in view of the subsequent order dated 15/6/2024, in case if said order is set aside or modified, it would be appropriate to reserve liberty to revive the present appeal. Hence
So
only.
liberty
the
is
above-
given,
They can
why you
revive it.
want it from us?
They can revive it.
Yes.
Heard ಅವರಿಬ್ಬರ ಹೆಸರು so and so and she so and so levels and who is for respond number 5 and 6?
5 and
I-
6.
I appear for respond number
She
5.
got Joseph for response 5 and 6. ಅವ್ರು ಯಾರಿದ್ದಾರೆ the under the impugned order, the trial court has rejected the plaint of the appellant exercising powers under order 7 to 11A, B and D as CPC. On hearing, both said some length. On hearing, both said at some length. 7 and 8.
Oh, 7
A doubt is entertained whether the. It is that they have entered, the trial court has probed all these issues and then passed the order.
Yes, considered order is passed.
The trial court, it is found that the trial court has rejected the plaint on probing into the documents produced by the parties and your documents were also.
Only the plaintiff's document. Only the plaintiff's documents. Court has not looked at the defendant's document.
Defendants have also set in claim in respect to the property.
No, I'm saying six.
That has
Or
also
simply
been.
we can say,
Or your lordship may say, because there are two properties. And the claim was with respect to only the second property. Since there are two properties, the order can be set aside and sent back.
no, on concession we can do it, or you want us to pass, give some reasons for that?
Concession.
The lordship,
Let's,
as far as the item number 1 property is
See,
considered,
the other two aspects, one is this bar of law. That has to be, that needed a probe, no?
Independently trial has.
Order 7 or 11.
Your lordship,
ಇಲ್ಲ, ಬರ್ಕೊಂಡು
as far as item number 1 property is concerned, it is already gifted by the father of M.A. Gopalappa.
ಎಲ್ಲಿ?
M.A. Gopalappa.
No, who is
Respond
the
number 1.
party?
Respond number 1. In the year 2000,
Respond number 1 was defendant? What was his rank?
defend number 1.
How he is related to this
Father.
father?
Father of the plaintiff.
Father only. Oh.
Annapa's son is M.A. Gopalappa, but I have taken a contention that only Gopalappa. So to
Oh,
to prove that, they have produced 2 documents wherein it was revealed that the item number 1 property was already gifted to.
What we are saying is otherwise, maybe that is correct. Maybe there may be some force in our submission because we keep seeing that after many generations, somebody comes and challenges. But for that, we have to hear you in detail. Till next hearing date, if you can, not about the structure, we say, otherwise we say that any alienation or any structural changes shall be subject to the result of this appeal.
Strict result
What
of-
stance you will take?
Subject to the result is, I have no difficulty. The Lord should say that.
Alienation.
Even otherwise.
Because we have to hear you in detail, because all these documents, even to consider whether it should have been rejected in this way or not, we have to go through the entire records.
Yes.
But we are finding that 1982, since 1982, they are not questioned. This reconveyance was in 1980,
Yes.
reconveyance document that you read.
From that time onwards, we were in possession by constructing a ladies hostel and we were operating till
That
2000.
there was a power of attorney in your favor to construct the building.
No, even
By
to sell
virtue
also.
of that document, you have done it.
It was coupled with interest. That power of attorney was coupled with.
Where is there is no consideration under the.
There is
power
an
of attorney.
agreement.
There is an agreement, a registered agreement.
Agreement is not before the court.
On the,
Before the court.
on the same date.
They themselves have
Yes,
produced.
yes.
They have not produced. They have not produced. We have produced.
Once
We
if
have
you
produced.
produce the document, if you take up
And
some contention, then
Which is why I said, the Lordship may set aside the order on concession. What do you say? And send it back.
There is no agreement, there is no sale deed.
Agreement to sell.
There is a registered, there is a registered.
On the same day as the
That,
GPA.
the trial court, while rejecting the claim, has gone into the merits of the case. Merits of the case, should be the branch in submits that the matter will be settled. We'll fix a day, I mean, period also for disposal. If your apprehension is that they may drag it. Branch in senior counsel submits that the matter may be, the appeal may be allowed and the matter may be remanded to the trial court for disposal in a time-bound manner.
Yes.
Disposal in a time-bound manner. Submission is recording the submission. The appeal is allowed. The impugned order, impugned order dated the same. Impugned order dated so and so. 15/6/2024. In on I number 2, 3 I3 passed by. And I3 in OS number 65/73 of 2023. Passed by the 12th additional city civil and session judge Bangalore is hereby set aside. We'll reject the application here only then.
Yes, it's
I number
exercise to
3 in
Lordship
the
may
same
close that
is
application.
hereby rejected. The matter is, there all are served.
Yes, all are served.
Matter is remanded to the trial court for remanded to the trial court, full stop alla ಕೊಟ್ಬಿಡಿ. The trial court shall give ಏನು ಅಲ್ಲಿ ಡೇಟ್ ಯಾವತ್ತು ಫಿಕ್ಸ್ ಆಗಿ ಇಲ್ಲ ರಿಜೆಕ್ಟ್ ಆಗಿ ವಿಲ್ ಫಿಕ್ಸ್ ಅ ಡೇಟ್ ಫಾರ್ ಅಪಿಯರೆನ್ಸ್ ಟು ಅವಾಯ್ಡ್ ಫರ್ದರ್ ಡಿಲೇ ದ ಪಾರ್ಟಿ ರಿಮ್ಯಾಂಡೆಡ್ ಟು ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ಅದಾದ್ಮೇಲೆ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಶಾಲ್ ಗಿವ್ ಅಪರ್ಚುನಿಟಿ ಟು ಬೋತ್ ದ ಪಾರ್ಟೀಸ್, ರೀಸನಬಲ್ ಅಪರ್ಚುನಿಟಿ ಟು ಬೋತ್ ದ ಪಾರ್ಟೀಸ್ ಅಂಡ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ ದ ಮ್ಯಾಟರ್ ಆಸ್ ಎಕ್ಸ್ಪಿಡಿಷಿಯಸ್ಲಿ ಆಸ್ ಪಾಸಿಬಲ್. ಏನದಕ್ಕೆ ಹಾಕ್ಬೇಕಾ?
Yes, 6 months.
6 months, too many parties are there, it seems, no?
Only interested parties are there.
The plaintiff and my lord, her father of course supports her now.
Apparently. Since.
Obviously, he will support her. It's all collusive to that extent.
We'll
And then,
say
my lord,
1 year.
We are the
6 months.
6 months.
Is enough, there's nothing.
Six.
Listen to the evidence of so many,
Our evidence ಮಾಡಬೇಕು.
our evidence, and documents are so many documents.
PDA ಇನ್ನೂ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕ್ಬೇಕು
ಅದನ್ನೆಲ್ಲ ನಾವ್ ಹೇಳ್ತೀವಿ, ಅವ್ರು ಹಾಕ್ಲಿಲ್ಲ ಅಂದ್ರೆ they can proceed. We are finding
One
flaws in
year,
whatever
1 year.
they are submitting also, but order 7 rule 11, we have a doubt could be done in this way.
We are not afraid, any date may be fixed.
Any delay will affect our right to
Sir,
6 months may kindly be fixed.
Within 6 months from the date of the appearance of the parties. To avoid further delay, the parties are hereby directed to appear before the trial court on ಈಗಂತೂ ಅಲ್ಲಿ ಸಿವಿಲ್ ವೆಕೇಶನ್ ಇರುತ್ತೆ, soon after the vacation. 21/10/2024 without any further notice. 6 months ಆಮೇಲೆ ಬರ್ಬೇಕು. The trial court shall dispose of the matter. ಅದು ಹೇಳಿದಿನಲ್ಲ 6 months ಅಲ್ಲಿ ಬರ್ತದೆ. Within 6 months from the date of the appearance of the parties. The party shall, you have filed your written statement.
Yes, all pleadings.
Yeah, all filed.
Pleadings are complete. It's only for issues.
Issues, sir.
The thing is, let the trial judge let not confused or influenced with his own order which has been passed on IN number 1 and 2. That observation may be made.
ಅದನ್ನ ಏನು ಹೇಳಿಲ್ಲ. We have not said anything. We have set aside the order. We have rejected the
Can you
application.
say, he has already passed an order, he should not get influenced
Should
with his
convince
own
him.
order.
Now the order is set aside. All contentions of the
The
parties are left
MFS that
open.
we have written.
ಅದನ್ನ ಹೇಳಿದ್ರು, conflicts ಅಂತ ಅಲ್ಲ ಅವ್ರು ಒಪ್ಕೊಂಡಿರ್ಲಿಲ್ಲ, ಇವ್ರು ಒಪ್ಕೊಂಡ್ರು, ಆಯ್ತು ಕನ್ಸ್ತು. Now you, brother was saying, his submission also, concession, whether that shall be record. Your submission, hangandre we will record concession of both.
All councils of 5,
Yes.
6, 7.
We have said all contentions are left open.
Yes, please.
Cell number 63, Vinod Prasad.
Petitioner, madam. Food for specific performance.
ಅದು concession ಅಂತ ಬರ್ಕೊಳ್ಳುವಾಗ ಇಬ್ಬರದು ಬರ್ಕೊಂಡಿದೆ, council files for 5, 6 and mention up. And edit it. Yes, sir.
Food for specific performance of the property measuring 4 guntas plus 4 guntas with RCC building, cattle shed and totally fenced for a sum of rupees 21 lakhs. Market price of which is more than 60 lakhs. The appellant defendant has obtained a loan through the signature with PWC Sheshamurthy. And he repaid the amount after taking loan from this plaintiff respondent. Again, he insisted security document, which is styled agreement of sale. Now, as per the agreement, I should hand over the title deed at the time of registration, but he is having the copies. And there was no need for us to sign acknowledgement on 4/9. They say.
Appeal is by defendant number 1 and 2 both.
Pardon, my lord?
Appeal is by defendant number 1 alone.
It is defendant number 2
But-
outside and nominal party.
No,
because
defendant number 2, no, there is an issue which says that whether defendant number 2 proves that
Defendant number 2,
there was some attachment. What was that attachment in OS number 26,319 of 2011?
1 minute, my lord.
Page number 22, issue number 3.
Page number 23, issue number 3.
So your contention was that you have received rupees 10 lakhs by way of loan and you have repaid it.
But
What
common sense, my lord, is if a market price of the property is 60, more than 60 lakhs, will everybody will sell for 20 lakhs, eager amount.
Now, what evidence you reduced to show that you had paid 10 lakhs, you had repaid the 10 lakhs?
10 lakhs to Sheshamurthy.
10 lakhs to?
Sheshamurthy, not this man. Sheshamurthy earlier, PW2 obtained, gave me 6 lakhs. With interest I paid him, and for that money,
You have examined that Seshamurthy?
Sheshamurthy is no more.
Divakar HK, no, ಅವ್ರು examine ಮಾಡಿಲ್ಲ, defendant ಮಾಡಿಲ್ಲ.
Sheshamurthy is PW.
ಅವ್ರು ಮಾಡಿದ್ದಾರೆ, ಇವ್ರು ಮಾಡಿಲ್ಲ. Subject to deposit of that rupees 10 lakhs.
Subject deposit
Of that rupees 10 lakhs, whatever you say, you have received. But
within 4.
heard admit call for TCRs. Appearance counsel shall submit the paper books within 4 weeks or 6 weeks. 6 weeks.
10 lakhs within 4 weeks.
Issue notice to the respondents. Interim stay of execution of
I deposit to this court. So that
interim stay of the execution of the impugned decree, subject to appellant depositing rupees 10 lakhs before this court within 4 weeks from the date of this order. Okay.
in the meanwhile, let them not stay of the judgment.
We stayed subject to this. Okay. IA number ಎಷ್ಟದು dispose of 124. This. Date ಹೇಳಿ, ಹೌದು, the party's appearance.
1911. Cell number 64.
Manoj, appearing for the appellant, this matter, Manoj. The suit, Manoj, is for declaring that the action of the respondents is defamation and
This is also again order 7 rule.
7 to 11, Manoj. Malicious prosecution. The Honorable Trial Court, Manoj, has rejected the plaint partly, Manoj. Page 33 may be seen, 32.
33. Partly him ಮಾಡಕ್ಕೆ
Operative portion of the order allowed in part it is declared the suit filed with the plaintiff against defendant number 1 to 3 is not maintainable for one prior sanction.
Sanction of section 70 of the Karnataka Police Act and also non-compliance of 81 CPC.
Please, my lords. The
Yes.
question.
81, who is the government here?
Government, my lords, 3 police officers against whom I had filed the suit, my lords. Respond
Yeah,
number 1,
but
2, 3.
It was in their personal capacity or an official capacity?
We claim that it is in the under personal capacity and under a color of duty under the Police Act.
Pardon?
Under the color of duty.
So you said color of duty.
Color of
then,
duty. Under a color of duty performing non-official duties, my lords. Therefore, my lords, the question of law, my lords, is
Plain copy?
plain copy is also annexed, my lords. In page number 34, it starts. My lords.
Yes, 39 is the prayer.
Please, my lords.
Defendant's actions as defamation and malicious prosecution.
And I've also asked damages.
15 lakhs damages.
Crores.
15 lakhs, 15 crores. Oh,
15 crores.
we are poor in counting the money. Yes. Yes.
Therefore, my lords,
What is the defamation to you?
my lords, what they do, my lords, is initially, the respondent number 4 files a complaint before BDA Special Task Force, where the STF, they give a report stating that I am clean. They give me a clean sheet. Later, my lords, again they file an FIR before the RT Nagar police station, where it came to be caused by this honorable court.
Hmm. So, they had filed the application. Who had filed the
They,
application?
respondent number 1, 2, 3 had filed an application.
One,
Four
two,
was placed ex parte.
No, what is their official position? 1, 2 and 3? One is Assistant Police Commissioner.
One is Assistant Police Commissioner.
Respond number 2. Respond number 1.
Respondent number 1 is a police inspector.
Deputy Secretary, Cabinet Secretary.
He is in respondent number 3 is IPS manage.
If Madak Baral, they can't bifurcate like this on the list of plain present manner.
I'll-
So what is that?
Allowed in part minutes. That is the.
But, heard admit, issue notice to the respondents, list down.
11.
Grateful.
Number 65, S.K. Hegde Mulkan.
Appeal of the insurance company on the question of negligence as well as quantum. 2 vehicles are involved in the accident. The charge sheet was filed against both the drivers. The tribunal comes to a conclusion, in respect of our vehicle, 65% negligence is to be attributed, and other vehicle, 35%.
35%. 1 crore 21 lakhs 17,000. Heard admit call for TCRs, issue notice to the respondents. Interim stay of the execution of the impugned award subject to appellant depositing. Nim liability though 50%.
Our liability is 65%.
65. 50% of its liability under the award. Under the impugned award.
Even,
Before the tribunal.
question of quantum also, it has been.
Within 4 weeks, you deposit 50% of your liability. Within 4 weeks before the tribunal. I-1 of 24 is disposed of accordingly. List out.
List 11. Number 66, Hemanta B.
Challenging the order of the divorce, my lord. The appellant is a wife.
They had contested.
Contesting,
He had appeared.
Yes, my lord. The husband was filed a petition on the ground of dissolution, my lord. But there is no ground for dissolution, my lord. There is a dissolution for minimum.
And desertion, both were.
Yes.
Petitioner proves that there has been no restitution of conjugal rights for a period of 1 year. There was a decree for restitution earlier.
Yes, my lord. That
At
point was rejected.
That is rejected.
Rejected. That is impage number, my lord,
Seeking for
16
public
and
authority
impage number 29, my lord.
Took place on. Where is that rejected? ಇಲ್ಲಿ allowed ಅಂತ ಮಾಡ್ಬಿಟ್ಟಿದಾರಲ್ಲ.
Page number 29, madam, impage number 29. Point number 2 is declined. Point number 1 is allowed.
1 capital A.
Yes, my lord. That was the decline. And another one is 1B, my lord.
Such decree. There was no restitution of decree. Then why they have filed the?
I don't know. That's why, man.
Third admit call for this.
Stay, ma'am.
Admit call for TCRs. Any criminal cases were filed?
Yes,
CC
ma'am.
charge sheet is filed.
Yes, my lord, against the,
What happened in that charge sheet?
is pending, my lord. For-
Trial is going on.
Yes.
Let it call for TCS, to notice to the respondent, interim stay of the interim judgment and decree till further orders. I 1/2025 is disposed, I 1/2024 is disposed of account. List on
1411.
Watch.
List number 2 for admission. List number 6. Krishnamurthy ji Hasyagar.
List number 2 कितने होता है कि नंबर yes.
ಎರಡನೇ ಲಿಸ್ಟ್ ಅಲ್ಲಿ
Hmm.
very appellant is defendant in the suit. Very strange order has been passed by the trial court, ignoring the specific admissions made by plaintiff PW1 and ignoring the fact that there is no denial of the evidence given by DW1 defendant. It proceeds to decree the suit for 80 lakhs. In fact, what's happened is the suit was based on two documents. One is exhibit P1 and the other one is cause of action subsequent supplementary agreement. That is not produced and marked. The learned trial judge refers to that supplementary agreement also and gives findings, ignoring the specific admissions made by PW1. Let me take this honorable court through the admissions made by PW1, specific admissions. He says that he was evicted in the 2010 and they were very much aware of the fact that the lease deed cannot be executed. Suit is filed in 2016. Order 2, rule 2 no barata because they had filed a previous suit. OS 739 of 2012.
For what relief? But there is no issue regarding that.
Illa, ಮಾಡೇ ಇಲ್ಲ and in fact
Order to rule 2 is the additional issue number 2.
ಅದರಲ್ಲಿ he has ignored the specific admissions made by
So you agreed that initially you had entered into a lease agreement with them.
ಇಲ್ಲ ಲೀಸ್ ಅಗ್ರಿಮೆಂಟ್ ಆಗೇ ಇಲ್ಲ ಲೀಸ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ತೇನೆ ಅಂತ
But there as a tenant.
ಇಲ್ಲ ಟೆನೆಂಟು ಆಗಿದ್ದಿಲ್ಲ ವಾಟ್ ಹ್ಯಾಪಂಡ್ ವಾಸ್ ಲೀಸ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ತೇನೆ ಟಿಲ್ ದೆನ್ ಒಂದು ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಅಂಡರ್ಟೇಕಿಂಗ್ ಅಂತ ಹೇಳಿ ಮಾಡ್ಕೊಂಡ್ರು ಎಕ್ಸಿಬಿಟ್ P1 ಮತ್ತೊಂದು ಅಗ್ರಿಮೆಂಟ್ ಇದೆ ಅಂತಾರೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲಿಲ್ಲ ದ ಸೂಟ್ ಈಸ್ ಬೇಸ್ಡ್ ಆನ್ ದಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಆಲ್ಸೋ ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ ಟ್ರೈಲ್
You were just now you submitted that you were evicted.
ಅಲ್ಲ ಅವರು ಎವಿಕ್ಟ್ ಆಗಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ 2010 ದಲ್ಲೇನೆ
For the appellant, sorry, plaintiff himself.
ಹೌದು ಅದಕ್ಕೆ ಇಟ್ ಈಸ್ ಎ ಕಂಪನಿ ದ ಡಿಫೆಂಡೆಂಟ್ ಈಸ್ ದ ಓನರ್ ಆಫ್ ದ ಬಿಲ್ಡಿಂಗ್ ದೇ ಅಪ್ರೋಚ್ ದ ಡಿಫೆಂಡೆಂಟ್ ಅಂಡ್ ಸೆಡ್ ದಟ್ ವಿ ವುಡ್ ಟೇಕ್ ದ ಪ್ರಾಪರ್ಟಿ ಆನ್ ಲೀಸ್ ಲೀಸ್ ಡೀಡ್ ಆಗೋವರೆಗೆ ವಿ ವಿಲ್ ಎಂಟರ್ ಇನ್ ಟು ಅಗ್ರಿಮೆಂಟ್ ಅಂತ ಹೇಳಿ ನೀವು ನಮಗೆ ಬೇಕಾದಾಗ ಎಲ್ಲ ಆಲ್ಟರೇಷನ್ಸ್ ಎಲ್ಲ ಮಾಡಿ ಮೇಕ್ ಇಟ್ ಸಿ ದಟ್ ಇಟ್ ಈಸ್ ರೆಡಿ ಫಾರ್ ಅವರ್ details are given for the purpose of renovation, alteration, ಎಲ್ಲ electricity ಅದು ಹೋಟೆಲಿಗೆ ಬೇಕಾಗುವಾಗ ಎಲ್ಲ ಬದಲಾವಣೆ ಮಾಡೋದು and the plaintiff instead of paying the security deposit 1 crore ಕೊಡ್ತೇನೆ ಅಂತ ಹೇಳಿದವರು ಕೊಟ್ಟಿಲ್ಲ. He gave it in different installments and the last installment was 7 lakhs on 2010 ದಲ್ಲಿ ಕೊಟ್ಟಿದ್ದು ಅದಾದ್ಮೇಲೆ ಕೊಟ್ಟೇ ಇಲ್ಲ. Instead of paying the balance 20 lakhs also and instead of paying the amount spent by defendant for renovation etc 1 ಕೋಟಿ 10 ಲಕ್ಷ ಖರ್ಚು ಮಾಡಿದ್ದಾರೆ. ಆಮೇಲೆ they filed a false suit in 2012 739 of 2012 ಅಂತ ಹೇಳಿ ಆ suit ಅಲ್ಲಿ prayer was restraining the defendant from interfering with his possession ಅಂತ ಹೇಳಿ injunction ತಗೊಂಡು for 3 years I was kept out of possession. 3 ವರ್ಷಕ್ಕೆ I was kept out of possession. I was not in a position to give it to others also. That is admitted by PW1. 3 ವರ್ಷ you could not take possession of the property. During the pendency of that suit, without withdrawing that suit, they file this fresh suit, 83 of 2016. The suit itself is barred by limitation and 739 2012 ಹಾಕದಾಗ್ಲೇನೆ
For recovery of money.
recovery of money, ಆ security deposit ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿ without giving the amount due to me.
You also without examining the defendant, no other witness was examined to show that all these developments were done.
PW1's evidence, I have got it here.
Anyway, it is in the nature.
It
of
is,
money
it is not
taking.
denied.
If you want an interim order, you have to deposit certain amount in this.
Please, ನಾನು ರಿಕ್ವೆಸ್ಟ್ 50% ಅಥವಾ 40% ಬ್ಯಾಂಕ್ಯಾಲಿಟಿ ಕೊಡ್ತೇನೆ ಸ್ವಲ್ಪ ಕಷ್ಟದಲ್ಲಿದ್ದಾರೆ ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗುತ್ತೆ.
ಅಲ್ಲ ಕಷ್ಟದಲ್ಲಿ ಅಂದ್ರೆ ಮತ್ತೀಗ ಅವ್ರ the court has held that you are liable to pay this much amount. This is you only said 2012 litigation started. Bit call for TCRs. Appellant's counsel shall submit the paper books within 4 weeks. 40 lakhs difference.
ಪೇಪರ್ ಬುಕ್ಸಿಗೆ 6 weeks ಅಂತ ಹೇಳಿ ದಯವಿಟ್ಟು.
Within 6 weeks. Okay. Issue notice ಅಂತ ಹೇಳೋದು. Issue notice to the respondent, sole respondent ಅಲ್ವಾ? Interim stay of execution of the interim decree subject to appellant depositing, you are going to deposit, you have to
ಅಲ್ಲಿ
deposit.
ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿ ಕೊಡ್ತೇನೆ ಅಂತ. ಎರಡು ಒಂದೇ ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿ ಕೊಟ್ಟರು.
ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿ ಕೊಡೋದಕ್ಕೂ ಅಷ್ಟು ದುಡ್ಡು ಅವ್ರ ಹತ್ರ ಇಡಬೇಕಲ್ಲ. ಯಾವತ್ತರ ಒಂದ್ ದಿವಸ ತಕೊಂಡ್ರೆ ಅವ್ರ ಅದನ್ನ ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿ ರಿವೋಕ್ ಮಾಡ್ಬಿಡ್ತಾರೆ ಬ್ಯಾಂಕ್ನವ್ರು.
ಇಲ್ಲ ಹಾಗೆ ಮಾಡೋದು.
ಸಬ್ಜೆಕ್ಟ್ ಅದೆಲ್ಲ ಬೇಡ. ಬ್ಯಾಂಕ್ನವ್ರು ಯಾವ್ದಾವ್ದ್ರ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿಯವ್ರ ತರ ರೆಪಿಡಿಯೇಟ್ ಮಾಡ್ಬಿಡ್ತಾರೆ ಆಮೇಲೆ.
ಆಯ್ತು.
Subject to appellant depositing 50% of the decretal amount before this court, you deposit your.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮೈಸೂರದಲ್ಲೇ ಮಾಡಿ.
Before this court, ನಾವು ಜನರಲಿ MACT ಆದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಮಾಡ್ಲಿ ಅಂತ ಹೇಳ್ತಿರ್ತೀವಿ. ಇಲ್ಲಿ ಮಾಡ್ಲಿ ಅಂತ ಹೇಳೋದಕ್ಕೆ there is some reason. Before this court, within 4 weeks from the date of this order.
Your lordship has treated the matter.
Admitted.
Paper books in 6 weeks ಅಂತ ಹೇಳಿ.
6 weeks.
Much obliged.
4 weeks list on date. 4 weeks of deposit ಮಾಡಿರ್ತಾರೆ. 1911.
ಯಾವಾಗ ಮೇಡಮ್?
1911.
ಇನ್ನು 1911.
Seal number 7, TK Rajgopal.
No representation in notice TI. No representation for the appellant. Issue notice to the respondent. ಮತ್ತೆ ಒಂದ್ ದಿವಸ ಬರ್ತಾರೆ ಮೂವ್ ಮಾಡೋದಕ್ಕೆ. ಯಾರು TI ರಾಜಗೋಪಾಲ್ ಅಂದ್ರೆ? ಇಲ್ರಿ ಇಲ್ಲಿ ಯಾರು ಫ್ರೀಕ್ವೆಂಟ್ಲಿ ಅಪಿಯರ್ ಆಗೋರ ನೋಟಿಸ್ ಯಾಕೆ ಕೊಡ್ಬೇಕು? ಪ್ಲೇಂಟಿಫ್ಸ್ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ರಿಫಂಡ್ ಮಾಡಿದ್ದಾರೆ. ಡಿಸ್ಮಿಸ್ ಇಲ್ಲ, ರಿಫಂಡ್ ಆಫ್ ದ ಕನ್ಸಿಡರೇಷನ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ. TI ನಾಟ್ ಟು ಅಲಿನೇಟ್ ಅಂತ ಇರಬೇಕು. Soon after vacation happened. No representation for the appellant. List on
1410. Seal number 8, Ravi Kumar MC.
For the appellant, my lord. Lord, this petitioner's appeal, my lord. Petitioners had filed a petition seeking divorce. That petition has been dismissed by the Honorable Trial Court. But the crux is, my lord, main ground for rejection of petition is that since I refused to join the respondent, where earlier he had filed a restitution of conjugal rights, that was decreed. My counterclaim for divorce was dismissed. So since I failed to obey that, I am not entitled to seek divorce and helkondu. That observation was made.
maintenance, we can't pass any ex parte interim.
My lord.
Order admit call for TCRs. Issue notice to the respondent. List on
1211.
1211.
List number 1 for further hearing, seal number 67. Dr. M. Sunil Shastri.
4 weeks time ಕೊಟ್ಟಿದೀವಿ, ಅದಾದ್ಮೇಲೆ ಕೊಡಬಹುದು ನೀವು. We have a grievance, none of you listen to us. Only we have to listen to you. ಇದು ಇರುತ್ತಲ್ಲ, ಇದು ಯಾವ್ದೋ there is some procedure, ಫಾರಿನ್ ಎಂಬಸಿ ಮುಖಾಂತರ ಮಾಡ್ತಾರಲ್ಲ. Serial number, we passed order after hearing you or before that?
ಅವ್ರು ಇರ್ಲಿಲ್ಲ ಮೇಡಮ್.
ನೀವ್ ಇರ್ಲಿಲ್ಲ ಅಂತಲ್ಲ. ಈಗ ಅವ್ರು ಇಲ್ವಲ್ಲ, their absence we can't do anything. Yes.
Seal number 67.
Correct. You do not come before the court. What shall we do? 2019 matter. Now you remember all your urgency. Yes. Yes, Idrali, you wanted to.
I'm filing.
Why did you not submit it in the?
ಇಲ್ಲ ಕೋರ್ಟ್ ಸೆಟ್ ಇರೋದ್ರಿಂದ ನಾನು ಇಲ್ಲೇ ಕೊಡ್ತಾ ಇದ್ದೀನಿ ಅಷ್ಟೇ. Now written submissions is there and it's continuous page number. I'll just show it to my lords. Continuous page number is in green ink in both the sets. ಆ ಗ್ರೀನ್ ಇಂಕ್ ಅಲ್ಲಿ ಏನಿದೆ ಅದನ್ನ ನಾನು ರೆಫರ್ ಮಾಡಿದ್ದೀನಿ throughout the written submission. In my written submissions, we have referred to the green ink of every page. wherever we are. And there is absolutely no additional document, no additional judgment.
Copy ಕೊಟ್ಟಿದ್ದೀರಾ ತಾನೇ?
What is it?
They have given a copy. Now, my lords, this is for the first time, my lords, if my lords may only have, I will not take more than 4 minutes, my lords, 4 to 5 minutes. If my lords may kindly have page 1 of their written submission.
Page 1 of the.
Page 1 of their written submission. A para 1. Now, my lords, my entire case, my lords, was only one. That para A1 anta ide. My lords, my case before my lords was only one thing, that the application under 2158 is not maintainable because there is no attachment. Now, my lords, kindly see what their contention here is. The order of attachment dated 29/10/2021 clearly indicates that amounts are attached before the trial court, and at the time of filing of the application by the appellant before the trial court, the same amount remained attached to the trial court.
This
Now-
was the submission made.
Yes, my lords, but my lords, to this effect, there is not a single pleading either in the application that was filed under order 21 rule 58. My lords, I will not take more than 4 to 5 minutes.
Last time, who appeared?
Senior counsel Srinivas Raghavan, when he appeared, this was
That
argued.
even if it is realized, it is virtually attachment to the.
My lords, but my lords, kindly see, because the entire order sheet was not only Akandre, my lords.
He did not argue on this line at all.
No,
What
my
he
lords,
argued.
because
is-
today that is their main contention. There was no pleading at all to that effect, either in the application or in the appeal. Now, my lords,
Really, Burkondral, the position is that after attachment, it was realized and deposited.
completely realized, and my lords realized before.
Why are you so touchy about that? It was
Allah,
real.
not-
Last time, senior counsel submit, we posed the same question.
Yes,
He said, you,
I follow.
after realization of the amount, if it is in the custody of the court, it is attachment only. This was the argument.
custodial
but-
legis was
my lord,
argued, and in fact, whatever judgment that the senior counsel referred to, that's the only judgment I have produced in support of this. I have not added anything else.
My lords,
And
if
ಏನ್
my
ಇದೆಯೋ
lords may
ಅದನ್ನೇ produce
one
ಮಾಡಿದ್ದೀನಿ.
ನಿಮಿಷ, kindly see para 2, my lords, ಅಲ್ಲೇ continuation. I will not take more than 2 minutes more, my lords. In fact, an order of release is passed on the same day as the impugned order, which clearly indicates that the amount continued to remain attached before the trial court. Now, my lords, only 3 dates of the order sheet. Can you give the- My lords, this is the order sheet, my lords. I will not, madam.
ನೀವೇ ಓದ್ಬಿಡಿ.
ಇಲ್ಲ, ಇಲ್ಲ,
There in the
ಇಲ್ಲ,
record.
this is not there in the records, my lord. This is the order sheet of the executing.
ಹೊಸದು
court. ಇಲ್ಲ,
ಕೊಡ್ತಾರೆ
ಇಲ್ಲ,
ಅಂತೀರಾ?
This was not at all,
ಅವ್ರಿಗೆ-
when I have not referred to
For what
something.
purpose he is saying, because
My lord, this goes
facts
to the
cannot
root.
be changed by the
This
party.
goes to the
Correct,
root.
and
Now, learned counsel, it is only appreciation. Facts. Who argued, we posed this question to him. He said, even if it is realized and it is in the court's custody, it is virtually attachment only.
My lord,
That-
I will not, on page, I won't even read, my lords, may mark those
Try to
pages.
interpret it.
My lords, page 24, the order sheet, page 24 ಅಲ್ಲಿ. My lords, I'm sorry, my lords, at 4 o'clock, I should not be troubling my lords like this, but
We do not know how, how do you get engaged yourselves during the vacation? ದಿನಾಲು ಇಷ್ಟು ಮಾತಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಊಟ ಹೋಗೋದಿಲ್ಲ.
ಇಲ್ಲ, ವಾಜ್-
ಅಲ್ಲ, ನಾನು ಏನಾದ್ರು ಇಲ್ದೇ ಇರೋದು ಅಡಿಷನಲ್ ಹಾಕಿ ಇಲ್ಲ ರಿಪ್ಲೈ ಕೊಡಕ್ಕೆ.
ಒಬ್ರೇ patient.
ಆಯ್ತು ಅಲ್ಲ, ಐ ಆಮ್ ಜಸ್ಟ್ ಮೇಕಿಂಗ್.
My lords, 2910 ಅಲ್ಲಿ 21, if my lords has the operative portion at 26.
Page
This is
number.
the, it begins at page 24.
ಆಯ್ತು 26 ಅಲ್ಲಿ.
26 ಅಲ್ಲಿ, my lords, they said there should be an attachment. There was no attachment pursuant to this. Thereafter, my lords may have page,
Current
there was no attachment, my lords. It's a matter of record. Page 29, my lords may have
29.
29 on 12/11/21. My lords,
12/11/2021.
12/11/21 ನಲ್ಲಿ, my lords, operative portion at 31. On this day, my lords, there was an order. Accordingly, it is ordered to call for the fixed deposits amount to the date accrued with interest to the extent of the amended EP from the garnishee bank, State Bank of India. Thereafter, my lords, over the page at 32, my lords, 2 DDs for 50 crores was submitted, office note ಅಲ್ಲಿ, left-hand side.
ಇದನ್ನೆಲ್ಲ admitted area.
No, my lords, now kindly see at page 34, ashte last document, my lords. I won't say anything beyond this. Last document at 34. My lords, this is dated 30/11/21. Now, my lords, may kindly have the operative portion at 36.
My lords, 25% of this amount was released in my name in my fixed deposit. My lords, 75% was released absolutely. So my lords, 100%.
Decree holder.
100% was released in the favor of the decree holder with a condition that 25% will be kept in your name for a period of 1 year. Now, my lords, kindly note his application date. His application date was, my lords, 15/6/22.
25% of the attached amount is kept in FD.
In, my lords, in the name of the decree holder. In the name of the decree holder.
And 75% is
Completely released. So, my lords, as on this date, 100% was released. 100% was released. His application came to be filed on 15/6/2022.
What happened after this one?
After this, my lords,
2021.
yes, my lords, after,
What happened after 1 year investment?
my lords, after that, now that 20,
Have realized that FD?
my lords, that 25% which is in my name was also ordered to be released. We did this impugned order. There were 3 orders passed on 11/12. The 25% was also ordered to be released. But only one more interesting date which my lords has to see is at page 46. Page 46.
No, order to be released, but you have taken that.
Yeah, no, my lord, 75% I have taken.
ಅದು ಎಷ್ಟು ಸರಿ ಹೇಳ್ತೀರಿ?
25% is in my name in my FD.
Now you said it is ordered to be released ಅಂತ ಹೇಳಿದ್ರಿ. Whether you have taken that?
25% have I taken? Yes, my lords, 25% is also realized by me. 100% is realized by me.
Right, now what else?
Now, my lords, at page 46, late, a further sum, my lords, was voluntarily deposited on 24/11/23.
JDR number 2.
Voluntarily deposits. It's not an
Appellant is
attachment.
JDR number 2 or?
BMRCL means. BMRCL.
So voluntarily deposited ಅಂದ್ರೆ ಅದು garnish sir.
ಇಲ್ಲ, my lords, not pursuant to an attachment. In compliance of it, they come and voluntarily deposit 56 crores.
But this appellant has not deposited.
Appellant has not deposited. He is a third party. My lords, just to give one illustration, my lords, let us say this is BMRCL money. BMRCL's FD is attached. Let us say Asian Bank has some charge on that property and Asian Bank says you cannot release this money to this person in land acquisition proceeding. They may be able to maintain it as a third party objector there because they have a direct interest on that. Not, my lord, trying to open up a partition suit. That would be my limit.
My lord, in response to that, I'll just show that attachment ittu anta. How they documental since it's my appeal. I should just make one statement.
ನಿಮ್ಮ senior counsel ಅನ್ನು
ಅಲ್ಲ, ಇವಾಗ ಆರ್ಡರ್ ಶೀಟ್ ತೋರಿಸ್ಬಿಟ್ಟು ತಮ್ಗೆ ಹೇಳಿರೋದಕ್ಕೆ ವಾಟ್ ಎವರ್
ತೋರಿಸಿದ್ರು ತೋರ್ಸೋದು
ಅದೇ ಕಂಪೈಲೇಷನ್ ಅಲ್ಲಿ if I may just point out.
Both of you have to pay double court fee. ಒಂದು ನಿಮ್ senior argument ಮಾಡೋದಕ್ಕೆ ಇನ್ನೊಂದು ನೀವು argument ಮಾಡೋದಕ್ಕೆ.
Argument ಏನು ಇಲ್ಲ. Since he has pointed out it's my appeal, I just have to show. ಅದರಲ್ಲಿ page number 2 of my written submission.
Last time also ಏನಾದ್ರೂ ಹೊಸದ್ ತೋರಿಸ್ತಾರ ಅಂತ ನೋಡಿದ್ವಿ ನಾವು. ಅದ್ರಲ್ಲಿ ಏನು ಇಲ್ಲ.
ಅಲ್ಲ, ಹೊಸದ ನಾನು ಏನು ಹೇಳಿಲ್ದೆ ಅದು he has pointed out.
Admittedly, as admitted by both sides, certain amount was attached and that is deposited before the court.
That attachment
Now he
is,
says some of it is released.
Allah, that attachment is still there ಅನ್ನೋದಕ್ಕೆ as on the date when my
Yes.
application was rejected
By the moment it is deposited in the court, that attachment order
goes on.
goes.
It is realized
Gets
and it is
evaporated.
concluded on.
Therefore, 2158 application
not apply.
will be maintained because
That is the argument.
2158 is only for attachment. of the-
Please, that is the
So
argument.
object the attachment. That is.
Please.
But last time it was argued on your behalf that even if the money is deposited, court is the custodial agent, therefore it amounts to attachment only.
Please.
Now we have to see what is the law on this point. Yes.
My lord, in fact, only one order 21 rule
for
55 may
certain-
be noted, my lord, that's time.
You have sufficiently argued.
ಅದಕ್ಕೆ ನಮ್ದು argument ಏನು ಇಲ್ಲ. This is something which was already argued that is simply brought to the notice.
ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ ತಿರ್ಗಿ ಅದೇನು.
Order sheet, my lord, that's time.
Will not receive anything further. We keep telling, ಈ ತರ ಜಡ್ಜಸ್ ಟ್ರಬಲ್ ಮಾಡೋರೆಲ್ಲ ಒಂದ್ ದಿವಸ ಜಡ್ಜಸ್ ಆಗ್ಲಿ ಅಂತ ನಾವು ಕರ್ಸ್ ಅಂಡ್ ಬ್ಲೆಸ್ಸಿಂಗ್ಸ್ ಎರಡೂ ಕೊಡ್ತೀವಿ. ಆಯ್ತಲ್ಲ, ಲರ್ನ್ ಕೌನ್ಸಿಲ್ ಅವ್ರು ಇನ್ನೊಂದು ಕೌಂಟರ್ ಹಾಕ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. See, the question is only this much now.
Yes.
Whether it amounts to attachment.
Yes, that's time.
ಅಷ್ಟೇನೆ.
That's all.
Whether they can maintain a.
Grateful, my lord.
ಅದಕ್ಕೊಂದು ಹಾಕ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಇಲ್ಲ, ಏನು ತಗೊಳ್ಳೋದಿಲ್ಲ, ಏನು ಹಾಕೋದಿಲ್ಲ. It may be reserved, my lord, because extensive hearing is.
Here for the appellant ಅಲ್ವಾ?
Please.
ಎಷ್ಟಿದೆ? 294. Counsel for the appellant submits ಏನದು ಪೇಪರ್ ಬುಕ್ಸ್
Convenience compilation.
written submissions, dates and events,
And list of documents and authority.
list of documents and authorities,
Please.
copies of the documents and authorities. Okay, third further reserved for judgment.
Grateful.
And
My apologies,
Used
my
to
lord.
work during Dasara vacation.
Like
No.
I was only.
we are grateful that such a long drawn litigation will admit ಆಗಿ ಬಿಟ್ಬಿಟ್ಟಿದ್ವಿ ಈ ಕೇಸ್ ಇಲ್ಲಿ
ಆಯ್ತು.
24th would have been difficult.
Grateful.
And one reminder, he had undertaken that.
Dasara vacation.
If I may just one reminder, he had undertaken that till orders have passed, he will not move the execution ಅಂತ. Just 1910 ಇದೆ execution court ಅಲ್ಲಿ ಅದಕ್ಕೋಸ್ಕರ.
Undertaking record ಆಗಿದೆ ಅದು.
My lord, it's not on a recording, it's on, my lords, I, till 1910, my lords, we'll come back on 1910, my lords.
ಅಲ್ಲ 1910.
Till 1910, I will not move, my lords. My lords, it may not be recording, my word may be taken, my lord.
Till judgment is pronounced ಅಲ್ಲಿ ತನ ಮಾಡ್ಕೊಂಬಿಡಿ ಅಷ್ಟೇ.
ಅದೇ
My lords, it may,
Judgment-
my lords, my,
Because
because.
ಅಲ್ಲ
it-
judgment
I-
orders.
I'll only tell the reason why. my
Let
lord.
there be some
No,
protection.
no, I've given my word, you can take my
we
word.
record that, whatever you have said, we
My lords, it may not be on my undertaking, my lord.
Respondent, which respondent?
Respondent number 1.
Respondent number 1 submits that till further orders, respondent number 1 does not precipitate the matter in execution petition.
Please.
Okay, list, list allala, reserved for judgment.
Obliged.
We'll try to do it as early as possible.
Well, my lord, because I'm having a
Wait,
daily
wait.
loss of interest, my lord.
Preliminaries, number 69, Sanjeev PL, Nayak Krishna Venkatraman.
My lord, I am appearing for petitioner, my lord. My senior ಹುಷಾರಿಲ್ಲ ಕಾರಣ ಬಂದಿಲ್ಲ, my lord. I humble request, my lord, please for time, my lord. Time, my lord.
Let's send it the request, ಆಯ್ತಲ್ಲ time. Yes, next. ಅಷ್ಟೇ.